Hello and welcome to another session for capital market and securities laws. If you belong to the new syllabus of the executive program, and if you belong to the old syllabus, it is the securities laws and capital market. So today's session is going to be useful for both new as well as old syllabus students, because I've selected a common chapter that is applicable to both the syllabus, and the content of both these chapters is also absolutely the same. So we can benefit both old and new syllabus students. So what is the topic for discussion for today's session? We are going to concentrate on a detailed analysis of one chapter, that is the Securities and Exchange Board of India Act of 1992. So in short, we call it as the SEBI Act of 1992. This is the topic for discussion in today's session. So which is the chapter that we are going to focus on? If you are a new syllabus student focusing on capital market and securities laws, you have to refer to chapter number 4 from your ICSI material. And if you belong to the old syllabus, you are studying securities laws and capital market, for you have to refer to chapter number 2 from your ICSI material. In addition to that, you also should refer to chapter number 14 from the material. Now, why is that? That is because when the institute was revising the syllabus and the new syllabus came out, they have clubbed chapter number 2 and 14 and included it under one chapter itself, that is chapter number 4. So what are we going to cover in this entire chapter? We are going to see the provisions of the SEBI Act of 1992. In addition to this, we are also going to study the scores mechanism. We are also going to study the informal guidance scheme. All these three topics are covered under chapter number 4 for the new syllabus students. But if you talk about the old syllabus, chapter number 2 is the SEBI Act exclusively, and chapter number 14 talks about dispute resolution mechanisms, under which you have the scores mechanism and informal guidance scheme and the ombudsman. Right? So we are going to study the scores mechanism, informal guidance, and the SEBI Act of 1992. So with this basic, open your materials from the ICSI material and let's begin the discussion. Right. So we are, as all of you already know, we are going to have a discussion on SEBI Act of 1992. SEBI Act of 1992 is an enactment. It is an act. It is a statute. What does it mean? It means that it is a law that is being passed by the parliament of our country. Now, whenever you are going to write the name of any act, any statute, any enactment, there are certain things that you should keep in mind. If you're a law student, you will already know, but if you're not a law graduate or you're not studying LLB, then for you all, this is some vital information. Please make sure that whenever you're going to write the name of any act, statute or enactment, the first letter of every word should be written in the capital letters. So see, we are seeing the SEBI Act of 1992. SEBI, that is Securities and Exchange Board of India. So under securities, S should be capital, E should be capital, B should be capital, I should be capital, A should be capital. Put a comma and then write the year in which that particular law was brought into existence. So what is the thing that you should keep in mind? Whenever you're writing the name of any act, statute or enactment, the first alphabet of the word should always be written in the capital letter. Whether it is the Companies Act, whether it is the Reserve Bank of India Act, whether it is your Competition Act 2002, whether it is our own ICSI Act. So whatever name of enactment you write, you write the first alphabet in the capital letters. So this is one point that you should keep in mind. So seeing this chapter, what are the things we are going to cover? We are going to cover the entire SEBI Act of 1992. We are going to study the SEBI Informal Guidance Scheme of 2003. In addition to that, we are also going to see the scores mechanism, but it is not included under the regulatory framework because SEBI Act is an enactment. It is an act that has been passed. Informal guidance is a scheme that is issued under the authority of SEBI, but scores mechanism has not been established by any act, guidelines or scheme, but it is merely passed by the way of a circular issued by the Securities and Exchange Board of India. That is why separately it has not been mentioned in the regulatory framework, but we are going to cover all these three things. One act we are going to cover, that is the SEBI Act of 1992, one guidance scheme we are going to cover, and one circular we are going to cover which talks about establishment of the scores mechanism. So these are the three things that we have to cover in this entire chapter. Let's begin our discussion first by talking about the provision of the Securities and Exchange Board of India Act of 1992. We have already seen the discussion on lesson number 1, which talks about the basics of the entire financial market, classification of financial market into capital market, money market, and then further classification of securities market into primary market, secondary market. All this discussion we have already done. So you already know a little bit about what is Securities and Exchange Board of India, what are the powers that are vested with SEBI, what are the functions of SEBI, and why we established Securities and Exchange Board of India itself. Right, after the Harshad Mehta scam, they realized the importance of giving statutory recognition to an authority. Right, we have already covered this in lesson number 1. If you have not seen the video, you can go back and see that video for reference of how and why there was a need for us to establish the Securities and Exchange Board of India. Now, it is established on 12th April 1992. It has been established by passing a law, and that law itself is the SEBI Act of 1992. This act, the passing of SEBI Act of 1992, has given the recognition to SEBI as a statutory regulatory body of the Government of India, which is first statutory regulatory authority set up by the government after the reforms of 1991. Now, this is basics. It is established on 12th April 1992. It has been established by passing a separate law for itself, that is the SEBI Act of 1992. And this is the first statutory regulatory authority which has been established by the Government of India after the reforms of 1991. Now, what is the thing that we should keep in mind here? We should give importance to two words. First is statutory. Next is regulatory authority. So we call Securities and Exchange Board of India as a statutory regulatory authority. What do we mean? What is a regulatory authority? Regulatory authority is any authority which is going to oversee the functioning of any particular market, which is going to see and monitor the activities of a particular market, which is going to regulate in simple terms. Which market? It is going to concentrate on the securities market functioning, regulation, overseeing, being the watchdog. That is why we call SEBI as a regulatory authority. It is the regulatory authority for the securities market. Right? Now, why do we call SEBI also as a statutory regulatory authority? A statutory authority means any board, any authority that has been established by passing a separate enactment. To incorporate or to establish SEBI, we have passed the SEBI Act of 1992. Under the SEBI Act of 1992, we have a section, under section 3, we have said that the Government of India has the power to establish a board to be called as the Securities and Exchange Board of India. So, the mere existence of the Securities and Exchange Board of India has been provided for in this enactment, which is a separate law in itself. It is passed or established by an enactment. It is passed or established by a statute, and that is why we call it as a statutory authority. It has been established by passing a statute, and that is why it is called as a statutory authority. So what is SEBI? SEBI is a statutory regulatory authority. Statutory because it is passed or established by passing of the SEBI Act of 1992. Regulatory means it has been established for the purpose of regulating the securities market, and authority means it is going to have a lot of powers, functions and responsibilities in relation to the securities market. Okay, that is why we call SEBI as the statutory regulatory authority. Now, let's look into the basics. Securities Exchange Board of India can. What are the basic things? Why did we provide for the establishment of the board itself? It can specify the matters to be disclosed and the standards of disclosure required in respect of protection of investors, in respect of any kind of issue, whether that is initial public offer, whether that is further public offer, whether that is rights issue, whether it is bonus issue, whether it is private placement. Whenever anybody is going to collect the money from the public investors at large, what are the disclosure requirements from the company side? Whoever is going to take the money from the public at large, they should give certain disclosures. What are the standards of disclosures? What are the matters to be disclosed? All that is going to be specified by the Securities and Exchange Board of India through various regulations that they can pass, and that itself is the basis of our subject, where we are going to study the SEBI LODR regulations, listing obligation and disclosure requirement regulations. So SEBI has the power under SEBI Act of 1992 to specify the disclosures to be made by any company which is going to collect the money from the public at large. And using this power, SEBI has passed the SEBI LODR regulations, SEBI ICDR regulations, issue of capital and disclosure requirements, listing obligation and disclosure requirements. So that is the power of SEBI. They can specify what is the disclosure that is going to be required to be made by any entity that is going to call for money from the public at large. Next, SEBI also has the power to issue directions to all the intermediaries who are going to be involved in the securities market in the interest of the investors and for the development of the securities market. Right? So it is the regulatory authority. It is going to monitor the entire securities market. In the securities market, we saw there are various components. There is a issuer, that is the company or the government. There are investors who are going to put in their money, as well as there are intermediaries who are going to connect these issuers with the investors, right? So they say that the Securities and Exchange Board of India has the power to issue directions to the intermediaries and any other person who is going to be associated in the securities market for keeping in mind the interest of the investors. The investor should be protected, their interest should be safeguarded. So keeping their interest in mind, any kind of direction can be passed by SEBI to any intermediary or to any person associated in the securities market. Also, when they are issuing directions, they should focus in mind the development of the securities market. And lastly, they can also conduct inquiries, audit and inspection of all concerned. So they don't only have the powers of regulating, overseeing, monitoring the activities, issuing directions, asking for information, but they also have the power of conducting certain kind of inquiries. They can get complaints from the authorities and look into that particular matter. If there is any violation of SEBI provisions, SEBI laws, SEBI regulations, SEBI can involve and conduct the basic inspection audit as may be required to get into the roots of whether actually there is a violation of any provision or not, and they can adjudicate upon offences under the Act. What is adjudication? Adjudication is listening to the matter, hearing both the parties and giving a decision of who is right, who is wrong, whether there is a violation, whether the interest of investors has been not taken into consideration, whether there is any violation of SEBI provisions or not. So that kind of decisions can be passed by the Securities and Exchange Board of India. So what are the 4 reasons or what are the things SEBI has the power to do. They can give the disclosure requirements and the standards of disclosure. They have the power to conduct inquiry, audit and inspection. They have the power to conduct audits, and they also have the power to adjudicate the matters. Apart from this, they also have the power to give directions to anybody associated with the securities market, keeping in mind the interest of the investors. Going ahead, it is established in the year 1992. From the time of its establishment till today, SEBI has taken a lot of initiatives mainly for protecting the interest of the investors. That whenever we saw the previous chapter, we saw it has three main objectives. It wants to protect the interest of investors, it wants to regulate the development of the securities market, and it has to focus on the development of the securities market. These are the three primary objectives of the Securities and Exchange Board of India as per the preamble of the SEBI Act of 1992. We are going to cover here, but we have already covered this under lesson number 1. So, when you know that the main purpose of SEBI's establishment is to protect the interest of investors, over the year from 1992 to 2024, what are the activities or steps that SEBI has done to protect the interest of investors? So, SEBI under the SEBI Act of 1992 has been empowered. Okay. So, you know that SEBI is a statutory regulatory authority. Its work is to regulate the securities market. But when it wants to regulate the securities market, some kind of powers are required to be vested on the authority so that it can fulfill its duties properly. We allow a particular authority to regulate the market. But if you do not give them enough powers, that authority itself will be of no use. You have created a designation, but that designation has no power. They cannot do anything. Then what is the use of establishing that authority, right? So, when you have established the authority for regulating the market, they should be given enough powers to actually implement the objective with which they have been established. So, for that reason, the SEBI Act has been, under the SEBI Act, SEBI has been given some kind of powers. What is it? To frame subordinate legislation. You know that in our country, the structure of government is established in a way that we have three organs of the state. One is the legislature, one is the executive, and another one is the judiciary. Legislature makes the laws, executive implement the law, and judiciary interprets the law. These are the three basic organs. So, the legislative making power, the power to make laws in the country is vested with the parliament, with the state legislature. They are the people who are empowered by the Indian constitution to make the provisions of law, to pass enactment, to pass the law for the country. But people who are sitting in the parliament will not know the root causes of the problems that are being faced in any particular area. So, that is where they have the power to delegate the power of making laws. We call it as quasi-legislative powers. What are they? Quasi-legislative powers. What is quasi-legislative? Legislative making powers is the power to make laws in the parliament and the state legislature. But they cannot take care of all the things. They have to delegate their powers to somebody else. So, SEBI has quasi-legislative powers, that they have the powers like that of the legislature to make certain provisions of law. So, SEBI itself cannot pass any enactment. SEBI itself cannot pass any statute. SEBI itself cannot pass any act by itself. What can it do? It can make regulations. It can pass circulars. It can issue directions. It can pass guidelines. It can give directions. So, it can create law by giving different names, rules, regulations, etc. So, by using this quasi-legislative power, SEBI has the power to pass various regulations, and that itself is called as the power to subordinate legislation. So, by the virtue of this power, SEBI has passed the SEBI ICDR regulations, LODR regulations, PIT regulations. You have various others, collective investment scheme you have, right? So, where mutual fund regulations, n number of regulations have been passed by SEBI using this first power. So, SEBI has been given the power to do subordinate legislation, that is quasi legislative power, keeping in mind your department, keeping in mind the securities market, what is the law that is required to be created to regulate the market, to protect the interest of investors as well as development of the market. Keeping all these three objectives in mind, what is the law that is going to be required? That law can be framed by SEBI in the form of regulations. Second, they have the power to investigate the wrongdoing, impose relevant penalties, and they can conduct search and seizure operations. So, at any point in time, if SEBI gets any intimation through any person, or it itself is a watchdog and it is monitoring some kind of activities, and it identifies that something is wrong, some transaction is in violation of the provisions of the SEBI laws, then it can impose penalties for those wrongdoings after conducting necessary investigation, inquiries, and coming at the outcome. If they find that there is actually violation of SEBI provisions, they also have the power among themselves to impose penalties. Apart from that, they can also conduct search and seizure operations. At any point in time, if they think that there is some relevant information stored in a particular place and that information is relevant for conducting the investigation by the SEBI investigating officer, they can direct a search. Please go to their office, search the premises and get those registers, get those documents, get those information that is relevant for the investigation. So, these are the powers that have been vested with the Securities and Exchange Board of India, that is power to make laws, power to conduct search and seizure operations, and power to identify the wrongful activities and thereafter do the investigation and impose penalties for the wrongdoings in relation to the securities market. So, these are the powers that have been vested on the authorities, that is SEBI by the virtue of the SEBI Act of 1992, only because they should be able to implement the objective with which it has been established. It has been given necessary autonomy and authority to regulate and develop an orderly securities market. Autonomy means it is an autonomous institution without the interference of the government authority, without the interference of the government itself, it is going to function. It is an independent authority. It is an autonomous institution where entire power is vested that with that body, it can decide and do whatever it thinks relevant for protecting the interest of investors, for regulating the market as well as developing the market. So, these are the powers that are primarily vested with SEBI for fulfilling the objectives for which it has been established under the SEBI Act. Let us see the establishment of Securities and Exchange Board of India. Section 1 is the basic section where we give the title of the enactment. It says that this act is going to be called as the Securities and Exchange Board of India Act of 1992. Then they talk about the applicability of the act, that the act is applicable to the whole of India. And next is the notification, that is from when is it going to be applicable. It is going to come into force on 30th day of January 1992, right. So, this is the details of the enactment. Every enactment, section 1 is going to be preliminary, where they are going to give you the title of the enactment, they are going to give the applicability of the enactment, and they are going to tell from when it is going to come into force. So, this act is going to be called as SEBI Act. It is going to extend to the entire country, that is whole of India, and it is going to come into force from 30th January 1992. Now, if you remember the previous slide, we say that SEBI was established on April 12th, 1992. Here they are saying that the act is going to come in force on 30th January 1992. What does that mean? That simply means the law, that is the SEBI Act, will become applicable in the entire country with effect from 30th January 1992. In this act, they have said that you should create one authority. That authority is going to be called as SEBI. This particular authority is going to have a certain composition. What should be the structure? Who should be the members on the board of SEBI, etc. So, they have given in the law of establishing the authority. So, they brought the law with effect from 30th January 1992. It took them time to create this authority and create the composition that may be required, and that is why from 12th April actually the first composition was done and SEBI as a statutory regulatory authority was established. Now, let's get to the objectives of SEBI. We have already covered this under lesson number 1. Let's quickly have a revision. I told you under the preamble of the SEBI Act, we have the objectives. It has been established mainly for 3 objectives. First one is for protecting the interest of investors, because ultimately it is the investors' money that is going to be invested in the securities market. Public money is going to be raised. That protection we should give them, that if you invest your money in the market, we will ensure that no scam, fraudulent activities take place, that you don't lose out on your money by wrongful activities. You might lose your money because of fluctuating share prices, but you are not going to lose out on money because of any fraud or wrongful or scamful activities. Second one, they should focus on not only protecting the interest of investors, but as the time progresses, as technology progresses, we should also focus on development of the securities market. Earlier, we had physical stock exchanges. Now we have everything over the platform. It is everything digital, everything is online, right? That progression has taken place. We have developed the market. So with times to come, there are going to be changes, there are going to be technological changes. We have to focus on developing our securities market and maintaining that standards and meeting the global international levels. And lastly, third one is regulating the securities market. Yes, you should focus on protecting the interest of investors. Yes, you should develop the securities market. But while focusing on these activities, you should also focus on regulating the securities market. Only when there is regulation in the market, then only there can be protection for the investors. So these are the 3 primary objectives with which Securities and Exchange Board of India has been established through the SEBI Act of 1992. Now, if you see the structure of the SEBI Act, there are a lot of chapters and a lot of sections that are there, but as such, you do not have to study each and every chapter and each and every section of the enactment. We are only going to cover relevant provisions. So overall, I have just given the entire SEBI Act is divided into 10 chapters and along with the headings I have given. But what is relevant for us? What is relevant for us is establishment of the Securities and Exchange Board of India. What are the powers and functions that are vested with SEBI? Certificate of registration that may be required. Penalty provisions. These are the things that we are going to focus on in this particular chapter. First, let's get into the establishment of the Securities and Exchange Board of India. Till now, we have only seen what is the establishment, as in when it was brought into force. It has been brought into force as a statutory regulatory authority, and that it has been established for 3 purposes. One is protecting the interest of investors, developing the securities market, and regulating the market. This is the overall objective of passing the SEBI Act, and these are the primary goals of the Securities and Exchange Board of India. Now, let's see for the establishment. How should we constitute this board? Who should be there in that board? Who are going to be responsible people? How is SEBI going to manage itself? Because again, it is a corporation. It is a body. It is an autonomous institution. So, there should be somebody who is going to monitor or run the Securities and Exchange Board of India. So, what is that composition we are going to study? So, under section 3 of the SEBI Act of 1992, we talk about establishment and incorporation of the board. When I say board, we are talking about the Securities and Exchange Board of India, right? So, let's see. Section 3 says that there shall be a board by the name Securities and Exchange Board of India, which is going to be established as a body corporate. What is a body corporate? Any organization in corporate form of organization, right? Body corporate. If you have studied provisions of company law, you will know what is a body corporate. That is different from its members. Next, it is going to have perpetual succession. What is perpetual succession? People might come, people might go, but that organization is going to stay as it is. It is going to go on forever, right? So, you have created SEBI. There is a chairperson. One chairperson will come. After his tenure, he is going to go. Some other chairperson is going to come. He is going to go. After that, some other chairperson is going to come. So people within the organization might change, but the organization has been established forever, perpetual, forever. Perpetual means forever. Succession means people might come, people might go, but the organization is going to function as it is. That is perpetual succession. It has the power to acquire, hold and dispose of property, both movable and immovable, because it is a separate entity as such. Its members do not create it. There is a difference between people who are holding the designation and the organization itself. So in its own name, in the name of Securities and Exchange Board of India, they can acquire property, they can continue to hold property, they can dispose of the property, and they can both hold immovable property as well as movable property. They can enter into contract. Now, if I am going to enter into a contract, it is going to be in my name, with the person with whom I am going to enter into contract. A and B enter into a contract. But when SEBI is going to enter into contract, SEBI is an artificial person created by law. It is a body corporate. It is a artificial person. Somebody else is running it. You have the chairperson, you have the board members who are going to run the Securities and Exchange Board of India. But we are not going to enter the agreement in the name of the members or the chairperson, but we are going to enter the contract in the name of the artificial person itself, that is SEBI. So even though SEBI is an artificial person which is established by law, it is going to have the power to enter into contract in its own name. SEBI can enter into contract. It is going to be done on behalf of SEBI by the chairperson, but in the name of the organization we are going to do so. Next, it has the capacity to sue and be sued. If anything wrong is there, they can file a case against anybody. If anybody else has a problem with SEBI, they can file a case against SEBI. Next, the head office of the board shall be situated in Mumbai and having multiple offices at such other locations as may be required. So this is the establishment of the board, that is the Securities and Exchange Board of India, where it is a body corporate, that is artificial entity created by law, which is having a perpetual succession, that is it is going to have or be established forever. People might come, people might go, but that organization is going to remain as it is. It is having the power to acquire the property, both movable and immovable. It can dispose of the property as and when required. It can enter into contract in its own name. It can sue and it can also be sued in its own name, and its head office is going to be situated in Mumbai. So this is the establishment of the Securities and Exchange Board of India. Next, coming to management. So we have created this body. We know that one authority is there. It is a statutory regulatory authority. Its function is to protect the interest of investors, to look at the regulation of the market, to look at the development of the market. We know that it is a body corporate having perpetual succession, power to hold property, acquire property, dispose of property, enter into contracts, and number of things. But it is an artificial person. To run an artificial person, ultimately you need human beings. So we are going to give management to Securities and Exchange Board of India, people who are going to be responsible for running the Securities and Exchange Board of India. That is called as the management. Section 4 of the SEBI Act talks about the management of SEBI, where they say that SEBI is going to consist of the following members who are going to be appointed by the central government. So SEBI is an artificial person. To run the artificial person, ultimately you need human beings, right? Those human beings are itself the members of SEBI who are going to do all the signing on behalf of the authority. Okay, so let's look at the composition. They say that SEBI is going to have one chairperson. It is going to have 2 members who are going to be from the Ministry of Finance and Administration under Companies Act. There is going to be one more member who is going to be an official of the Reserve Bank of India. You are going to have 5 other members, out of which 3 of the members should always be whole-time members and 2 other members can be part-time members, and all of them are required to be appointed by the central government. So in total, you are required to have 5, 6, 7, 8, 9 members in the management of SEBI. One chairperson, 1 member from the Reserve Bank of India, 2 members from the Ministry of Finance and Administration of Companies Act, and lastly you have 5 members, out of which 3 should be whole-time members, 2 can be part-time members, and they are going to be appointed by the central government. So these 9 members together constitute the Securities and Exchange Board of India. They are the people who are going to make the decision on behalf of the authority, right? This is the management of SEBI. Now, coming to the management basic, we have seen the composition that there are on the board, there are 9 members. Now, let us see what other powers are given to SEBI for managing the affairs of the organization of the body itself. So, they have general superintendence and direction and management of the affairs of the board. It shall vest with a board of members. So, SEBI is a board. We have board members, we saw the 9 members, they are the people who are going to be responsible for the overall functioning of the Securities and Exchange Board of India. They will be responsible for giving directions as may be required. They are the people who are going to be responsible for managing the entire affairs of SEBI as per the provisions of SEBI Act of 1992. They will have all the powers and they can do anything that may be vested by the board. The chairperson shall also have the powers of general superintendence and direction of the affairs of the board, and may also exercise all powers and do all the acts and the things which may be exercised or be done by the board. Because board itself is an artificial person, it cannot do anything. On behalf of the board, the powers are going to be vested on the board members. Apart from board members, chairperson is going to have an exclusive role. So, even the chairperson will have all the powers that are going to be vested on the Securities and Exchange Board of India, because they are going to function on behalf of the board. The chairperson and all other 8 members are required to have certain type of capabilities, abilities, because we have entrusted on SEBI a very big responsibility, that is managing and regulating the securities market. They should see the investors' objective, they should see the protection of investors, interest of public at large should be taken into consideration. They have a huge responsibility to play in the entire financial market. So, when SEBI has such huge responsibility cast upon it, the members who constitute the board, they should be people who are going to have certain level of expertise, certain level of abilities and capabilities. Only then we can ensure that okay, SEBI is in safe hands. Depending upon the capability of person who is running SEBI, then only we can see whether the authority is functioning properly or not. That is why we have certain restrictions, we have certain kind of checklist that should be completed or fulfilled before you are going to be appointed as a board member for the Securities and Exchange Board of India. So, whether you are a chairperson or any other member, certain requirements are there. What is it? That person should be having ability. They should have basic ability to do their work. They should have integrity. They should be person of standing, means if they have made that statement, they should be able to stand by it, they should be able to abide by it. Capacity in dealing with problems relating to securities market. If at instantly some problem arises, do they have the capability of solving that problem? Do they have that critical mindset to solve critical problems? How are they going to handle critical situations? How are they going to tackle problems that might come before them? Solution seeing ability, do they have that ability or not? They are going to check. Having special knowledge or experience in the field of law, finance, economics, accountancy, administration, or any other discipline which is required for the functioning of the board. So, you have 8 other members. So, they will be from different departments, so that you have input from each and every side, each and every sector, each and every person is going to give their suggestion and opinion, so that ultimately the rules, regulations that are going to be framed by SEBI, directions or guidelines that are going to be framed by SEBI, that is going to be for in the interest of the entire securities market. So, these are the basic things that should be checklisted before being appointed as a board member to the Securities and Exchange Board of India. So, what is it? The chairperson and all the other members should be people who are having the ability and capability of doing their job perfectly, fulfilling the responsibilities that are cast upon them. They should be person of integrity, that means basic ethical things. They should have values, principles should be there. They should not be people who are going to deceive or are going to do any kind of wrongful activities within the organization. They should be people of standing, that they should have some kind of value, they should have some kind of authority, they should have some kind of responsibility, capacity of dealing with problems, and they should have special knowledge in area of any one of the following. Either they are expert in law, either they are expert in economics, either they are expert in accountancy, or they are expert in one of these areas, or any area that may be required or be relevant for the functioning of the Securities and Exchange Board of India. So these are the things that we are going to checklist. If they fulfill all the criteria, only then they will be permitted to be appointed to the members of the board of the Securities and Exchange Board of India. So this is about the management of SEBI. So quick revision let's do before going into the powers of SEBI. We saw about the establishment of the board under section 3, which says that it is going to be called as SEBI, that is the Securities and Exchange Board of India, which is going to be a body corporate, which is going to have perpetual succession, which is going to have the power to enter into contract, which has the power to sue and be sued. It has the head office in Mumbai. These are the basic things that you should keep in mind. Then it is under section 4, we saw the management, which says that it is going to be monitored by the board members, which is going to be having 9 members in total, 1 chairperson, 1 member from RBI, 2 members from finance and company law provisions, administration of company law. We have 5 other members, out of which 3 should be whole-time members, 2 can be part-time members who are going to be appointed by the central government. Then we saw for the management of the SEBI, the certain general superintendents of the affairs of the SEBI is going to be vested on the board members, which is also going to be vested mainly on the chairperson of the Securities and Exchange Board of India. So this is what we have covered as of now. Let's get into what are the powers and functions of the Securities and Exchange Board of India. Now we have divided it into various subtopics depending upon the provisions. Section 11 talks predominantly about the functions of SEBI, and all other section talks about the powers, right? So we are talking about powers and functions. For function you have only one section, that is section number 11. All other sections, section 11A, section 11AA, 11B, 11C and 11D, all of these talk about some or other power of the Securities and Exchange Board of India. SEBI has the power to regulate and prohibit the issue of prospectus. SEBI has the power to regulate the collective investment schemes. They have the power to issue directions and levy penalty. They have the power to conduct investigations. They have the power to pass, desist and cease and desist order. So these are the powers that we are going to focus on. Each one of these topics we will discuss in detail. First, let's look into the functions of SEBI which are provided under section 11. So section 11 is absolutely similar to the preamble of the SEBI Act of 1992. What is the preamble of SEBI Act? Preamble of SEBI Act says that we are passing the SEBI Act of 1992 for establishing Securities and Exchange Board of India for 3 purposes. What are those 3 purposes? Protecting the interest of investors, regulating the securities market and developing the securities market. These 3 itself are also the functions of the Securities and Exchange Board of India, where they say that it is the primary duty of the Securities and Exchange Board of India under the SEBI Act. We have created this authority for 3 reasons. Those 3 reasons are itself the duties of the authority. That is, first, you should protect the interest of investors in the securities market. You should promote the development of the securities market, and you should regulate the securities market. To do any one of these 3 things, whatever measures are required to be taken, those measures can be taken by the Securities and Exchange Board of India. So what is the duty or function of SEBI? Function of SEBI is to take any measure, pass any directions for keeping in mind 3 things: protecting the interest of investors, regulating the securities market and developing the securities market. So these are the 3 functions of SEBI. These are itself the 3 objectives of SEBI. So objectives, functions and goals of SEBI are similar. Preamble also tells the same thing. Section 11 also tells the same thing. That main purpose for establishing SEBI is for these 3 reasons, right? Very, very important. Protecting the interest of investors, regulating the securities market and developing the securities market. These are the 3 primary duties and responsibilities of the authority, that is Securities and Exchange Board of India. So this is the function of the Securities and Exchange Board of India under the provisions of Section 11 of the Securities and Exchange Board of India Act of 1992. Now, Section 11 subsection 1 we saw was the functions, 3 points. Section 11 subsection 2 tells that we saw that under Section 11 subsection 1 they said that SEBI has the duty to protect the interest of investors, regulate the market, develop the market, and to do these things, whatever measures are there, whatever directions are required to be passed, that SEBI can do. Now, we under Section 11 subsection 2 are going to see what are the measures that can be taken by the Securities and Exchange Board of India as mentioned under Section 11 subsection 1. To fulfill Section 11 subsection 1, to implement the functions, to implement its objectives, to implement its goal, what are the measures that are required to be taken by SEBI, what is permitted by the SEBI Act, that we are going to see. So, first measure that can be taken by SEBI for implementing its functions is regulating the entire business of the stock exchange and any other securities market. Our entire basic or foundation of the entire securities market is the public issue in the primary market and thereafter trading of shares in the secondary market. So, all these activities take place on the stock exchange. Stock exchange is the facilitator, it is the marketplace where we are going to run the securities market, right? What is the stock exchange? It is a marketplace. Marketplace for what? For the purpose of buying and selling the securities. So, whatever activities take place in the securities market, whether it is in the primary market or the secondary market, all those activities are facilitated through the stock exchanges. So, if you want to have a proper functioning of the securities market, the basic regulation starts from the topmost place, that is the marketplace. So, if the stock exchanges are running and functioning properly, to a huge extent, the market is going to be regulated. So, the first measure that SEBI can take for overseeing the entire securities market is regulate the business of stock exchange. Second, register and regulating the working of certain categories of intermediaries, right? We know the 3 important segments of the market: the issuer, the investor and the intermediaries. Intermediaries are people who are going to connect and provide the facilities required in the securities market. So, if we focus, so who are the next level? So, you have the stock exchange where the trading place or marketplace is there for the securities. To facilitate this, we have intermediaries. So, second place where some kind of wrongful activities can take place is from the end of intermediaries, right? So, if you say that anybody who wants to function as an intermediary in the securities market, whether you are a mutual fund, whether you are a banker, stockbroker, sub-broker, registrar to an issue, no, underwriter, portfolio management, investment advisors, whatever is your designation, if you require each one of these categories to be registered and obtain a license from SEBI before starting the intermediary services, to a certain level you can bring regulation within the market, because they will directly come under the ambit of SEBI. If they do anything wrongful, their license is going to be cancelled, license is going to be suspended, and the investors can be protected. So, that is why they say that for ensuring the first 3 primary objectives to be fulfilled, SEBI has to first regulate the stock exchange. Second one is that they should regulate the intermediaries. For regulating the intermediaries, we have provided that SEBI has to obtain first registration should be done and necessary license should be obtained. That is what they say, that SEBI can take measures by requiring registering and reporting and regulating the working of intermediaries such as stockbrokers, sub-broker, share transfer agent, bankers to an issue, trustee for trust deed, registrar to an issue, merchant banker, underwriter, portfolio manager, investment advisor, or any other category of intermediaries in the securities market. So, even the registration and licensing requirement for intermediaries are going to come directly under the ambit of the Securities and Exchange Board of India. You have an entire chapter, SEBI intermediaries, where we talk about the registration of all the intermediaries, what is the procedure, what are the obligations and responsibilities of these intermediaries, and how they are answerable to the Securities and Exchange Board of India. That is the second measure. Third one, registering and regulating the working of certain other category of intermediaries, being the depository participant, custodian of securities, foreign institutional investors, credit rating agencies, and other categories of intermediaries as being notified by the Securities and Exchange Board of India. So it is a continuation point of the previous point, where other categories of intermediaries name has been listed. Fourth measure that they can focus on is registering and regulating of the working of venture capital fund, collective investment scheme, mutual funds, etc. So whenever we are going to create a fund by taking a pool of money from the public investors at large, and that money is further going to be invested in the securities market, every such fund that is going to be created is going to be required to obtain a registration and be regulated by Securities and Exchange Board of India. And that is why you separately have SEBI mutual fund regulations, you have separately SEBI CIS regulations, separately for venture capital fund you have regulations. So that is why we say that SEBI, for protecting the interest of investors, regulating the market, developing the market, first they have the power to regulate the stock exchange, second they have the power to regulate and register the intermediaries, in that various sectors are there, and then they have the power to register and regulate the funds which are established by taking the pool of money from the public investors at large. These are certain measures that they have to take to ultimately ensure that the entire market is functioning properly. Next function is promoting and regulating self-regulatory organizations. What are self-regulatory organizations? Organizations who believe that we should be 100% compliant. As teachers, as faculties, we tell students, please study, please complete the entire syllabus before going for exam. We will tell, it's our duty to tell you, it is our duty to give you guidance on how you should complete the entire syllabus. But do all the students listen to what the teachers say? No, they don't. There are few category of students who actually abide by everything that their mentors tell them. They are self-regulated, they are disciplined, they are diligent, they are self-regulating. They are following the schedule, they are following the timetables, they are following everything and ensuring that each and every line, each and every chapter from the syllabus, from every subject has been completed. Because they are self-regulated, they know that I want to clear the exam, they know that yes, I have to achieve this, for that I have to put in certain amount of hard work. They are self-regulating themselves, they are self-disciplining themselves, because they have certain objective. That is what is the expectation of SEBI, that we want stock exchanges, we want depositories, we want these kind of intermediaries who are involved in the market to become self-regulatory. They say that SEBI is there to overlook, but we as SEBI do not want to pinpoint and say do this, do that, do that. No, you know the law, you follow the law 100%. No, that will reduce the workload of the Securities and Exchange Board of India. So what SEBI is saying, they want to promote the self-regulatory authorities. They want the organizations to become self-regulation. They want the authorities themselves to think, the organizations like stock exchange, depositories, they themselves should get the feeling that we should be 100% compliant with the provisions of law. We should self-regulate ourselves. We don't want SEBI to monitor us. We are there, we know the laws, we will ensure that our laws, we comply with the provisions of law. So they want to promote the organizations to become self-regulatory in nature. Next, prohibiting any kind of fraudulent and unfair trade practices relating to the securities market. So at any point in time, they identify some kind of fraudulent activities, they identify some kind of unfair trade practices, they have the power to prohibit such transactions, and that by the virtue of this measure itself, they passed one separate regulation also, prohibition of fraudulent and unfair trade practices regulations. Next, promoting the investor education and training of intermediaries of the securities market. So they want to create more education about the securities market. They want to create more awareness. What are the things that you should keep in mind before making an investment? What are the things that you should keep in mind before associating yourself with any intermediary, right? They should create investor education. They should create that awareness in the market about the securities market. To the public they should give awareness, and enough training is required to be given to the securities intermediaries, because these intermediaries are the people who are going to connect with the public at large. So you should give them enough training of how the market functions, what are the basic things, in relation to the work that they are going to do. Basic training is required to be given. So they should take measures to create awareness among the public. They should take measures to provide training to the various categories of securities market intermediaries. So these are various measures that SEBI can take under section 11 subsection 2 to implement that duty that has been provided under section 11 subsection 1. Next, so that was point 7. The other measures that they can also take is prohibit insider trading in securities. What is insider trading? Insider trading is, now we know that there are shares available in the secondary market on the stock exchange quoting at a certain price. You can buy, let's say, the share price, okay, per share is rupees 100. This is the market price as on the stock exchange. Okay, if you want to buy the share, you have to pay 100 rupees, right? Now, there is, and this is in relation to company A. There is one person X. He is an employee of this company A. He works in company A. He is in the finance department. He knows that the company's financials are very good. They have done really well. They have generated huge revenues. They have got a lot of projects. Everything is implemented properly. They have made huge profits. And they know that when the quarterly or the annual result of the company is going to be declared, the share price of the company is going to shoot up, because again the share price is dependent upon the performance of the company and demand and supply. When a company is performing well, everybody wants the shares of that company. So somewhere demand and supply mechanism will work and share price of that company is going to go up. He knows this is bound to happen when the results are going to be declared, and nobody else knows this information. We from public will not have information about how the company has performed, right? Till they don't give us in the press conference or put out the financials in the public domain, till then we don't know the financial position of the company. But he is within the organization. He is working inside the finance department. He knows these basic details. He knows that the share price of the company is going to go up. So what he does, he buys the shares of the company on the basis of this information that he has, that the company is going to do really well when the financials are going to be declared. He has bought the shares when he was in possession of some important information which is called as unpublished price sensitive information. It is an information that is not out in the public domain, but if that information comes out in the public domain, it is going to impact the share price of the company. Having an unpublished price sensitive information, he has undertaken trading activities. He has bought the shares of the company because he knew that the share price is going to go up. He bought it today. If anybody from among the public would know, even they would buy. But now he is in a privileged position. All other people who are from the public category do not have access, so they cannot take the benefit of the share increase in the share price. So they say that any insider who has access to unpublished price sensitive information should not undertake trading activities. They should not use their privilege to make profit and gains. So that is why insider trading itself is prohibited, and that is one measure that SEBI can take, is prohibit insider trading in securities. And to prohibit insider tradings, SEBI has passed the Prohibition of Insider Trading regulations to specifically deal with insider trading violations. That is the next measure that SEBI can take, that is prohibit insider trading. Other measures that they can take is regulate substantial acquisition of shares and takeover of companies. For that, SEBI has passed the SEBI SAST regulations. Next, SEBI has the power of calling for any information, conducting inspection, conducting inquiry, conducting audit of the stock exchanges, of the mutual funds or any other person in the market, of the intermediaries and the self-regulatory organizations in the securities market. So this is one more measure that they can take by calling for information. If they think that there is one person who has access to some information which is going to be helpful in the investigation, it can issue a direction that Mr. A, you are related to this case, you have access to some information, please give us that information, it is going to help us in our investigation. So they have the power to call for information from anybody who is related to in the securities market. They can conduct inquiry, they can conduct inspection, they can conduct the audit, basically to identify whether anything wrong has happened, any violation of SEBI laws have taken place or not. And ultimately on the basis of this, they also have the power to impose penalty for wrongful activities. Next. So previously we saw they have the power for calling information from stock exchanges, intermediaries or any person in the market. They also have powers to call for information from any person. It need not be from a stock exchange, need not be from the intermediary, need not be from the company or the issuer of securities. It can be in general any person. It could be the bank with which the companies have their banking accounts. It could be any other board like the IRDA, PFRDA, if it is belonging to any other sector of business, they have a regulatory authority. You have RERA, you have RBI, you have IRDA, you have PFRDA. So for different sectors, you have different authorities who are overlooking the sector. So from those authorities also, you have the power to call for the information, right, for the purpose of conducting the investigation, inquiry in relation to that particular transaction. So whoever you think has any kind of information or will be helpful in the investigation, you can call information from any such person. There is no restriction that it should be only from the securities market, only from this. First point is with relation to any person in the securities market. Second one, it could be any person, any board, any establishment, any corporation, any bank who can give you vital information for completing your investigation. SEBI can call for any information records from such authorities. Next. They also have the power to call for information and authorities from any other agencies as may be required by SEBI, that they think that such information may be necessary and efficient discharge for their functions. Whatever information that agency has will be necessary and will be important for discharge of SEBI functions. From such agencies also SEBI can call for information from any other authority. Okay. Any other authority in India or outside India which is functioning similar to those of SEBI. So it can be any authority within the country or even outside the country. If any authority is there which is doing work similar to SEBI in relation to regulating the securities market, you can call information from such other authorities as well. So SEBI has the power to call for information from within the securities market. They have the power to call in information from any person, from any department, from any bank, from any other establishment. They also have the power to call for information from any agencies, or they also have the power to call from any other authority within the country or outside the country. Ultimately, any person, any authority, any agency, if SEBI thinks that they have any vital information which can be helpful in the development of the market, regulation of the market or investigation of a particular case, they can call for any information, they can call for any records as well. So that was calling of information, point 10. So calling of information is from various authorities. Next one, performing any other functions and exercising any other power under the provisions of the Securities Contract Regulation Act 1956 as may be delegated to it. So what had happened? We know that SEBI Act came into existence in the year 1992, but the stock exchange is functioning from a very long time. At that point in time, most of the powers were vested in the central government through the Securities Contract Regulation Act. But once the SEBI Act of 1992 was established, all the powers of the central government have been now also delegated to the Securities and Exchange Board of India. So what is there? Securities Contract Regulation Act is there. Under this act, various powers and responsibilities were cast upon the central government because SEBI was not there. In the year 1992, SEBI was brought into existence. SEBI was established. Now, these powers which are vested with the central government have now further been delegated to SEBI. So, SEBI can take measures for performing all such other functions that are given under the Securities Contract Regulation Act, which were primarily vested in the central government. They also have the power of levying necessary fees and charges as may be required. So, to function they need money, right? So, they say that SEBI can take measures by levying fees and collecting any charges. So, when any intermediary want to register itself, it can collect registration fees, right? Any company wants to make an IPO, it has to pay necessary fees, right? That is the fees. Conducting research for the above purposes. So, you know, these are the measures that we can take. How do we take these measures? You know that you have to create laws or you have to prohibit insider trading. But how will you prohibit insider trading? For that, research is required to be done. You want to prevent hostile takeovers, but how do we prevent hostile takeovers? What are the current situations? What are the loopholes? You have to do the research and then frame the rules, then you can frame the regulations. Without having the background knowledge, you cannot make laws, you cannot make rules and regulations. So, you should do complete research of what is the problem, where, what is going wrong, how we can rectify this issue. After you have information on all this, then you can create a law. So, for implementing any one of these above mentioned measures, basic research work is going to be required. After doing the research, they can implement any one of these measures so that they can efficiently fulfill their duties and functions which are mentioned under section 11 subsection 1. Next, the measures are still continuing. 13. Calling from or furnishing of any such agency as may be specified by SEBI, such information as may be necessary. Performing any other function as may have been prescribed under the provisions of this particular enactment. So, these are the measures that can be taken by SEBI under section 11. So, what have we done? What have we studied? A quick recap. We are seeing the powers and functions of SEBI. First, we are focusing on the functions of SEBI. Functions of SEBI is clearly given off under section 11 of the SEBI Act of 1992. Section 11 is divided into two subsections. Section 11 subsection 1 talks basically about the three functions of SEBI, that is nothing but also the duties cast upon SEBI, that is protecting the interest of investors, regulating the securities market and developing the securities market. These are the three primary goals, functions, objectives of SEBI, and to do these things certain measures can be taken, and they say that SEBI has the power to take any measures to implement these three objectives. And what are the measures that they can take? That is provided under section 11 subsection 2, where a long list of various measures that can be taken by SEBI to implement their objectives is going to be provided. We have seen close to 15 points. That is what you have to write. What are the measures that SEBI can take in order to implement its objectives? Now, you have seen 15 points. Is it going to be difficult to remember all these 15 points when you are going to write your exam? So, there is a quick trick that you can keep in mind while writing the measures. So, now if you are going to study and appear for exam, basically at least you will know the name of all your chapters. We have one chapter on SEBI ICDR regulation, you have one chapter on SEBI LODR regulation, you have one chapter on SEBI SAST regulations, you have one chapter on SEBI PIT regulations, you have one chapter on SEBI wrongful activities and fraudulent activities and wrongful activities, you have one chapter on SEBI intermediaries, you have one chapter on SEBI mutual fund, you have one chapter on collective investment scheme. Remember the name of these regulations and what is the purpose of passing this regulation. That itself is measure. One measure was prohibiting insider trading. SEBI has passed PIT regulation. One measure is to prohibit hostile takeovers, regulating the substantial acquisition of shares. You have SAST regulations, then you have prohibition of wrongful practices and unfair trade practices. You have a separate regulation for that. You have regulation of intermediaries, collecting fees and registration licensing requirements. You have SEBI Intermediary Regulation 2008. So, these, remember the name of your chapters, name of the regulation, that itself can be put as measures. SEBI can take measures to prohibit insider trading. SEBI can take measures to look into substantial acquisition of shares and takeovers. SEBI can look into registration and regulation requirements of various intermediaries. SEBI can take into the measures and regulating of the functioning of the stock exchange. So, keeping the name of all your chapters in mind, you can automatically write any point for measures that can be taken by SEBI. So, that was a quick trick and tip that you can use for writing the measures. You do not have to by heart anything. Learn the concept, apply the logic and write your answers. You can easily score marks. There are 15 points. How do I by heart it? No, don't think like that. Understand what is it, correlate the concepts and you can easily write your answers. So, what we have covered? We have covered entire section 11 where we have dealt with the functions of SEBI and what are the measures that can be taken by SEBI to implement its duties and functions. Now, let's move to the next concept, that is what are the powers of SEBI. Again, powers of SEBI have been further subdivided into various categories. One by one, we are going to look into various powers. The first one that we are going to focus on is the power of SEBI to conduct inspection. It is given under section 11, subsection 2A and section 11, subsection 3. Okay, let's see. Power with respect to inspection of books and documents. So, what they say that SEBI is going to conduct investigation only when it thinks that something wrongful is there. We have to investigate and see whether it is wrongful or it's only our assumption. It's only something that is on the face of it looking like it is wrongful. You will get to know the true facts of what is going on only after doing the inspection. For that you need books, you need registers, you need information. I am working in a company, okay. I am the compliance officer of that particular company. Whatever happens in the company, the legal advice, the secretarial advice is given by me. So, I am the person who is going to have a lot of information. I am the person who is going to have a lot of documents in my safe custody as the compliance officer of the company. So, SEBI, if it is going to conduct the investigation on my company in which I am the compliance officer, it is my duty bound to give any information that is in my possession to the Securities and Exchange Board of India. So, whenever SEBI is conducting any investigation, there is a duty cast upon any person who is being investigated to help them in investigation. We should cooperate with SEBI in conducting the investigation. We should not hide information. We should not destroy the due course of investigation. That is what has been provided, that at any point in time, if SEBI is going to conduct any investigation, it calls for any information, it is duty of every such person to cooperate and give the information as may be required. So, they say SEBI can take measures to inspect any book, any register, any document or any record. So, it could be book, register, document, record, it could be physical, it could be manual, it could be digital, it could be computerized, anything, information in any form from any public listed companies, that is the companies which are listed on the recognized stock exchanges, companies which are intending to be listed on the stock exchange. Those are the companies which have filed their draft prospectus with the Securities and Exchange Board of India. They are in the process of becoming listed. So, because we know SEBI is going to be regulator for the securities market. When we talk about securities market, it is the companies which are listed on the stock exchange. Private companies do not come under the regulatory ambit of the Securities and Exchange Board of India as such. So, when it is information is in relation to the listed public companies, you can get information. They can conduct inspection of their books, register, documents, etc. They can also inspect in relation to the companies which are intending to be listed. They are not listed. They have submitted the draft prospectus. In a few months' time, they are going to become listed. They can look into and inspect the register records of such other companies as well. Next. And where SEBI has a reasonable ground to believe that such company has been indulging in either insider trading, some kind of fraudulent or unfair trade practices relating to the securities market, on these reasonable grounds only they can order for inspection to be conducted. Merely at the discretion of SEBI they cannot do. Now, SEBI is a statutory regulatory authority, we already know. Right? SEBI is a statutory regulatory authority, we know. They are the overseer, they are the watchdog of the securities market. Does that mean they can do anything and anything that they want? No, even they are bound by the rules and regulations. Merely, okay, they think that SEBI thinks that this is one company which is flourishing. We want to torture them. Let's issue all kind of orders against that company. Can they do so? No. To start an initiation of an inspection, to conduct an inquiry, to do any kind of inspection, they should have a reasonable ground. Simply at their own discretion, they cannot start investigation. Basic ground should be there to order for investigation. So if they think there is insider trading, if they think there is fraudulent activity, if they think there is unfair trade practice, if they think there is violation of SEBI laws, if they have a ground to believe, and that is a reasonable ground, they have some basic proof to say that something like this is happening, only then they can order for inspection. It is not at the willful discretion of the authority. Even they need certain basic grounds to order for inspection. They have the power to inspect, but that power for inspection is based on reasonable grounds. Only if you have reasonable grounds, you can go ahead and conduct the inspection. Merely to torture or to harass anybody, you cannot do any kind of inspection. You have a reasonable ground, only then we will give you the permission to conduct the inspection. Next, civil court powers. We know they have the power to do the inspection. To do the inspection or to do the basic work or to get the information, you need some kind of powers. We know that SEBI is a statutory regulatory authority which has quasi-legislative powers, quasi-judicial powers and quasi-executive powers. It is not a court. It is not a judiciary as provided under the Indian Constitution, but they have adjudicative powers, right? So that is why they say that we need certain powers that are given in the court. Ultimately, court also give judgment of whether something is right or wrong. Even SEBI is required to do that. They are required to tell whether there is violation of SEBI provision or there is no violation of SEBI provision. Whether somebody is guilty or somebody is not guilty. They have to tell that. To tell that, to give that judgment, to give that decision, they need certain powers of the civil code. And that is what they are saying, that to execute any work, SEBI will require certain powers that are vested with the regular civil codes, and that is why the powers which are vested with the regular civil codes, the same powers we are also going to give to the Securities and Exchange Board of India while they are discharging their quasi-judicial powers. Quasi-judicial means powers like that of courts. Judiciary is the court which are going to interpret the laws and give the final judgment and decision. Here SEBI is also delegated the power of making some kind of decision. That is why we say quasi-judicial. Powers like that of the courts, powers like that of the judiciary are vested even with SEBI. So they say that under section 11 subsection 3 of the SEBI Act, SEBI possesses powers equivalent to that of the civil code as provided under the Code of Civil Procedure, specifically in relation to certain points. The entire code is not applicable. Certain powers which are given to the civil court under the Civil Procedure Code, certain powers are also given to the Securities and Exchange Board of India. Which are those powers? Those are the powers in relation to discovery and production of books of accounts. That means they have the power to direct any person to give them the document, submit the information as may be required. They have the power to summon and enforce the attendance of any person and examining that person under oath. You think that this person is a witness. This person is who has some kind of information. This person will be helpful in this particular case. Whoever that person be, you have the power to summon them. Summon means tell them that on so and so date you are required to appear before the investigating officer of the Securities Exchange Board of India. You are summoning them, you are calling them that this is the date, this is the time, you have to appear before the authority. And when that person comes and appears before the Securities Exchange Board of India, that person can be examined. You can ask him questions relevant to that particular case under oath. What is oath? You would have seen a lot of movies. When any court is there, they give a book and say, whatever I say, I will say the truth and nothing but the truth. That is oath. You are taking an oath that whatever statement I am going to make in this court hall, whatever statement I am going to make within this premises, I am only going to tell the truth and nothing but the truth. That is the oath that people are taking. right? So they say that even SEBI can summon people, call them before them, and once they appear before the authority, they will examine them, they will question them, and whatever question they are asking, they are going to make the person take a oath that whatever I tell, I will tell the truth, and he is bound to tell the truth while he is being examined by SEBI. So that is one power of the civil code that has also been given to the Securities and Exchange Board of India. Next, you have the power for inspecting any books and registered of listed entities. So you can conduct the inspection of any books and records of listed companies, conducting inspections of relevant documents in securities market, right? So you can conduct inspections and issuing commission for examination of witnesses or documents. Generally what happens? Whenever court hearings are there or quasi-judicial hearing is there, we summon the people that you come to the court and give the witness, you come to the court and give us the evidence, you come to the court and give us the statement. It is expected that the witness should walk into the court hall and answer the questions that are being asked by the advocates as well as the judge. That is, witnesses appearing before the court. But at various times, it is not possible for getting the witness to the courts, or it is not possible to get such huge volumes of books, records, etc. to the court hall. In that case, the court passes an order of issuing commission. Means we are creating a group of few people and we are sending them to the place of witness. We are sending them to the place where the books and records are kept. Instead of getting everything to the place of court, we are going to the place and doing whatever is required. We are going to the place and looking for witness. We are going to the place and looking for evidence. That is issuing commission. The general rule of the court is people should come to the court and give evidence. But various expert evidence, sometimes doctors are so busy, you need doctor's opinion. I'm just saying in general medical cases. Doctors are very busy, they cannot come. So the court might issue a commission where people will go to the court's doctor's place, his clinic or hospital, get his statement and come and produce it before the court. That is issuing commission, right? Same thing can happen in any area of expert requirement of field. So one witness might be there, he might be on his deathbed, he's very critical in a hospital, you have to get his statement. The judges will go to the hospital where he is admitted and take the statement and come. That is issuing of commissions, right? So these are all the various powers which are actually vested with the civil courts, and these powers are provided for the civil courts under the Civil Procedure Code. All these powers that the civil courts have now also have been vested on the Securities and Exchange Board of India, because they also have to make a decision of whether it is right or wrong, whether somebody is guilty or not guilty, and to reach to that conclusion while doing the inspection, they require these powers, and these powers are by the virtue of CPC also being given to the Securities and Exchange Board of India as per the provisions of section 11 subsection 3. Right? So that is the power of SEBI to conduct inspection. The next power of SEBI is SEBI's orders and measures. What are the orders and measures that can be passed by SEBI under section 11 subsection 4? They say SEBI may, by an order and for reasons to be recorded in writing, whatever is the decision of SEBI, whatever order SEBI wants to pass, it can pass, but it should be in writing always. And along with in writing, I have decided so and so, the order is there. In the writing, you should have the order, but along with the order, what is the reason for passing that order? Even that should be written in the order itself. In interest of investors or in the interest of securities market, take the following measures either pending investigation or pending an inquiry or on the completion of the investigation or inquiry namely. So they are saying that SEBI has the power to pass orders. It can pass orders. It can do so by putting it into writing. In the writing, you should tell what is the order you are passing. You should tell what is the reason for you to pass that order. But when can you pass the order? You can pass the order when your investigation is pending, interim orders we call. You can pass the order when you are pending some inquiry. You can pass the order after completing of investigation. At any stage, you are permitted to pass the orders. We'll see what they can do. What are the orders? First one is suspension of trading. SEBI can suspend the trading of any securities on the recognized stock exchange. They think that one particular company is involved in fraudulent activities and that company is listed on the stock exchange. Okay, we can suspend the trading, you can stop the trading of those shares of that company from the stock exchange. Suspension of trading, you don't allow the trading of the shares of that company to take place on the stock exchange because you know that company is involved in wrongful activities, it is involved in unfair trade practices, it is involved in fraudulent practices. So let us suspend that company, we will not permit the trading of the shares of that company at all. That is suspension of trading. This is one of the orders that can be passed by SEBI when it is looking at some case, whether the case is pending investigation, pending inquiry, or after the investigation is completed. At any point in time, they think that it is important for us to stop the trading of the shares, they can pass the suspension order. Next order that they can pass is access restraints. Means banning a particular person either permanently or for a fixed duration of time, right? They say that SEBI can restrain individuals from accessing the securities market. Insider trading is taking place. We know insider trading is prohibited. Nobody within the organization who has access to price sensitive information which is not in the public domain, he cannot undertake trading activities, but still he is undertaking activity. You can prohibit that insider from undertaking trading activities for a certain duration of time or permanently ban him from the market itself, right? So we are talking from individual investors' point of view. And they can prohibit any related activities such as buying, selling or dealing in securities. Either you put a permanent ban that no, you cannot do any kind of trading, you cannot access the securities market at all, or you say that you are not allowed to sell these securities which are under investigation. You cannot buy securities till the further orders are going to be discussed. You cannot dispose of any of your shares or securities in your demat account till the entire investigation is completed. So depending upon the facts of the case, depending upon the investigation that is taking place, depending upon the circumstances, SEBI is going to decide whether it should impose a complete ban, temporary ban, or prohibit only buying, selling or dealing in securities. So this is one of the various measures or orders that SEBI can take when it is investing a particular case. Next, suspension of office bearers. Now, generally we assume that all wrongful activities can take place at the end of listed companies. It can take place at the end of the intermediaries and the employees of intermediaries. And ultimately, if there are acquirers, from the end of the acquirers. These are the predominant pinpoints where unfair wrongful trade practices can take place. But there might be possible that to execute any kind of unfair trade practice, wrongful trade practice, they take the help of the employees of the stock exchange. They take the help of any people who are on important designations. So they, at any point in time during the investigation, if they get to know that any of the office bearer of a stock exchange, of a self-regulatory organization is involved in that activity, they can suspend such office bearers. People who are involved in the activity from important designations, they can also be suspended from their position. They can be suspended from their designation. Next, impounding proceedings. What is impounding proceedings? SEBI may impound and retain the proceeds of the securities related to the transactions under investigation. What do they mean? They mean they want to retain the funds that are involved through that wrongful transaction. Let's take the same insider example that I had taken. There is a company A, right? The share price of this particular company on the stock exchange is ₹100. There is Mr. X, who is an insider, who is working in the finance department of the company, A. He is an employee. Okay, he knows that the share price is going to become 180 rupees in a few months to come. So what has he done? He has bought the shares. How many shares? He has bought 100 shares of the company at 100 rupees each. After a duration of time, 80 rupees per share profit 80 per share he is made profit. It was 100 when he bought. He knew that it is going to go up and it has gone up 80 rupees. Okay, 80 rupees it has gone up. 80 rupees per share he is made profit. Into 100 shares he has bought. That is a profit of 8,000 rupees he has made merely on the basis of the unpublished price sensitive information that he had. Now, SEBI has the power to tell this Mr. X that give us this 8,000 rupees. You were not permitted to trade when you were in possession of unpublished price sensitive information. If you would have followed the law, you would not have bought these 100 shares. Because you have bought these 100 shares which you are not entitled to, any profit that you have made out of a wrongful transaction, that profit should be given to the Securities and Exchange Board of India. So, any wrongful earnings you have made or any losses that you have avoided, any money out of a transaction that is unlawful should be retained, or impounding proceedings can be initiated that you give all the money involved in the wrongful transaction to the Securities and Exchange Board of India. You have done a wrongful activity, we will punish you for wrongful activity, but we will also take away the money that you have wrongfully made by the virtue of this wrongful transaction. Merely imposing a penalty is not sufficient. Even the profits that are wrongfully made, if you take, then there is a value for that authority's decision, right? So, they say that we will not allow you to do the wrongful activity. If you do a wrongful activity, we will punish you for the wrongful activity. Not only that, all the wrongful gains that you have made, even that you have to surrender it back to the Securities and Exchange Board of India. That is impounding proceedings, where we are going to take back all the profits that you have made out of wrongful transactions. Next measure or order that can be passed by SEBI is attachment of property. So, SEBI can attach for a period of not exceeding 90 days any bank account, any other property of any intermediary, any person associated in the securities market who is involved in the violation of any of the provisions of this act, means SEBI Act 1992. The rules and regulations made thereunder means any rule or regulation passed or framed by SEBI, and only that property can be retained. Only that bank account can be seized. Only those securities can be restricted in relation to which actually the violation has taken place. You have done a violation and you have deposited the proceeds or the wrongful gains that you have made in one bank account. Only that one bank account of yours can be attached by the Securities Exchange Board of India. Your other accounts need not be attached because that is not involved in any wrongful activity. So, only that property which is anywhere linked to the wrongful transaction, only those kind of properties bank account can be attached by SEBI, and that too only for a period of 90 days. If you want beyond period of 90 days, you should take special permission. Next, non-disposable directive. Non-disposable directive, that you are not permitted to dispose of, you are not permitted to sell, you are not permitted to change the situation. You are required to maintain status quo. Maintain the things as it is. Don't bring about any change. Don't sell the securities. Don't buy more securities. That is what they're saying, that don't dispose, don't sell off. You are not permitted to deal with the securities which are under investigation currently in your demat account. So, SEBI can direct intermediaries or associated persons not to dispose of, alienate any assets which are involved in the investigation. So, whatever is the question in the investigation, depending on the facts of the case, they can say that you are not permitted to deal in those assets. Maintain status quo as it is, let the things be till the investigation is not completed. You cannot dispose of anything from your asset pool. So, these are certain orders that can be taken by SEBI when they are doing investigation. Suspending the trading activities, suspending the people from their office if they are involved in the wrongful activities. They can pass the order for, what else did we see? Non-disposable directive, impounding proceedings. These are the various orders that SEBI can pass when it is doing its investigation and inspection. Next power, procedural safeguards. What are procedural safeguards? When you are doing any inquiry, when you are doing any inspection, basic things should be kept in mind. What is it? Without hearing one party, without giving an opportunity or person to give his side of the story, without giving a person to tell what happened in the given circumstances, if you pass a suspension order, is it relevant? Is it valid? So that is what they say, that whenever you are doing anything, whenever you are passing an order that is going to adversely affect someone, don't pass the order until you don't give them an opportunity of being heard. Something called as principles of natural justice. You should deliver justice, right? But for that, you should hear both the parties. You should see what circumstance there were. Why did they do a particular act? Did they do it? What is their side of story? What is A saying? What is B saying? Hear both of them. Because in one situation, every coin is going to have two sides. Everybody is going to have their side of the story. What is right, what is wrong is for us to decide as judges, as authorities, inspection officers. But to reach that decision, you should hear both the parties. So before passing any kind of order, it is always advisable that you should give them an opportunity of being heard, and that is one basic thing that has to be followed by any authority. See, opportunity of hearing. SEBI must provide an opportunity of hearing to the intermediary or any person that is going to be affected by its order, either before or after issuing such orders. So it is very important for us to hear the other party before passing any order, specifically if it is going to be an adverse order. In any case, you should hear, but if it is going to be unfavorable to that person, you cannot pass without hearing his side of the story, and this is which we also called as basic principles of natural justice. Hear the other side. Opportunity of being heard should be given before passing any order. So that is the procedural safeguard you should keep in mind. Next, the next power of SEBI. So till now what we have covered, let's do a quick recap before you get confused. We are seeing section 11. Section 11 subsection 1 talks about the functions of SEBI. Section 11 subsection 2 talks about the measures that can be taken by SEBI for implementing the objectives and functions given under subsection 1. Thereafter, we started seeing the various powers of the Securities and Exchange Board of India. We have seen first one, the power to conduct inspections. Then we saw the power of the SEBI to pass certain kind of orders. Now we are seeing the power of SEBI to regulate the issue of prospectus, offer document or advertisement soliciting the money for issue of securities. So what are they saying? They are saying that SEBI should regulate. What should they regulate? They should regulate whenever a company is going to issue a prospectus. What is a prospectus? Nothing but a document where the company is telling the public at large that we are bringing a public issue. If you are interested, you can buy the shares of our company, you can buy the securities of our company. That is a prospectus. We are giving you an offer that we are launching our shares, we are issuing our shares, you can come and buy our shares. So whenever a company is going to issue a prospectus, offer document or issue any advertisement in relation to any kind of public issue, or any advertisement in relation to calling for money from public at large, that advertisement, that offer document, that information, all that should be regulated by the Securities and Exchange Board of India. Not only that, there are also certain kind of prohibitions that are going to be given. What kind of prospectus, which company cannot issue prospectus? What are the things that you should not advertise, or what are the basic contents in the advertisement? So not only regulation, but some kind of prohibitions are also there in relation to issue of prospectus, advertisement or any information when we are going to call for money from the public at large. So that is one power that is vested with SEBI under section 11A. Now, SEBI may, for the protecting the interest of investors, pass certain kind of orders. What are those orders? Certain orders are specific orders, certain are general. These are by regulations and these are by orders. What do we mean? SEBI may, for the protection of interest of investors, specify by regulations the matters relating to issue of capital, transfer of securities and matters thereto, and the manner in which the matter shall be disclosed by the company. So we are talking about raising money from public at large, issuing prospectus. We are talking about issuing any kind of advertisement calling people for subscribing to the shares of your company. So in relation to that, we have given powers to SEBI to create a separate regulation, a specific regulation telling them what is the matter that should keep in mind while you are issuing securities, and when you're transferring the securities, what you should keep in mind, and what are the disclosures that are required to be made by the company. And using this power, SEBI has passed SEBI ICDR regulations, issue of capital and disclosure requirements. When you're issuing an offer document under ICDR regulations, a lot of eligibility criteria are there. Do you satisfy that? That is regulation. And disclosure requirements, whenever you're making a rights issue, public issue, IPO, FPO, n number of disclosures are required to be made by the company. That is also clearly specified under ICDR regulations. So they say that in relation to regulating the public issues, SEBI has the power to make regulation, and using this power, SEBI has passed the SEBI ICDR regulations. Not only that, apart from passing a regulation, SEBI also has the power to pass orders. And the order can either be a general order or it can be a specific order. General order is an order that is applicable to all the listed companies. Specific order is an order which is passed again company A, company Y, company Z. Okay, what is it? When SEBI passes order and it passes a general order, that means that order is applicable to all the listed companies. But when a company passes a specific order, it will specify that this order is against company A, it is specifically for company B, or it is specifically for only those companies which have listed their debentures, it is only for those companies which have listed their convertible instruments, right? So, by general or special order, SEBI can prohibit any company from issuing prospectus or offer document or advertising or soliciting for money, and it can specify the conditions subject to which the prospectus or such the offer document, advertisement, if not prohibited, may be issued. It might categorically tell that company XYZ, you are not permitted to make a public issue, we will not permit you to make it issue, we are prohibiting your company from making a issue, and subjected to conditions, we will permit you to make an issue. That they can pass specific orders as may be required based on the facts of a particular case. So, to monitor the public issue, they have the power given, and to monitor the public issue, they can pass regulations and they can pass orders. They can pass regulation by the virtue of which they have passed the SEBI ICDR regulations. They can also pass orders that can be company specific, or it can be a general order that is going to be applicable to all category of companies as may be required. So, this is the power of SEBI in relation to regulating and prohibiting public issue or any kind of offer document, advertisement where they are calling for money from the public at large. Next power is the power to regulate the collective investment scheme, that is the CIS. You have an entire chapter dedicated for regulating of the collective investment scheme. Using this power itself, SEBI, it is AA, see, it is added by the way of an amendment. Earlier, SEBI did not have the power to regulate the collective investment schemes. Now, they have been given the power to regulate the collective investment scheme. That is why it is AA added by the virtue of an amendment. Okay. So, for this, let's see basically overall when we discuss that chapter, we are going to see in detail. Here, we are only going to see that any collective investment scheme, if it is coming under the ambit of the definition of collective investment scheme, it is automatically going to come under the regulatory ambit of SEBI, and all the provisions of the CIS regulations will become applicable. What is a CIS, collective investment scheme? It is any scheme or arrangement which satisfies the basic conditions provided under the collective section 11 to 2A. We have certain conditions. Okay. So, if it satisfies those conditions, then it is going to be called as collective investment scheme, and that is going to come under the virtue of the SEBI regulations. Again, I am not going to get into the details of CIS now. Here our main focus is what is SEBI permitted to do, what are its powers. When we see the CIS chapter in detail, we will see what is CIS and what are the activities. As of now, you just have to know that CIS comes under the regulatory ambit of the Securities and Exchange Board of India. Again, this is what are deemed to be CIS. As of now, I am not dealing with it. Next power of SEBI is power to issue directions and the power to impose penalty, levy penalty, impose penalty. So, they can issue as many directions as may be required to control a particular situation in the securities market, or they have the power to impose any kind of penalties. Let us see. SEBI may issue directions. First one, to whom can they issue directions? They can issue direction on any person or any class of person, specifically in relation to section 12 associated with the securities market, and they can issue directions to any company in respect of matters relating to issue of capital, in relation to transfer of securities, or any other matter that is in relation to the securities itself. But the most important thing is, whatever directions are being passed, that should be the interest of the investors and in the interest of the securities market. So, whatever directions are going to be passed by SEBI to whichever category of person, to whichever company, ultimately that direction should be for a certain objective. What is your objective of passing a direction? It is that you should take the interest of the investors into consideration, and you should take the interest of the securities market into consideration. Only if it is good for the investors and the securities market, only then you can pass the directions as may be required. In the interest of investors or the orderly development of the securities market, for when you can pass directions. Directions can be passed for the following reasons: for the interest of investors, for the development of the market, for the regulation of the market, for preventing the affairs of any intermediary or persons referred to under 12 being conducted in a manner that is detrimental to the interest of investors or the market, or to secure proper management of the intermediary or such other person. On what grounds can you pass the directions? So, SEBI can pass directions on any one of these grounds: in the interest of the investors, for the orderly development of the market, to prohibit any activity taking place detrimental to the interest of investors, or for ensuring the management of some intermediary to be properly carried out. You can direct, you are an intermediary, you are bound by SEBI regulations, you are required to do this. This is my direction. SEBI is giving the intermediary that you should do this for proper enforcement of SEBI laws. So, these are the situations where SEBI can pass directions. Now, authority to issue directions. Who has the authority to issue directions? Because we know SEBI as an authority is a body corporate. It is an artificial person. So, who is going to issue directions? You know to whom to issue. You can issue to any person. It can be any company, it can be any person associated in the securities market. But who has the authority under SEBI to issue these directions? So, they say that SEBI has the authority to issue directions to any person involved in the transaction or the activities that violate the provisions of SEBI Act or related regulations. So, they say that SEBI has the power to issue directions to any person who is involved in any wrongful activity. Next. Disgorgement of gains. Disgorgement of gain. What do they mean? The same concept that I explained to you at the time of impounding proceedings. Whatever wrongful gains you have made or losses that you have avoided by the virtue of a wrongful transaction, by the virtue of violating SEBI provisions, that amount does not belong to you. If you would have followed the procedure of law, if you would have been ethical, if you would have been compliant with the provisions of law, you would not have made that profit. You could not have avoided that loss. Only because you have taken a wrongful path, you have that money in your hands. You are not entitled to that money. You have to give back that money to the Securities and Exchange Board of India. That itself is the disgorgement order. Means any amount that you have wrongfully made, you are not authorized to keep it. Please give it back to the authority. So, what is disgorge? It means to return. What should you return? You should return an amount equivalent to the wrongful gains that you have made or the losses that you have avoided due to the law of contraventions or unlawful transactions that you have executed. Right? So, they are saying that any money that is in your possession because you have done an unlawful activity is not your money. You cannot keep it. You have to give it back. You have to return it back to the Securities Exchange Board of India. So what do they? Disgorgement of gains means SEBI can pass a disgorgement order. That means whatever wrongful gains you have made, whatever losses you have avoided, that money you have to give it to the Securities Exchange Board of India. So it has the power to direct any person who has made a profit or who has avoided any kind of loss by indulging in a transaction or an activity that is contravening the provisions of the Act, rules, regulations, to disgorge, that is to return back an amount equivalent to the wrongful gain or the loss that has been avoided. So in simple terms, you are in possession of some kind of money because you have violated the provisions of law. If you would have followed the provision of law, you would not have that money. So you are not entitled to keep that money even if it is in your possession. So please give it back, disgorge it, return it back to the Securities and Exchange Board of India. So they have the power to disgorge, to pass a disgorgement order. Next. What is the purpose of introducing the concept of disgorgement or disgorgement order? What is the impact and purpose? It is to deter. Generally, the law is based on identifying the wrongful activity, imposing a penalty or giving punishment, done and dusted. What happens to the wrongful amount that he has made? Who is going to talk about that? For this, that's why they want to say that we want to create a deterrence, we want to create a fear that if I am going to court, I am not only going to impose penalty, but whatever money I have made, that also I have to return it back. If that mindset is there, people will deter from doing a wrongful activity. We want to create a fear in the mind of people from executing any kind of wrongful, unlawful practices in the market. So what is the impact and purpose of creating these disgorgement orders is this power of passing the disgorgement order is going to serve as a deterrent, means people are going to fear against the violation by ensuring that any financial benefit gained through an unlawful transactions are required to be returned back into the securities market with integrity. We will not permit you to retain any kind of wrongful gain or money that you have made. That kind of fear we want to create. We want to create deterrence in the mind of people that let's not do it, because even if we do it, all the unlawful gains, money that we have made, that also we have to return it back to the authority. Next one is investor protection. First one is to create fear in the mind of people and create that mindset that let's not do it, because again, even if we do it and we are caught, the entire money we have to give it back. We will not even benefit out of that unlawful transaction. Second one is for the purpose of investor protection. By enforcing the disgorgement orders, SEBI aims to protect the interest of investors and maintain fair market practice. So they want to maintain justice, they want fair market. So why should we allow a person to keep the unlawful money that they have, right? They should return it back. So for the protection of investors, they have decided to go ahead and order even disgorgement amount. Next power is power to conduct investigation, and that is under section 11C. What is that? Section 11C talks about the power of SEBI to conduct various investigations. Let's see. Again, like I told you, at the time of inspection, it is not at the discretion of SEBI that they can go ahead and conduct the inspection. They should have reasonable grounds to believe. They should have some proof. There should be some kind of evidence, some kind of information that will direct you that something is wrong. Merely at your will and wish, you cannot start any inspection investigation. You cannot. You need to have a reasonable ground to believe that something wrongful has taken place. Let me investigate it and see. Again, it is not at the willful discretion of authority. They should have a reasonable ground to believe that detrimental transaction has taken place. That is, any transaction in the market is conducted in a manner that is going to harm the interest of investors or is going to harm the securities market as a whole. That means any violation of SEBI provisions has taken place, because all the SEBI provisions are for protecting the interest of investors. If investors are not protected or any transaction is detrimental to their interest, means somewhere some SEBI violation has taken place. SEBI laws are not complied with. So if any transaction is against the interest of investors, it is against the interest of the securities market, we say it is a detrimental transaction. And if you identify any detrimental transaction, SEBI has the power to order for an investigation. Any regulatory violation, by the face of it, you know that they have violated the provisions of law. We know that at every quarter, every half yearly and annually, the listed companies are required to give out certain disclosures. One-time disclosures, quarterly disclosures, half-yearly disclosures, annual disclosures, event-based disclosures. N number of compliances there for listed entities. If even one of these requirements are not fulfilled, they are violating the provisions. There is a regulatory violation, so they can order for investigation. There are so many restrictions on related party transactions. Companies Act also talks about it, even LODR regulations talk about it. But you have violated something in relation to that. Even in that case, we can order for investigation of those provisions. Next, SEBI may at any time by order in writing direct any person specified in the order to investigate the affairs of such intermediary or person associated with the market and to report that to the Securities and Exchange Board of India. Most important, like I told you, I raised the question even some time back that SEBI is an artificial person. It is going to be run by the board members that are 9 members, the composition of the board. They are only going to oversee the functioning of the board. They will not sit and see each and every case because so many cases, crores of companies are there which are listed. How will they monitor each and every company? So when there is any case, when there is any violation, SEBI is going to appoint one investigating officer. SEBI is going to delegate the power to the investigating officer. It is going to pass an order. This is the case relating to company B. And investigating officer Mr. X is entitled to investigate the case of this particular company. Right? So they are going to pass an order in writing, specify who is the investigating officer, and that investigating officer is going to complete the entire investigating procedure. He is going to fulfill the investigation. After the investigation, he is going to come to a conclusion. That conclusion he is going to specify in the report, and this report he is going to submit it to the Securities and Exchange Board of India. So it is not the board itself which is going to do all the work. SEBI is going to have various category of employees. It is going to have investigating employees to do the investigation. It is going to have adjudicating officers to adjudicate the hearings, to look and hear at the evidence. Depending upon what work is there, you are going to have employees. So for the purpose of investigation, SEBI is going to have investigating officers. Whenever a case comes before SEBI, SEBI is going to pass an order, specify the name of the case, specify the investigating officer who is delegated with the power of investigating that particular case, and he is going to be given all the powers. He is going to complete the investigation. After the investigation, whatever report he finds, he is going to give that conclusion by the form of a report, and that report ultimately it is going to submit to SEBI, and on the basis of that report, if SEBI wants to start a case, it can initiate a case. It can file a case for violation of provisions if the report says that yes, something wrongful is there. If the report says that no wrongful activity is there, they are going to put an end to that particular thing. So what happens? SEBI is there. SEBI for some reason from somewhere gets some kind of information about any wrongful activity. But merely on the basis of information, you cannot start a case, right? For initiating a case, for filing a case, for suing somebody, you need solid reasonable ground. And when you have any information which is a reasonable ground for a wrongful activity, he is going to order for investigation. And this investigation is going to be conducted by the investigating officer. Investigating officer will conduct the investigation and submit a report. If this report confirms that yes, there is a wrongful activity that has taken place, then we are going to file a case for non-compliance of SEBI provisions. If this report says that no, it was a wrong information that was given for us, there is no wrongful activity that has taken place, there is 100% compliance with all the provisions of law, all the investors are safe, there is nothing wrong that is happening in relation to the securities market, we are going to put an end to this particular investigation here here and no further case is going to be filed. Only when there is an investigation and a report that says that yes, wrongful activity has taken place, it is necessitated that you please file a case against them for wrongful transactions or violation of SEBI provisions. Only then the case is going to go back to SEBI. SEBI is then going to appoint that case for the adjudicating officer to hear the case and decide how much penalty is required to be imposed. Right? So that is what is required to be done. Next, duty to produce accounts and records. So like I told you, we are seeing the powers of SEBI for investigation. So we have seen that they are going to appoint investigating officers, they are going to do the investigation, submit the report to SEBI. Now during the process of investigation, the investigating officer will require cooperation and help from various people involved in that case. That is why we say that we are casting duty. Duty is imposed. It is your responsibility to produce accounts and records. So whichever individual, whichever employee, whoever is in possession of vital information, records, documents, information, they are under a duty to give that information to the investigating officer and help in completing the procedure of investigation. They say that individuals and entities are required to preserve and produce all relevant documents for the purpose of investigation which are in their custody. So if I am the compliance officer, I have something in my possession. There is a chief financial officer, there is something in his possession. There is an accountant who has something in his possession. There is an administrative staff who has something in his possession. So whichever individual in their capacity have any information available with them, they are required to submit that information to the investigating officer in their custody. So who all come under the ambit? Managers and officers. It includes every manager, managing director, officer or any employee of the company. It could mean intermediaries, any intermediary which is involved in the securities market, any associated person, any individual entity associated with the market. In short, any person who can help in the investigation of any particular case, and he might have vital information, document, records, that person will come under the ambit of this duty and they have to help and cooperate and coordinate for the purpose of completing the investigation. Now, we know that we are going to do the investigation. SEBI is going to authorize the investigation. Investigating officer is going to complete the process of investigation. But these investigating officers will also require some power. If they don't give them the power, nobody is going to have value for that position of investigating officer. To get things done, to complete the investigation, to call for information, they need powers. Without powers, they cannot execute their duty. They cannot execute their work of completing the investigation. We need to give these investigating officers also some kind of powers, and that is what we are going to discuss here. That similar to how we had given certain powers to the Securities and Exchange Board of India, similar to that of the civil courts as provided under the Civil Procedure Code 1908. Similarly, certain powers we are going to give to the investigating authorities or the investigating officers. Let us see. The investigating authority may require any intermediary, any person associated with the securities market to furnish such information and to produce certain books, records, etc. before him or any other person authorized by him in this behalf, as it may consider necessary, if the furnishing of such information or production of such books, registers, documents or records will be necessary for the purpose of investigation. That is what they are saying, furnishing and producing. You are required to give and produce books, registers, records, information, documents, whatever may be relevant. They have to produce it before the investigating officer. Now, period of custody. For how long can the investigating officer take these documents, books, registers, records, etc. in their custody for doing the investigation? The investigation cannot go on forever. Ultimately, even the listed entities or the proposed to be listed entities are required to enter certain details in the register. They have to maintain documents, etc. If you take the documents, register documents, etc. and keep it with you, it is going to be difficult for them also to continue doing the entering process and enter the further details. Also, we know that for any kind of listed company, public inspection is permitted. At any point in time, anybody can come and inspect the records. So, they will not have records to further give it for the public inspection. That is why we have created a timeline that any investigating officer can have the books, register records that they have seized or taken from the custody of the employees for a maximum period of only 6 months. Within 6 months, you should complete your examination. You should complete your basic inspection. But it is not that once you give, you cannot ask for it back. Do the basic investigation during the 6 months period. Get relevant information that you want. See what you want. Give them the book back. Later, at any point in time, if you want to refer back, you can go back and ask them for those books, documents, registers or records. After this period of 6 months, the documents must be returned back to the person from you had taken it. If the compliance officer had given that book or record or register, you have to hand it over back to the compliance officer. If chief financial officer had given it to you, you have to return it back to that. If accountant had given it to you, you have to give it back to the accountant. So, from whomever you had taken it, to same person, you are required to return it back as may be required. If necessary, the authority can also request the same document again. Like I told you, in 6 months you complete the investigation. Complete the investigation in 6 months' time. Afterwards, if you want to review, you want to go through back, you want to just revisit the documents, you can again ask them to give you back the document for a certain duration of time. The certified copy of these documents must be provided upon request to the person who produced them. At any point in time, if you can't get the original documents, you can ask them to give a certified copy of the original document to be permanently kept with the investigating authority. But the custody of original documents with the investigating officer cannot be for a period beyond 6 months. The investigators may examine the witness, people who are there, on oath. I have already told you what is examination on oath. Anybody who is going to appear before the investigating officer, investigating authority in relation to any case will be asked questions by the investigating authority. Whenever a question is going to be asked to that person, witness, the person who is alleged to have done a wrongful activity, they are required to take an oath that whatever I say, I will say the truth but nothing but the truth. That is an oath that they are taking. They are promising that I will tell only the truth and nothing but the truth. So, you are expecting that that person is only going to say the truth. We are going to examine them under oath and ask them questions. We are giving them the oath and asking questions, and we are believing that whatever they are going to say, they are going to say the truth. The investigators may examine individuals under oath, including the managers, employees, directors or any person for that matter, and require the personal appearance for questioning regarding the business affairs. You can ask them to personally be present also before the investigating officers. Obligation. Obligation is nothing but the duty that is going to be cast. We have already seen this. It is the duty of every person, every employee and any person who has vital information to help the investigating authorities in complete the investigation in a fair manner. Same obligation is cast here. They say that individuals must produce necessary documents, they must furnish the required information, they appear for questioning as and when required, and they also must sign examination notes. Now, what is this examination notes? One situation is going on. We are in a room. I am the investigating officer. There is one more person. I am asking questions. He is giving me the answers under oath. Now, whatever is happening here, this is not a court hall, because investigating authorities are not court officers. They are not police officers as well. It is a quasi-functioning authority that is going on. So, what we are required to do, whatever I am saying is written down. Whatever he is saying is written down. So, we are documenting whatever is happening in this room. What was the question asked? The investigating officer Mr. A asked so and so question. The witness Mr. B answered this to this particular question. Like that, like we maintain minutes of the meeting. minutes of that situation, of that circumstance, of that examination is going to be maintained. Ultimately, after the examination is completed, the investigation is completed, the questioning is completed, we have to read out what we have written in that notes to the person who has made statements before us. If he agrees that what he has said, that itself is mentioned in the notes, he is required to sign it, and that will be used against him before the adjudicating officers. If he's made any statement which is helpful for the case in proving that there was something wrongful, it can be used as evidence at the time of adjudicating the procedure. Right? So that is what they say. We have to take the signature of the person who is being examined, and it is his duty to sign if he is satisfied that whatever is written is exactly what he is said in that particular examination. He cannot deny the signature if it is correctly written. Penalties. If any person does not oblige by the obligations, or if any person does not help in investigation, any person fails to appear before the investigating officer, any person denies producing some kind of register or documents, during this procedure of investigation, if you are creating hurdles, you are creating problems, you are destructing the documents, at that time the investigating officer can impose penalty. They say that there is imprisonment of up to 1 year, fines up to 1 crore rupees, additional fine of up to 5 lakh rupees for every day during which the non-compliance continues. If you don't follow the orders of the investigating authority, you don't appear before them, you don't produce the documents, you don't furnish the information, you don't give under examination under oath, if you don't follow, you are subjected to penalty under the provisions of this particular enactment. Notes of examination. This is what I was saying. What is it? What does it mean? It just means that examination notes must be written down. Whatever conversation is taking place between the investigating authority and the person who is being examined, that conversation is required to be written down. After the investigation is completed, examination is completed, you are required to read it out loud to that person who has been examined, and then it is required to be signed by the person who has examined. I am investigating officer. My signature is not as essential as the person who has made the statement. Because, why is that signature very, very essential? It is very, very important because as investigating officer, I can write anything and submit it to the court. I can submit it to the adjudicating officers of the Securities Exchange Board of India, right? So that the investigating officers do not misuse their power, they have said that any statement, any examination, the person who has been examined, his signature is mandatory. Only if his signature is there, we are going to believe that he has made that statement. Or else the investigating officers can write any answer for their matter and submit it, no? So it is very important to get the signature of the person who is being examined on the register to prove that yes, he has made the statement and he is agreeing to what he has said before the investigating officer. These notes can be used as evidence during the proceedings. If the investigating officer thinks that yes, there is a wrongful practice, there has been a violation that has taken place and that has been confessed for, or somewhere some statement has been made which reflects that a wrongful activity has taken place, that notes during examination that was made, that can be used as evidence by the adjudicating officer before the adjudicating officers. Next is seizure of records. Seize means taking in your custody, right? Now, generally, what is the rule? Whenever a class is going on in your college, you are not supposed to use your mobile phones. But still, students use their mobile phone. What are the college authorities going to do? They are going to seize your mobile phones, right? There is a difference between CEASE and SEI. This is to take custody. Seize is to stop. We are taking away, we are taking the custody of your phone because you are wrongfully using it during the class hours. Here, we are taking the seizure. We are taking away the books, registers, etc. Why? Because we know that if we allow the books, register, documents, information to be in the custody of the employees, there is a possibility that they will permanently destroy it, they will manipulate it, they will alter it, they will modify it to erase the evidence of any wrongful practice. So, whenever any investigating officer has this fear that in this particular case, if we allow the books or information or records to be continued to be in the possession of the company itself, there is a possibility that evidence is going to be destroyed. So we are going to say that we don't want to let the books be in their possession. We want to seize it. We want to take the custody of all the books only to ensure that the evidence is not destroyed off. Right? But because he is an investigating officer, he does not have the power. He has to submit a request to the magistrate, get the permission from the actual court, and only then take the custody. Right? Let's see the provisions. He has to make an application for seizing the documents, for taking the custody of the documents, register, books, records, anything. Right? So, investigating officer has to make an application to the magistrate or the appropriate court who has jurisdiction over that particular area. If the investigating authority believes that any kind of records can be destroyed, can be mutilated, can be altered, can be falsified, can be secreted, you are hiding the documents, you are hiding the registers, you are destroying it, you are burning out, you are tearing it out, it is written, you are changing that to something else, you are modifying the information within the documents. In any way, if you are going to tamper the evidence, if you are going to change the structure of the documents, they can make an application to the magistrate or the judge having appropriate jurisdiction for an order to seize such books, register, documents, etc. This is not in every case. In only those cases where there is a reasonable ground that there is a chance that manipulation can take place, tampering of evidence can take place, only in those cases the investigating authorities are going to submit an application to the magistrate, and the magistrate is thereby seeing the case, hearing the investigating officer, then he is going to decide whether I should permit the application submitted by the investigating authority or not. Okay, if the magistrate thinks that okay, it is necessary for me to give protection for evidence, then he is going to allow the investigating officer to go to that particular premises and seize all the records, documents, books, registers as may be required. Now, assistance. What is assistance? Assistance of the police authorities. Now, whenever you are going to seize something, they are not going to happily hand over the documents. There are people who might do it, but what is going to happen? There is generally going to be hesitance. There is going to be some kind of revolt by the opposite party that I am not going to allow you to seize my documents. Generally, when you are using your phone and teacher comes and snatches, you generally try to get it back, right? So, that is what they are saying, that there might be some kind of tiff between the investigating officer and the person or the employees or the officers of the company. So, in that case, whenever an order of seizure is going to be passed, the magistrate might also give the assistance of police authorities, that whenever you are going to go and seize any books, register, documents, you can take these police inspectors along with you in case, just to prevent any wrongful incident to take place, right? So, you are going to get the help also of the police officers to complete the procedure of seizing the documents. The authorized officer may also request the service of any police officer or any officer of the central government or both to assist in the purpose of above specified, and shall be the duty of every such officer to comply with such requisition. Is nothing but requesting the police officers to help in complete the procedure of seizing the documents which was permitted by the magistrate in the previous paragraph. Now, court authorization for seizure is mandatory. Like I told you, investigating authorities only have the power to take in custody for a period of 6 months. Thereafter, they have to give back the records. But even before getting the custody of the books, or after the custody has been given back, they are manipulating. At any point in time, if he thinks that no, we should not allow the custody to remain in the hands of the company, it is going to make an application to the court, that is the magistrate. So, without getting an order from the magistrate or the appropriate court, investigating officers cannot seize the books. They are only taking in custody for the purpose of examination. It is not seized. If you want to seize the books, registers, you need to mandatorily get the permission from the regular courts. After considering the application and hearing the investigating authority, the magistrate or the judge may authorize the investigating officer. After hearing the investigating officer, they are going to decide, should we permit the seizure or should we not permit. If he permits, he is going to give powers for 3 things. First one is to enter the location where the books etc. are kept. Only when you go to the place, you can seize it. So, first one is you should be allowed entry into the premises where the books are kept. Second one, conduct the search as specified in the order, because as soon as you enter the premises, they are not going to happily hand over all the documents that are relevant for the case. It is for the investigating authorities to see, go take lot of officers with them, see what are the registers, what are the documents, what is relevant for the investigation, select what is the document that is required to be seized, which are the computers that are required to be sealed, right? So it is for you to go and search the premises and select whatever you want for the purpose of seizure. And last one, once you have got the relevant information, relevant books, register, computer systems, hard drives, whatever is required, then you can seize it. So what is the procedure of seizure? Investigating officer should apply to the magistrate. Magistrate is going to hear the case. If he thinks that there is a fear of destruction or tampering of the evidence, they are going to authorize the investigating officer first to enter the location, second one to conduct the search of the premises and identify what is required. After he has got what he is required, he can seize that he needs for the purpose of investigation. And in this entire process, also assistance of police officers can be applied for, and the magistrate, if he thinks he is reasonable, he is also going to provide the assistance of the police officers. This is the entire process of conducting the investigation by the investigating officer. Next, exemption. What is exemption? Exemption is this power of taking the documents or seizing the documents will be exempted for certain class of companies. They say that the seizure of records from listed public companies or companies which are intended to be listed. We have submitted the draft prospectus or prospectus, but the IPO is not yet completed. For these category of companies, we will not allow seizure of documents. Generally, it is not allowed because it is public company and all the documents must always be available for the purpose of public inspection. We are not allowing to seize it, except when there is insider trading and market manipulation. If these two situations are involved, we will permit the seizure. We will permit the seizing of documents by the investigating officer only and only when there is insider trading or market manipulation. In any other case, they come under exemption and we will not give them the permission to seize the documents with respect to two companies, listed public companies and the companies which are proposed to be listed. For these two categories of companies, seizure is not going to apply. Seizure is going to apply only when situation is in relation to insider trading or market manipulation. Next, returning of the records. You should give it back, no? You have taken the custody of the documents or you have seized the documents after taking the permission from the magistrate, all that is fine. But at some point in time, you have to return back the documents to the person who is authorized. So they say that investigation officer must retain the seized documents only until the investigation concludes, but must return them afterwards from whose custody it has been taken. So here they have not given a time duration as such. They have said just as soon as the investigation is completed, you should give them back the books. If you have taken from Mr. A, give it back to A. If you have taken to B, give it back to B. So from whomever you have taken, give the books back to that particular person. Investigating authority may mark the documents for identification purpose and must inform the magistrate or the judge of the return. You got the permission to take that particular book into custody only by the permission of the magistrate, right? So you should inform magistrate back, you had ordered us to seize the book, we seized the book, we completed our investigation, now we have given back the books to them. They should not ask that we have not given it back to them. So inform the magistrate that we have completed the process and we have given them the books back. But when you're returning the books back, if the investigating officer thinks that some page is relevant, some information is important, they can put bookmarks, they can put identification mark that this information is important for us, this page is important for us. This is something that we will look for in future if we re-verify the information. So they can put any identification mark on any information that they think is relevant for the purpose of investigation. Next. Every search that is going to be done of the premises, every seizure of books records that is going to be made under the virtue of these particular provisions must be carried out in accordance with the provisions of the Criminal Procedure Code 1973. This particular Criminal Procedure Code has now been repealed. A new act, that is the Bharatiya Nagarik Suraksha Sanhita 2023, has been replaced the Criminal Procedure Code. So whatever procedure relating to search and seizure is provided under the Criminal Procedure Code, but now the BNSS, that is going to apply for even the search and seizure that is going to be conducted by the investigating authority as per the directions given by the magistrate. So all those provisions of this particular relevant law with respect to criminal procedures is required to be followed even by the investigating officer. One case in relation to investigation and the help and cooperation that is required by every employee towards the investigating officer and helping him in completing the investigating procedure is this. Nilesh Kumar Radhesham Lahoti versus the Securities and Exchange Board of India. It is a case of 2021. This was in relation to investigation into a particular company, Supreme Tech Smart Limited, and this case was decided by the adjudicating officer of the Securities and Exchange Board of India. Let's see what happened. SEBI was investigating that particular company for the period between 1st June 2016 to 31st October 2016. During this period, whatever activities have taken place within that particular company, that was the subject of investigation for the Securities and Exchange Board of India. During this time, what all has taken place is what is being investigated by the investigating officer. Mr. Lahoti had received a summon from the adjudicating officer under section 11C, okay, requesting him to submit the documents and informations as may be required, right? He has submitted the information, but what information and documents he is given to the investigating officer was later found to be incorrect. So what he has done, he has tried to mislead the investigation. He has given the wrongful information under oath, or when he is given the documents, everything what he said is incorrect. So what he has done, he has not cooperated in investigation. He has misled the investigation. That is why a case is initiated against him, where they said that we initiated an adjudication proceeding not against the company. Against that company, still investigation is already going on. During the investigation, this one person, Mr. Lahoti, has given wrongful information. So now, apart from that case, a new case is filed against that individual for giving wrongful information, for misleading the investigation. So it was brought against him individual capacity under the SEBI Act, imposed a penalty of 8 lakh rupees for giving false information to the investigating officers. It established that Mr. Lahoti's action obstructed the investigation and violated the provisions of section 11C, that is the power for investigation. So it is very important that you abide by the provisions that are provided under SEBI Act, otherwise huge penalties are going to be imposed under SEBI Act. So here one person who was the witness, who had documents, if he would have given the right information, the investigation would have been correct, he would also be in a safe position. But he did not abide by the duty that is imposed upon him in giving the correct information. He did not cooperate, he did not coordinate, because he cooperated in the sense he gave the book, but he gave a wrong book, he gave wrong information. So in that case, he was held guilty for misleading investigation and hampering the process of investigation, and 8 lakh penalty he had to give for submitting that wrongful information before the investigating authority. Next. What is the takeaway from this case? It is individuals who are associated with the securities market must cooperate fully when investigation is going on, and they should provide accurate information. They should not mislead the investigation by giving wrongful information. So that was the power of SEBI to conduct investigation. So we have seen various powers of SEBI. Next power of SEBI is to pass the cease and desist order. What is cease and desist order? I told you CEASC. What is cease? Cease is to stop. Desist is to refrain. Stop means I am doing a wrongful activity, okay? I am involved in, let's say, market manipulation. I am undertaking, I am some way controlling the price of the securities. I am controlling a demand and supply mechanism of the shares of my own company in the stock exchange. So that somewhere I am involved in market manipulation. SEBI will tell me, it will pass an order against me, cease, stop doing these activities, stop manipulating the market, stop doing any wrongful practices, stop violating the SEBI provisions. That is cease order, stop immediately. You are doing a wrongful activity, stop now. That is cease order, stop, enough, stop, don't continue doing these wrongful activities. What is desist? Stop now, but future refrain from doing such activities. Now because we have told stop, you are stopping. After the cease order terminates and the case is done, after some time don't again start doing these activities. Refrain from again doing these wrongful activities. That is cease and desist. Stop it now and don't continue and don't repeat again in future. Refrain. Do not repeat the wrongful activities again. That is cease and desist. Right? They have the power to pass these cease and desist orders. Let's see. Authority, SEBI has the power to issue cease and desist orders. What are the conditions for action? If SEBI finds through any inquiry that any person has violated or likely to violate any provisions of SEBI Act rules, regulations, it can pass this necessary order. So, if it is identifying that something wrongful is taking place, only then, no, only when violation is there, it is going to tell to stop. So, at any point in time, if SEBI thinks that anybody is violating the provisions of law, they have the power to issue a cease and desist order where they are telling them, please stop these wrongful activities. Also, you refrain from repeating these wrongful activities in the future. So, they are controlling the immediate situation. Also, they are warning them that in future, don't repeat it again. That is cease and desist order. Next, SEBI may pass an order requiring such a person to cease and desist from committing or causing such violation, right? So, it is SEBI who is going to pass such an order on the direction as may be required. Exemption, okay. Again, exemption is given from cease and desist order. Again, it is to two categories of companies, listed public companies and companies which are intended to be listed on the stock exchange. Again, these companies generally we cannot issue cease and desist orders except in two situations which is similar, insider trading and market manipulation. If it is a case of insider trading, if it is a case of market manipulation, only then against these two categories of companies we can issue cease and desist orders. Otherwise, we cannot issue against these companies. But we can issue against individuals. Whether it is the cease and desist order or the order of seizure, there we cannot do it in relation to the public company. To the company itself we cannot issue, but people who are involved within that particular company in their designation, individual people in that capacity as employees of those companies, to them we can pass. But in the name of this public listed company and intended to be listed company, we cannot pass any cease and desist order except it is in case of market manipulation and insider trading. One case, Nishan Singh versus SEBI, it is the latest case 2024. Unregistered portfolio management services by Mr. Nishan Singh, proprietor of Sanban Investments. Okay. So, again what is here? Here we are saying in relation to cease and desist order. Here Mr. Nishan Singh, what did he do? He portrayed himself as an investment advisor. He was not an investment advisor or a proprietor or a portfolio manager. He was not having that license and registration from the Securities and Exchange Board of India. But he portrayed himself before individuals as a portfolio manager, that he is registered with SEBI, that he has a license. Only when he portrayed, people will get confidence, right? So, he portrayed himself to be the registered SEBI portfolio manager and he got a lot of clients. He took their investments for the purpose of giving them advice of how they should invest their money in the market, etc. And people lost a lot of money. That is when SEBI filed a case and passed a cease and desist order that stop using the pretext of being a SEBI registered portfolio manager. First of all, you are not registered, so stop using that name, stop your portfolio management services. N number of other cease orders were passed against this Mr. Nishan Singh. Let's see. A complaint was received from Mr. Kaif Khan, alleged that this Mr. Nishan Singh falsely represent himself to be a registered portfolio manager with SEBI. So, he falsely told that yes, I am SEBI registered portfolio manager. Mr. Singh told Mr. Khan, and this Mr. Khan gave his money to Mr. Singh for the purpose of investment, and that is 1.21 crore rupees of money was given to him for the purpose of investing in the securities market. What were the services offered? That Mr. Nishan Singh claimed to manage the entire investment portfolio but requires a minimum of 1 crore rupees. He says that he handles only high net worth individuals. Only if you give me 1 crore rupees, I will take your account and do the portfolio management services. So minimum 1 crore rupees transaction should be there, and charge 50% of the profits. He said, I will help grow your money significantly by investing in appropriate places. But whatever profits you make, out of that 50% will be mine. That is my service charge. He obtained login details of his Demat account. He took the client's Demat account for the purpose of making an investment and managing the portfolio. Agreement. Agreement was entered into between Mr. Khan and Mr. Singh. Agreement was executed stating Singh was a SEBI registered portfolio manager. However, Khan's holding, which was 1.2 crore rupees, after handing it over to Mr. Singh, significantly dropped to 20% of the initial holding. It dropped. If 100 rupees was there in the account, only 20 rupees are pending. Other amount is manipulated or losses were suffered. He has manipulated the funds of Mr. Khan. That is when he filed a case before SEBI, that he is saying in the agreement also that he is SEBI registered portfolio manager, but he is actually unregistered portfolio manager. That is when this case was filed against him, and SEBI has passed an order. The SEBI has investigated the case. It has reached to a conclusion. Adjudication is taking place. The adjudicating officer has said that first cease and desist. Cease and desist is stop and refrain from doing it in future. First, stop calling yourself a SEBI registered portfolio manager. You have not obtained a license, you have not obtained the registration. How can you write yourself as a SEBI registered portfolio manager? First, stop, and in future also stop providing portfolio management services in the name of SEBI registered portfolio manager. So Singh must immediately stop acting as a portfolio manager and refrain from any unregistered securities market activities. Please stop, and in future also don't repeat it again. Next order that was passed in the cases, you have taken 1.26 crore rupees from Mr. Khan. So you have to refund this total amount back to your clients, not only Mr. Khan, but there were other clients also. To all those clients also, whatever you have done, within 3 months time, you have to return this entire money to all your clients. Public notice, he was required to give a public notice in a public newspaper that I am so and so person, I provided these services, and now this is the refund thing. This case was filed against me and I am giving back the money. This entire thing was required to be published in a public notice. And repayment method, they say that you cannot give in cash. You have to make the transaction only through the bank drafts, bank documents, electronic transfer to maintain an audit trail. We want the records to be there, and that can happen only when you are making an online payment, either bank to bank transfer. No, so that is why they said that physical cash will not be permitted. You have to maintain accounts and the refund should be done. So these are the orders that were passed against this Mr. Singh for wrongfully portraying himself as a SEBI registered portfolio manager. Why did we see this case here? Because in this case, SEBI adjudicating officer has passed a cease and desist order. They've stopped him from calling himself as a SEBI registered portfolio manager, and they've refrained him, directed him that please don't continue these portfolio management services till you're unregistered. Next, asset restriction. Asset restriction, we also saw the powers of SEBI to pass non-disposal orders, non-disposal directions. The same thing they applied here. They told Singh that he cannot sell any assets except for making refund. Bank can only allow withdrawal for this purpose, because it was a huge amount that he had to give to various clients. So he was not permitted to withdraw money, sell his property, except for the purpose of collecting money, for the purpose of making the payment to these particular clients. For any other payment, they have said that don't do it. Don't allow him to withdraw the money until and unless it is to give it to one of his clients. He cannot withdraw money from any of his bank accounts, neither can he sell his property for any other reason. If he is selling his property, whatever money he is getting from that property, that should be used for paying back the clients itself. So there was order on disposing of his property. Completion report. After the entire refund process is completed and all the clients have been given back their money, a report is required to be submitted to SEBI stating that the case has been brought to an end. All the people who had to be given their money, the money has been given, and now we can let him go. Last one is escrow account. What is the account? Any money that has been remaining in his funds, that money should be taken back and it should be given to the investor protection fund. SEBI should retain the money. We will not allow him to make any profits. Next, market access ban. also told you suspension, right? Suspension could be a temporary suspension or a permanent ban from the market. So they've imposed a ban for 2 years or until the refunds are completed, whichever is later. So they've imposed a ban on him personally, individually, that he cannot undertake any transaction in the securities market for 2 years or till the refund to all the clients is not completed. He finished the refund to the client within 1 year. After 1 year itself, ban is over, whichever is later. Okay, so 2 years, right? Minimum 2 years, or if the refund takes longer, the longer period, right? So that is what they said. And registration requirement, that you cannot provide any portfolio services without obtaining SEBI registration. If you are really inclined in doing and providing these portfolio services, please make an application to SEBI, get a valid certificate, get a valid registration, and then you start your services. But as an unregistered portfolio manager, you cannot provide your services. So a restriction was imposed upon what are the services that he is going to provide, right? Next power of SEBI is the power to make regulations. Regulation is nothing but delegated legislation. I have already explained this in the first half of the session. What is it? SEBI has the power to make regulations. Generally, Parliament makes the laws, but the Parliament cannot go to the grassroots level, identify the problem and give a solution by the way of law. It is the regulatory authorities who should know better their sector. So they should be given the power to make basic rules and regulations, and that is why SEBI, being the regulator of the securities market, has been vested with quasi-legislative powers that are nothing but power to make regulations. They can make laws for the securities market by the way of regulations, and using this power itself, SEBI has passed the SEBI ICDR, LODR, PIT, mutual fund, CIS, all these regulations by using this particular power under section 30 of the SEBI Act. Let's see. SEBI's authority. SEBI can create regulations consistent with the Act to fulfill the objectives. Again, SEBI is the main act, SEBI Act of 1992. Under the ambit, using the powers that are vested, we saw the measures that can be taken by SEBI under section 11 subsection 2, right? What are the list? Using those measures, for fulfilling those measures, if any regulation is required to be passed, they can do so. So any regulation that is going to be framed by SEBI, that should be compliant with the SEBI Act. It cannot do anything over and above the powers that is given. If a power is given, use that power. If a power is not there, SEBI cannot do anything about it. So what is allowed to do under the SEBI Act, only that can be done by SEBI by passing various regulations. Specific regulations may include, you can pass specific regulations in relation to meeting times, procedures and quorum for the board. This is in relation to the management, right? If SEBI is there, you know there are 9 members on the board members are there. When are these members required to meet? How frequently they are required to meet? What are they going to discuss? How are we going to maintain the minutes of their meetings? All those details, procedures can be the rules regulation for its own procedure can be made by SEBI. Terms of service of SEBI employees and officers, for how long their employment will be, what are the terms, what is going to be their salary, what are the terms and conditions of employment, all that is also going to be decided by SEBI itself. Next, disclosure requirements for companies regarding capital issues and security transfer. So using this itself, we have the ICDR regulations. Next, utilization of funds credited under the Act. So if any money is received by SEBI, we know SEBI can impose penalties. SEBI can have disgorgement orders through which it is receiving the unlawful gains. It is getting the avoided losses. All that money SEBI is collecting from the wrongdoers. What is going to happen to all that money? That money is going to be deposited somewhere. How are we going to use that money? That rules also they are required to frame. Conditions for collective investment schemes. Registration and certificate requirements and cancellation of procedures. Okay, if you have given the certificate of registration to any intermediary, for which category of intermediary, what is the registration fees, right? What are the basic obligations? What are the things that they should do? When their certificate can be cancelled, when their certificate can be suspended, all these are the points on which they can make rules and regulation. Settlement of proceedings and procedures. At any point in time, if a wrongdoer himself walks to SEBI and tells that yes, I did a wrongful activity for so and so reason, I want to settle a dispute. I don't want this case to go on, don't want adjudicating proceedings to go on, I don't want examination, investigation to take place. This has happened, I am coming directly to you, please settle the matter. You say, you take the settlement fee as may be required, let's not fight over it, let us settle the case mutually between us. Okay, that is settlement proceeding. And any other matter as may be necessary. For all these things, SEBI can make specific regulations as may be required. Next, powers of SEBI that we have studied over various sections, whether it is the power of SEBI to pass orders, power of SEBI to take measures, power of the SEBI to order investigation, power of SEBI to regulate any of these activities. These powers of SEBI are restricted only to the territorial boundary of India firstly, and these shall not apply to the international financial service centers. You have an entire chapter for the new syllabus, chapter 7, which talks about international financial service centers. Though these financial centers are situated within the territory of India, they are considered as an extra territory. It is considered as foreign territory for the purpose of this act. So, for the International Financial Service Center, we have established one more authority called as the International Financial Service Center Authority. So, that authority will take care of all the activities within the financial center. SEBI is not applicable. SEBI is not having the jurisdiction to look after anything that is taking place within the International Financial Service Center. We have the International Financial Service Center Authority who has been given the jurisdiction to regulate the financial centers. So, anything in relation to SEBI is not applicable to international financial service centers. Same thing what I have explained just now, that SEBI's power do not apply to international financial service centers. Regulation of the financial products and services which are provided within the financial service center come under the jurisdiction of the International Financial Service Centers Authority. So, that authority will take care. SEBI has no role to play over the international financial service centers. Next. So, that is all with respect to the functions and powers of SEBI that we were seeing initially. Now, let's move ahead to the next topic of discussion under SEBI Act 1992 is the registration of intermediaries. This is provided under chapter 5 of SEBI Act of 1992. Again, we have one exclusive separate chapter on intermediaries where we are seeing what is the definition of intermediary, how intermediaries are required to obtain the certificate of registration from SEBI, what are the forms they have to submit, what is the fee they have to submit, whether one intermediary can provide multiple services or they can provide only one service. Right, we have n number of topics for discussion is there exclusively in that particular chapter. Here we are only going to see the overview of registration process, that is merely because it is coming under the ambit of SEBI, that all the intermediaries, if they want to function in the securities market, they have to take mandatory registration from the Securities and Exchange Board of India. If you are an unregistered intermediary, you are not permitted to operate at all, right? And that awareness SEBI is creating for investors, that whenever investors are looking out for services, please look for SEBI registered intermediary services only. If you are going to an unregistered intermediary, then don't expect SEBI to protect your interest, because SEBI has clearly created awareness that investors are requested to deal only and only with SEBI registered intermediaries. So, the investors also should take that step, and little they should be diligent when they are making their investment decisions. So, we are going to focus here about registration of intermediaries and how they cannot operate without obtaining a SEBI license. Yes. Intermediary requiring registration, section 12 says that the following category of intermediaries are required to mandatorily obtain a certificate of registration from SEBI to buy, sell or deal in securities. That is the stockbrokers. Now, categories of subbroker does not exist. Share transfer agent, banker to an issue, trustee, registrar, merchant banker, underwriter, portfolio manager, investment advisor, depositories, depository participant, custodians, foreign institutional investors, credit rating or any other category. All these intermediaries, they can function, they can provide provide services, they can deal in securities on behalf of their clients only and only if they are SEBI registered intermediaries, that is they have valid certificate of registration which is issued by the Securities and Exchange Board of India. Restriction on being a sponsorer for CIS, VCS or mutual funds, that is what they say. This collective investment scheme, venture capital fund and mutual funds are the pool of money which is going to be created by collecting money from public at large for various different categories of investment. Now, they say that a person will not be permitted to become the sponsor of any one of this until and unless they have obtained the SEBI registration. Same thing applies for here also, restriction on investment by unit linked insurance policies. Unit linked insurance policies are nothing but where they are going to make an investment in the insurance sector, where they are going to put that money ultimately into the market itself. So, for that also there is restriction that until and unless they have not obtained the necessary registration requirements, they are not permitted to make an investment in these kind of policies. Next. That is just basic. Now, let us get into the process. Again, a lot of details are not given. This is just a brush up of the topic. The actual registration procedure is provided under the chapter on intermediaries. Here, they only say application procedure. What is it? Any person who wants to register himself as any one of the intermediary, whether a stockbroker, whether it is a depository participant, whether it is a portfolio manager, investment advisor, custodian, whatever category of intermediary, if you want to give services, first you should make an application to the Securities and Exchange Board of India. Appropriate application is there for every different category of intermediary. Different application form is there. You should select the application form that is suitable to you. Along with the application form, you should attach the necessary fees in the name of SEBI by the way of a demand draft and submit it to the Securities and Exchange Board of India. They will process the information, they will process the application, they will see eligibility criteria, they will go through a historical background, they will do all the verification. After they are satisfied that okay, this is correct, they are going to grant you certificate of registration. After the certificate of registration has been granted to an intermediary, that does not mean that it is permanent. At any point in time, if the intermediary after getting SEBI registration resorts to any kind of violations of SEBI laws, resorts to any kind of unfair trade practice, any wrongful trade practice, fraudulent trade practice, SEBI at any point in time has the power to suspend their license, suspend their certificate of registration, and if it is found, they are found guilty. Suspension is during the pending investigation or like a warning, we are suspending for so many days and letting it be. But if they find that the offence they have done is very serious, it has caused a lot of loss to the public investors at large, it has damaged the securities market, in that case they can also pass the cancellation order where we are going to permanently cancel off the registration and they will never be allowed to carry on the services that they are providing. So, this is the registration requirement for intermediaries and thereafter suspension and withdrawal and cancellation of their services, that is certificate of registration, in case they violate to any wrongful or violent practices. Next is prohibition of manipulative practices under chapter 5A. So, here SEBI has the power to stop any kind of manipulative practices that are taking place over the securities market. So, section 12A of the Act provides that any person shall not directly or indirectly, whether directly or indirectly, you should not be involved in the following activities. What is it? Using any kind of manipulative or deceptive device in the securities transaction. A lot of technology goes in establishing the securities market, right? So, at any point in time, you should not use any device or anything that is going to cause any kind of manipulation in the securities market transactions. You should not employ any device, scheme or artifice to defraud in connection with the issue of dealing in securities. So, your intention should not be to do any kind of scam or fraud in the market. Engage in any act, practice, course of business which operates or would operate as a fraud or deceit upon any person. So, ultimately, if you are going to involve in any activity which is going to manipulate the market, you are doing any activity for defrauding the investors or defrauding the securities market itself, in that case, they have a right to prohibit such transactions and no such person shall be permitted either directly or indirectly to engage any one of these activities. If it is found that any person is involved in any one of these activities, SEBI is going to take appropriate action for such wrongful and fraudulent practices. Next, continuation. No person shall be permitted to be engaged in insider trading. No person shall be allowed to deal with non-public information, that is nothing but unpublished price-sensitive information. No person shall be allowed to carry out fraudulent practices in connection with securities. No person shall be permitted to acquire control on any company or securities for more than the percentage of equity shares of the company. So, under SEBI regulations, we have clear-cut guidelines how much amount of shares or what number of shares can be acquired by one person over a given duration of time. If you are going over and above board that, you cannot do so. So, there are certain restrictions that are imposed upon the persons, and these should be followed. If any one of these is violated, we say that there is violation of the SEBI regulation. So, yes, they can prohibit the activities which are going to manipulate the market. Now, getting to the important segment, penalties and adjudication under chapter 6A of the SEBI Act. Let's look at the penalty provisions. Penalty is nothing but if you have done a wrongful activity, for the wrongful activity we are going to impose a penalty. You have done a wrongful activity, you pay for the wrong that you have done. So, SEBI has the power to impose penalties. For what reasons can we impose penalty? If there is any failure, you are required to give us disclosure every quarterly. You have not given us the disclosure. You are required to submit us so and so financial statements. You have not submitted the financial statements. You are required to produce documents before us. Investigating officer has called for the production of books. You have failed to give those production of books, right? Default. You have declared a dividend, but you have not paid it, right? You have defaulted the provisions of law. Non-disclosure. You are required to give information to the stock exchange, to the public. You have not given that disclosure, or for any other offense, right? So, for these reasons, on these grounds, SEBI has the power to impose penalties. In short, if there is at any point in time contravention of SEBI rules, regulations, SEBI has the power to impose any kind of penalty. Now, under section, I am quickly taking you to a quick recap of from where SEBI has got the power to impose penalty. Under section 11, subsection 2, clause 1, we say that SEBI has the power to call for any kind of information. They have the power to conduct inquiry. They have a power to conduct audit of any stock exchange, mutual fund, or any person associated with the entity. And thereafter, if they find that there is any kind of violation, they also have the power to impose a necessary penalty provision. So, this is the provision that says that they have the right to call for information. If the information is not received, also they have the power to impose penalty. Yes. So, now let us quickly look at the various penalties. For which wrong, what is the penalty? So, a long list is there. I will tell you how you can easily remember what are the penalty provisions, because sometimes they ask that the company failed to furnish the information, how much penalty is required to be paid. Like this, under multiple chapters, you have penalty provisions, and for different wrongful activity, different penalty is there. So, you generally tend to confuse about what is the penalty amount for which wrongful activity. So, at the end, towards the end of penalty provisions, I will give you a tip of how to remember these penalty provisions. First penalty is for failure to furnish the information. The investigating officer or the SEBI has requested you to give some information to them, but you have failed to give the information to them. In that case, what will they do? They will impose a minimum penalty of 1 lakh rupees minimum. And if you don't give even after the imposition of penalty, that penalty will continue to 1 lakh for every day, per day 1 lakh. Till you don't give, till that every day 1 lakh will be adding on, subjected to a maximum of 1 crore rupees. Minimum is 1 lakh, right? You have to give, after we impose the penalty, you have to give. Even after imposing penalty, you are still not furnishing that information. Till you don't give that information, 1 lakh every day will be adding, till it reaches 1 crore rupees. Beyond 1 crore rupees, we cannot take. Even after 1 crore rupees, you are not furnishing the information, we cannot increase the penalty beyond 1 crore rupees. So, what is minimum? Minimum 1 lakh rupees, subject to a maximum of 1 crore rupees. But during this duration, 1 lakh for every day of non-compliance is going to be added till it reaches 1 crore rupees. Next, failure to enter into an agreement with the client. So this is a new topic, we have not discussed much about it, but there is a general obligation on the intermediaries that if an intermediary is providing a service to the company, the intermediary is required to obtain and enter into an agreement with the company. If the intermediary is providing a service to the investor, they are required to enter into an agreement with the customer before providing those services. So at any point in time, if the intermediaries are not entering into the agreement with their respective clients, right, in that case they are violating the provisions, because they say that intermediaries can provide services only after entering into agreement. If you fail to enter into agreement, penalty provisions under 15B will become applicable. They say again it is the same thing, 1 lakh rupees minimum and 1 lakh rupees is going to add till your failure continues, subject to a maximum of 1 crore rupees. Next, 15C, failure to redress investor grievance. What is investor grievance? If anybody has any problem with you, whether you are a listed company, whether you are an intermediary, if any person has any problem with you, they have raised a complaint, but you have not answered to their complaint, you have not addressed to their complaint, you have not given solution to their problem, in that case, you are held responsible, because there is a timeline set that if an investor is raising a complaint, within this time you should give them a valid solution. You should reply to them, you should give them the solution, you should help with their problem. If you are not doing so, then there is a penalty that can be imposed, which is similar to what we saw in the previous two penalties, minimum 1 lakh rupees, 1 lakh every day till the default continues, subject to a maximum limit of 1 crore rupees. Next, default by mutual funds. Okay, for specific defaults specified for mutual funds, if they are doing any kind of default which is specifically provided, then again it is the same penalty that we saw for the previous one that is going to become applicable. Non-compliance by asset management companies, again it is the same thing. The previous one for mutual fund, this is for asset management companies. Alternative investment funds compliance. Failure to comply with SEBI regulations or directives, again it is minimum 1 lakh rupees, but which can extend to 1 crore rupees or 3 times the amount of wrongful gains that you have done because of non-compliance, whichever is higher. So what are they saying? They have changed it here. Till now it was same, minimum 1 lakh every day till default continues, subject to a maximum ceiling of 1 crore rupees. Here they say minimum 1 lakh, that is same. Every day nothing is adding up, but they say that can extend up to a maximum of 1 crore rupees or 3 times the amount of gain that you have made. Out of 1 crore and 3 times the amount of gain, whichever is higher, that is going to become the upper limit. Right? So minimum is 1 lakh, upper limit can either be 1 crore rupees or 3 times the amount of wrongful money that you have made because of that wrongful practice. Whichever is higher of those two, that is going to be the penalty provision. Next, non-compliance by investment advisors and research analysts. So now we are seeing for category wise. First we saw mutual fund, then we saw asset management companies, then we saw alternative investment funds. Now we are seeing investment advisors and research analysts. All these are different categories of intermediaries. So if they breach the provisions of SEBI regulations, penalty is applicable, 1 lakh rupees minimum, subject to a 1 lakh rupees every day during non-compliance, subject to a maximum of 1 crore rupees. Again, we are going back to the initial penalty that is there for all the offences. Next, default by stock brokers. This is the next category of intermediaries. If they contravene, if they fail to issue contract notes correctly, if they fail to deliver the securities and make payments, if they do, they charge excess brokerage from the customers. In all these cases, we can impose penalty for them. If they fail to deliver contract notes, 1 lakh minimum, maximum 1 crore rupees. If they fail to make payments and deliver securities, 1 lakh, maximum 1 crore. If they do charge excess brokerage for the services that they are providing, minimum 1 lakh, then it is up to 5 times of the excess amount that they have charged. So these are the penalties for the wrongful activities of the stock broker. Next, insider trading, very important, 15G. If any person involves in insider trading, what are the contravention and what is the penalty? He is trading based on unpublished price sensitive information. Not only trading, but if he is communicating such information for somebody else to make unlawful gains or avoid losses, even that itself is insider trading. What do I mean? Trading means, like I told you, let's take the same example. There was this company A whose shares were 100 rupees per share on the stock exchange. X was the employee working in the finance department. He knows the share price is going to go up. So what he did, Mr. X itself bought 100 shares, right? This is what we saw. Now, that is first part, first transaction, where he himself has bought 100 shares. That means he is trading based on unpublished price sensitive information. That is a violation. Now, let's assume that Mr. X did not buy 100 shares. Mr. X has given that information to Mr. B, who is one of the relative, and this Mr. B buys 100 shares in his name. Even then, X itself will be held liable for insider trading, because he has communicated that information to somebody else for making the unlawful gains or avoid unlawful losses. So, it is not only trading while you are in possession of unpublished price sensitive information, but you cannot also communicate that information to anybody else. If you trade or if you communicate on the basis of unpublished price sensitive information, penalty will be a minimum of 10 lakh rupees extending to 25 crore rupees, or 3 times of the profit that you are made, whichever is higher of the following. So, very, very strict for insider trading violations. Next, non-disclosure of share acquisitions and takeover. Again, this is one of the penalties under the SEBI regulations, that under SEBI regulations you are required to make an open offer, you are required to make disclosures that I have acquired so much percentage of a share of a particular company, this is my shareholding. You have to give intimations, you have to give disclosures. If you don't make those disclosures on time when you are making additional acquisition of shares or when you are selling off your shares, at that point there is a contravention of the provisions of SEBI regulations and SEBI provisions, and that is why penalty is 10 lakh rupees, 25 crore rupees, or 3 times the amount of failure, whichever is higher. Next, fraudulent and unfair trade practice. Anybody who is going to engage in fraudulent or unfair trade practices is going to be subject to a penalty of minimum 5 lakh extending to 25 crore rupees, or 3 times the amount which is made from such practices, whichever is higher. Of this, whichever is going to be higher, that is going to be the upper limit, but minimum is going to be 5 lakh. Within this range, they are going to decide what is the penalty that is required to be imposed. Next, alteration, destruction of records, right? At any point in time, if you fail to protect the electronic database or alter or destroy the database records, anything that is being provided, penalty is 1 lakh extending to 10 crore rupees, or 3 times the amount of profit that you are making, whichever is higher. And general contravention, what we have seen now is specific. If you have not failure to give information, contravention by mutual fund, contravention by stock brokers, no insider trading. For each one of these specific wrongful activities, we have penalty. But by chance, if there is some kind of wrongful activity for which no specific penalty has been provided, then this general clause is going to become applicable, which says that any other violation without a specific penalty, for which specifically under section 15, one of the clauses we have not specified, then the general will become applicable, that is minimum is 1 lakh and subject to a maximum of 1 crore rupees. So, these are the penalty provisions of the Securities and Exchange Board of India. Now, I'll tell you how to remember the penalty provisions. First and foremost is I want you all to make 2 tables. In one table, you are going to write down the common penalty. What is the common penalty? We saw in multiple kind of offences. They said that minimum is 1 lakh, additional 1 lakh till the default continues, and subject to a maximum of 1 crore rupees. This is a common penalty that is there under the SEBI Act for multiple offences. So, write this common penalty in bold. Under this, write down what are the offences that come under this general common penalty. I am not telling general penalty because general penalty is different, right? Common penalty you write, common penalties means for multiple different category of failures, same penalty provisions are there. So write down what is that common penalty and write down the list of offences which come under this common penalty provisions. One more table that you have to draw, here you're going to talk about specific penalty, because it is not common. For this separate penalty itself they have provided. For this you have to draw a table like this, where you are going to have two columns. Here you are going to write what is the offence and here you are going to write what is the penalty. But which one are you going to study? Where should you focus on? You should focus on this table. You should know every point out of this table. You should know the offence and you should know the penalty, because you should be able to correlate what is the penalty. You cannot interchange the answer, that will become a wrong answer. For what offence, what is the penalty, exactly you have to write. So this is the table that you have to study. From this table, do you need to study anything? You have to only study what is this penalty, the common penalty, right? So in exam, how are you going to write? In exam, if they give you a particular question, what is the penalty for so and so offence? You know that if that offence comes under this list, you know what is the penalty because you have studied. But if the offence comes and it is not from one of these offences mentioned in this table, then automatically you know that that offence is coming under the general common penalty provisions. It is there among one of this list. Then you write the common penalty and come. So you only have to study this one specific table correctly. You do not have to study all the offences which is coming under the common penalty. If it does not come under the specific penalty list of offences, that means it is there under the general list. Under the general list, you already know what is the common penalty. Write that answer and come. So this is how you should make two tables for every chapter where penalty provisions are going to be provided. Here you remember what is the penalty provision. You have to mandatorily remember what is the common penalty. You need not remember what are the offences that come under the common penalty. But you have to mandatorily remember what is the specific offence and what is the specific penalty. If the question is asked from among the specific penalty, you know the answer. But if the offence is from among the general list, even then you know the answer, it is a common penalty, right? So this is how you should create tables for penalty provisions of the entire subject in this capital market and securities or securities laws and capital market. Now, penalty is over. Let's get into the adjudicating procedure. I showed you in the initially how it happens. SEBI is there. SEBI gets any kind of doubt. Okay. As soon as doubt is there, that doubt should be a reasonable doubt. If there is a reasonable doubt, it is going to order for an investigation. If it orders for an investigation, an investigating officer is going to be appointed. That investigating officer is going to complete the investigation and submit a report. That report can have two outcomes. Once, that yes, there is a violation of any kind of SEBI laws. Other one is that there is no violation of any kind of laws. If there is no violation, we are going to put an end to this particular case. If it is held that yes, there is a violation, we are required to file a case. Once a case is filed, report is going to go before SEBI that yes, there is a violation. SEBI is going to make a decision, we should file a case, and SEBI is going to pass on that case to one of the various adjudicating officers that are appointed by SEBI, and he is going to conduct the case. He is going to hear the case. He is going to give the final decision of how much penalty is required to be imposed, what is the due course, whether he is guilty, whether he is not guilty. Ultimately, that decision is going to be taken by the adjudicating officer. Now, we are going to focus on the adjudicating procedure. Okay, who is the authority? SEBI is going to appoint an adjudicating officer for the purpose of conducting the inquiry into violation. So, there are two procedures. One is investigation. Next one is inquiry. Investigation is done by the investigating officer, inquiry is done by the adjudicating officer. He is going to collect and give us the details. On the basis of the details, he is going to inquire, he is going to ask the people, he is going to question the people, he is going to ask for witness, he is going to ask for evidence, right? So, he is going to inquire into the violation as suggested by the investigating officer. What is the procedure? Again, there is no procedure because these are quasi-authorities. They are not courts. They are only having quasi-judicial powers. They do not have powers that of the court to do everything as that of the court. So they are not bound by the Code of Civil Procedure, they are not bound by the Code of Criminal Procedure, they are not bound by the Indian Evidence Act. No, they have the power to regulate their own procedure, but only one thing that they should follow is the basic principles of natural justice that give an opportunity of being heard. Before passing any order, please hear the other party. Before deciding something, hear what he has to say. After hearing him, then you give your judgment. Maybe he will change your mind after giving a reply to anything, after giving his side of the story. Maybe our decision will change, maybe our mindset will change, because till we don't know all the details, we cannot pass a judgment. Right? Don't believe in rumors. Hear both the parties and then make a decision of what is right and what is wrong. So that is the only one thing that they have to follow by the way of procedure, is to follow the principles of natural justice. Hear all the parties before giving a judgment. Other procedural laws are not applicable. Next, what are the powers of the adjudicating officers? Like we have given powers to SEBI, we have given powers to the investigating officers. Now we also need to give some kind of powers to the adjudicating officers, because they are carrying out the functions of the court. They are carrying out quasi-judicial functions. Functions like that of the court. They are not directly courts, but they are doing something that the court does. They are solving disputes, they are hearing cases, they are giving judgment. So when they are giving this final judgment, where they are imposing penalties, they should have some kind of power to do this entire procedure. So same what we saw for SEBI in respect to the powers of the civil code, same powers we are giving them. We are giving them to call, summon people and enforce the attendance of people before them for the purpose of giving the facts and evidence and produce any document before them. So you can summon a person, call them and ask them to produce document. You can call for the attendance of any person before the adjudicating officer. Next, enhancing penalties, very, very important. Very, very important provision. Why is that so? This power is of the Securities and Exchange Board of India. What do they say? Here we know that SEBI is going to forward a case to the adjudicating officer. Adjudicating officer is going to hear the case and then they are going to impose the penalty if as may be necessary. So adjudicating officer is an employee of the Securities and Exchange Board of India, right? This is the basics. Adjudicating officer is hearing a case. He is the person who is going to impose a penalty. Is there a possibility that one of the parties, so case is between two people, okay, let's assume these two people are fighting against each other. This is the case before the adjudicating officer, right? Now, is there a possibility that this one Mr. person contacts the adjudicating officer, tells that I will give you so and so amount of money, you give the case in my favor. I have done a wrong, but you give the case in my favor. Or he says that yes, I have done a wrongful activity, you can hold that I am guilty, you can tell that I am liable. I have done an offence where 25 crore rupees of penalty should be imposed on me. Such huge wrongful activity I have done in the securities market, which is evident on the face of it. But I will give you the money. Instead of giving the money to SEBI, in your personal capacity, I am going to give you the money. You impose a penalty of 12 lakh rupees. I will give you 8 lakh rupees in your pocket. This you impose a penalty. This I will give you as bribe. Totally I am spending only 20 lakh rupees, whereas actually if the case was properly investigated or adjudicated, 25 crore rupees had to be given. So here who is at the benefit? This person is at benefit because instead of spending 25 crore rupees, he is only spending 20 lakh rupees. Out of the 20 lakh rupees, only 12 lakh is going to SEBI as penalty. Adjudicating officer is also benefit because he is getting a bribe of 8 lakh rupees. Is this situation possible? It is possible. So what they have said that so that these situations do not arise, what are they given? Who is supreme here? Here always supreme is the Securities and Exchange Board of India. So they have said that at any point in time, if SEBI thinks that any adjudicating officer has imposed lesser penalties, 12 lakh rupees is less than 25 crore rupees, significantly lesser than 25 crore rupees. If SEBI identifies that any adjudicating officer is resorting to such practices, is imposing penalties much lesser than what he should do, SEBI is retaining the powers to increase those penalties as may be required and take actions against the adjudicating officer. This is what we are reading here. SEBI has the power to enhance the penalties. SEBI may call for and examine the record of any proceedings under this section if it considers that the order passed by the adjudicating officer is erroneous. By mistake, willfully or wrongfully, he has imposed lesser penalties for a very serious offence. SEBI can call that case before it. It will call the adjudicating officer, submit the details of this case. On what basis have you imposed this penalty? You have given a wrongful penalty for such a serious offence. It can thereafter increase the penalty. It may extent. It is not in the interest of the securities market. It may, after making and causing an inquiry to be made, pass an order for enhancing the quantum of penalty as may be required to justify that particular case. But even when SEBI is going to enhance the penalty, it is required to hear the other party before enhancing the penalty, right? So this is to check the adjudicating officers that they don't resort to wrongful practices within the system. Enhancing penalties, the same thing. No such order of enhancing penalty can be passed by SEBI until and unless an opportunity of being heard in the matter is not being given to the adjudicating officer as well as the person who has to pay the penalty, right? To both the people, you should give an opportunity of being heard. But nothing contained in this section will be applicable after the expiry of 3 months from the date of passing of the order of the adjudicating officer or disposal of the appeal, whichever is later. So there is a time bar. Okay, SEBI should continuously monitor. If 3 months is over and this erroneous order has been passed, SEBI cannot do anything about it because the limitation period is 3 months. Within 3 months, if you identify a wrongful order is passed, only then you can enhance the penalty. If 3 months period is over, you cannot reopen again a case for enhancing the penalty. That is the restriction that is there with respect to limitation period. Okay, so that is it. From investigation to adjudication, imposing penalties, we have seen. Now, adjudicating officer has come to a conclusion that this is the person, he has done a wrongful activity. Yes, he is guilty of an offence and various sections are there. We saw from right section 15, 15A, 15B, C, D, E, F, multiple sections are there where various for different offences, different penalties are provided. Lower range is given, maximum range is given. Now, adjudicating officer, depending upon the facts of each case, depending upon the violation, depending upon the seriousness of the offence, he should determine for this case how much penalty I should impose. So here we are seeing in the Securities Exchange Board of India Act itself, they have clearly given what are the factors that are required to be taken into consideration by the adjudicating officer while they are deciding the quantum of penalty. We know adjudicating officer has to impose a penalty, but how much penalty is he going to impose? That, how he is going to determine? The SEBI Act section 15J itself has provided 3 factors. These are the things you should keep in mind while determining the quantum. Let us see what are those provisions. They say, when an adjudicating officer has to impose a penalty, he has one specific range available for him, lower limit, upper limit. Within that huge range, because 1 crore, 1 lakh is the minimum, maximum is 1 crore. Somewhere 1 lakh is minimum, maximum is 25 crores or 3 times the amount. There is a huge gap between lower range and the upper range. So among this range, how much penalty should be imposed? That is a question. That is a question mark. So that they have left to the discretion. Means it is left to the choice of the adjudicating officer. Depending on the facts of the case, he is going to decide. In that facts, what are the things we are going to consider? First, we are going to see what is the disproportionate gain or unlawful advantage that he's got. How much money has he made by doing that wrongful practice? how much profit he is made by resorting to violation of the provisions. That we have to see. Second, we are going to see by his wrongful advantage, what loss has been caused to the ultimate public investors. That is the second point. Last one is repetitive nature of default. How often this wrongful activity is undertaken by this person. These are the three things that the adjudicating officer has to keep in mind when he is imposing any kind of penalty under the SEBI provisions. The next question is, should the adjudicating officer limit the factors only to these 3 points? Can there be point 4, 5, 6, 7, 8 depending upon the facts of each case? Because the SEBI Act points only 3 points. These are the 3 factors you should take into consideration. But only are these 3 points relevant, or depending upon the facts of each case, the adjudicating officer can consider even other relevant facts as may be necessary, or factors should be taken into consideration. This was the question also that was asked in one of the case. Okay, that is it from the time of getting an intimation about a wrongful activity to doing the basic investigation and then forwarding the report to the adjudicating officer. We have seen what the adjudicating officer is going to do. Now, when adjudicating officer has a case before him, he has come to a conclusion that this particular wrongful offence has taken place. Thereafter, he has to decide what is the penalty that is required to be imposed on the basis of the wrongful act and the circumstances of the case. When he is imposing the penalty, what are the factors that an adjudicating officer is required to take into consideration is what we have to determine. Because when we saw the penalty provisions under various sections from 15A to 15E, E, F, G, H, under all the provisions, we have the lower limit, we have the upper limit. Somewhere they say that minimum of at least 1 lakh rupees subject to a maximum of 1 crore rupees. For some offences which are very serious, up to 25 crore rupees. So you have minimum value of 1 lakh rupees, maximum value of 25 crore rupees, which is a huge range. Now within this range, what is the actual amount of penalty that has to be imposed by the adjudicating officer? That is going to be determined on the basis of facts and circumstances of each of the case. Now, the Act itself has provided us 3 points. What are the basic 3 things that an adjudicating officer has to keep in mind while determining the quantum of penalty to be imposed for a wrongful activity? So, let us see what are the factors that are required to be taken into consideration while adjudging what is the quantum of penalty under section 15J. So, 15J is very important. It is a repeated question that is being asked also by the institute. So, please look into this carefully. So, they say that whenever a case is brought before an adjudicating officer and he determines that a person is guilty, he should see firstly what is the disproportionate advantage or gain that a wrongdoer has made. What is the profits that he is wrongfully made? How much is the losses that he is avoided by resorting to wrongful practices? That one we are going to consider. Second, we are going to consider how much loss is caused to the ultimate public investors because of this wrongful activity of this one person. Lastly, what is the repetitive nature of the default? How often this one individual is violating the provisions of SEBI regulations in specific relation to one particular activity? How many times he is resorting to wrongful practices? These are the 3 basic factors that are required to be taken into consideration by an adjudicating officer while he is going to determine how much penalty is required to be imposed for a wrongful activity based on the facts and circumstances of each of the case. Now, the next question that arises is, are the factors limited only to these 3 points? Because the SEBI Act section 15J gives only 3 points. Now, should the adjudicating officer limit his scope or factors only to these 3 points that are provided, or in addition to these points, we can have other points as well depending upon the facts of the case? This was the question that was raised by the adjudicating officers. They said that if you are telling the factors to be taken into consideration is limited to do these 3, Even penalty provisions specifically you have provided for every category of offence, this is the penalty to be imposed. Then what is the role of adjudicating officer here? What will we do when you have clearly provided everything in the enactment itself? What is the role of adjudicating officer? Why do you want us to be there? Right? When penalty also you are telling under various provisions of section 15. Factors also you are only given. Then what is the role of adjudicating officer? That is when the Supreme Court has clearly said that we are giving you only the lower limit and the upper limit, in which a lot of gap is there, right? And we are giving you only illustrative list. This is only illustrative. These are the basic things. In addition to this, if you want any other factor which is relevant for your facts, you please take that into consideration. And moreover, it is the discretion of the adjudicating officer to determine within this range what is the penalty that is required to be imposed. You determine that. How serious is the offence? On that basis, you tell us what is the penalty. So yes, there is a role of the adjudicating officer. It is his discretion to impose penalty only within the range, and this is only illustrative in nature. In addition to this, whatever other factors are there relevant to your case, you can take that into consideration. So this is very, very important topic which is multiple times asked by the institute. Next, the 3 points I have given a little detailed explanation. The penalty may be influenced by the quantifiable benefit which is gained by the offender due to the default. This ensures that those who have profited from the misconduct should be held accountable. Second one is the loss to the investors because of the gain of one person. If anybody else is suffering, we have to also take that into consideration, and the main aim of this factor is to protect the interest of investors and restitute the confidence of them back in the institute. And lastly, repetitive nature. How often you are offending the same SEBI regulations rules is very important. If it is a one-time event, you can impose lesser penalties, or more so if it is not a serious offence, give a warning or a suspension and leave them. But if it is repetitive in nature, you have to take it seriously, because if you become a habitual offender, it becomes difficult. You have to take the last resort means and impose higher levels of penalty. That is why the repetitive nature of the offence is very important. What does SEBI do with the collected penalties? So we have seen the penalty amounts are huge: 1 lakh, 5 lakh, 10 lakhs, 25 crore rupees, 3 times the amount of default. These are all the words that are used on penalty provisions. Now, when SEBI imposes penalty, the person is going to pay that money to SEBI. What is SEBI going to do with that money? SEBI is going to transfer all that money to one account called as the Consolidated Fund of India. All the money is going to be deposited there, and thereafter how are we going to use that money? That money is further going to be used by SEBI for specified activities as provided under rules and regulations itself. Now, one case law, this is the one that I was talking about, where the adjudicating officer themselves have filed a case saying that penalty provisions are provided, factors are provided, then what is the role of adjudicating officer? Why have you even appointed us? Okay, we do not have any role to play while we are imposing penalties. This was the complaint that was raised by them. Let's see, and it was a case that is decided by the Supreme Court of India. Let's see what were the factors, what were the questions they raised. First, they said that whether the factors that are provided under section 15(j) are they exhaustive for adjudicating penalties. Exhaustive means that is the maximum. Beyond that, we cannot consider. And the word illustrative, means it is only an example of list. You can add anything as per your requirement. So that is the question they asked. Second one, whether the penalty provisions under various provisions of section 15H limit the discretion of the adjudicating officer. When you yourself have given lower limit, upper limit, what is the role of the adjudicating officer is what they were questioning. And to this, Supreme Court has clearly answered. To the first question, the factors that are provided are only illustrative in nature. Those are certain examples, points that are given in the section. Beyond this, based on the facts of the case, if you consider anything else is relevant for consideration, you can please go ahead and add those circumstances and factors also while imposing the penalty. And for the second question, they said that whatever we have provided under various provisions of section 15, they are only to ensure that each one category of case is treated equally. Like if there is one violation of insider trading, another violation of insider trading, two different adjudicating officers are hearing to this matter, they want some kind of similarity in punishment that is going to be given, right? If that is why they have specified minimum and maximum limit. Within that range, still the discretion lies in the hands of the adjudicating officer itself. So they say that yes, the discretion is still in the hands of adjudicating officer to determine what is the quantum of penalty based on the lower and upper limit. Just to bring similarity in cases when punishment is going to be given in same offence, they want to bring some kind of consistency in the cases. That is why they have just given lower limit and upper limit, but still the entire discretion is in the hands of the adjudicating officer. Right. One more case, India Ratings and Research Private Limited versus the Securities and Exchange Board of India. This particular case has been decided by the Securities Appellate Tribunal. It is an appeal case. The adjudicating officer has imposed a penalty of 25 lakh rupees for violating the code of conduct by a credit rating agency. Okay, so this was a credit rating agency, it had violated the code of conduct, and for the violation, the adjudicating officer has imposed a penalty of 25 lakh rupees for the violation. SEBI has issued a second show cause notice directing the appellate to show as to why the penalty should not be enhanced. We saw the provisions where power was given to SEBI that in case there is any error in the order passed by the adjudicating officer, the Securities Exchange Board of India has the right to enhance the penalty. So in this particular case, adjudicating officer imposed 25 lakh rupees penalty, but SEBI is not satisfied with it. So it has issued one more notice asking the person why we should not enhance the penalty that has been imposed by the adjudicating officer, because in the opinion of Securities Exchange Board of India, the adjudicating officer's order was not in the interest of the securities market. Some error has been done by the adjudicating officer while he is imposing the penalty of 25 lakh rupees. That is why SEBI has reconsidered this particular case. Order that was passed in this particular case, SEBI has the authority to examine the decision of AO and further enhance the penalty. This is the section that we are covering in this particular provision. The Securities Appellate Tribunal directed the appellant to deposit first 25 lakh rupees that is ordered by the adjudicating officer and then further continue the inquiry on enhanced penalty. However, the new orders from SEBI will not take effect during the appeal procedure. So, during the appellate pending appeal, we cannot enhance the penalty. After the appeal, we are going to see what the Securities Appellate Tribunal is going to say and then decide the enhanced penalty. Here, discretion of adjudicating officer. The adjudicating officer has the flexibility to consider various circumstances while determining the penalty, which supports a more nuanced approach to adjudication. So, yes, we are only giving lower limit, upper limits. Remaining discretion, the decision is still in the hands of the adjudicating officer itself. So, here the oversight is SEBI can review and enhance the penalty, ensuring that the actions taken are in the interest of the investors and they maintain the integrity of the securities market and consistency in penalty provisions. The relationship between penalty provisions is critical for fair enforcement of regulations in the securities market. So, the same thing they are continuing and saying that yes, though SEBI has a right of increasing the penalty, they can do so, but also there should be consistency in the penalty that is going to be enforced for different kinds of offences. If multiple cases of insider trading are there, you cannot have different levels of penalty for insider trading case. All insider trading case should have same levels of penalties. Again, slight variation will be there depending upon the facts of the case. So, that is what is the outcome of these cases. Next. That is all with respect to the adjudicating procedure. Now, let's move to a new concept, that is settlement of cases, settlement proceedings under SEBI Act. What is settlement? Settlement is just settling down for something. You are just agreeing on certain terms and conditions. So, what happens in a settlement proceeding is, a person is there, he knows maybe there is a violation that has happened from their end, or he is of the opinion that why do we have to get into this litigation, let us just settle the case. Whether there is an error or not an error, we don't want to be dragged into various cases. Let's just talk it out with the authorities and settle the matter. Let's just close the matter by mutually having a discussion. That is settlement proceedings. We want to settle the case without fighting it in the quasi-judicial authorities or before the judicial authorities. That is settlement. You want to just put an end to the case by having a mutual discussion. So how does SEBI entertain settlement proceedings? Does it allow, does it not allow, is what we are going to focus in this part of the slide. Now, section 15JB talks about the settlement procedure. What are the things that should be taken into consideration? First, always whenever a new thing is required to be done or new request is there, is going to happen by the way of an application. So anybody who wants to settle a dispute with the Securities and Exchange Board of India, they have to make an application. Once SEBI receives the application, it is going to consider the case whether it is worthy enough for settlement or actual case should be initiated. We are not going to go for settlement. They are going to make that decision. If they go and agree that okay, we are going to settle the case, basic terms and conditions discussion and procedure is going to go on. Once the final settlement is done, they agree on mutual terms, they agree on the settlement fees, all that is done, the procedure is coming to an end, a final decision is there. That decision that comes by the way of a settlement proceeding can never be appealed before any authorities. It is not appealable in nature. And lastly, whatever settlement fees is going to be collected, that is going to be treated similar to that of a penalty, and it is going to be credited to the Consolidated Fund of India. So this is the basic procedure for entering into a settlement deed or agreement, finally, settlement proceedings. First one, application. Any person against whom any proceedings have been initiated or may be initiated, a case is already filed against you, or you are under an apprehension that maybe I might get a notice from SEBI for this wrongful activity, whatever, even after a case is initiated against you, you can request them that please don't start this case, we will make an application for settlement. Okay, so whether it is initiated or not initiated, right, under these provisions, they may file an application in writing to SEBI, giving them an idea or proposing a request or giving them an offer that we want to settle this particular case. We don't want to go and have a hearing or go into litigation. Let's just talk it out and put an end to this particular case. So basically, an application is required to be submitted in writing to the Securities and Exchange Board of India. Next, after the application is received, SEBI is going to see what is the nature of offence for which they want the settlement. They are going to see the gravity, what is the seriousness of the offence, and what is the impact of default. Because of that wrongful activity, how much damage has been caused. These three things are going to be taken into consideration. On the basis of these factors, either they are going to approve the settlement proceeding or they are going to reject the application that is going to be submitted. If the application is going to be rejected, we are going to continue with the case. If the application is going to be accepted, we are going to go for the settlement proceeding. Okay, on the basis of these factors, SEBI will then decide whether they are going to agree to the proposal of a settlement by payment of, by the defaulter, certain fees that is going to be called as the settlement fees. Now, procedure for settlement, again, it is as may be specified in appropriate regulations. Rules are there, bylaws are there for Securities Exchange Board of India. According to that, certain standards and procedures are there. We are going to follow that procedure for going about the settlement proceedings. No appeal shall be made from a settlement order. Why? Because settlement order is coming by mutual discussion. The offender and SEBI together are sitting and deciding what should be done, how are we going to put an end to this particular case. Certain agreement is going to be entered into between SEBI and the wrongdoer or the person who has made an application for settlement of the case. Mutually, they are agreeing to terms and conditions. When mutually you agree to something, what or where is the question of being aggrieved? Where is the question of questioning or going back on the decision? So they say that no appeal will be permitted when mutually you have agreed on a settlement proceeding. No appeal shall be allowed under 15T against any order passed by SEBI or adjudicating officer as the case may be in a settlement procedure. Next, settlement amount is going to be credited to the Consolidated Fund of India, excluding the disgorgement amount and the legal cost. Right? What is the disgorgement amount? I have already told you. Whatever unlawful profit has been made, that amount is not going to go to consolidated fund. And also legal cost, whatever cost has been incurred in fighting that case, that can also be ordered by the court. So that these two amounts are not sent to consolidated fund. Penalty is sent to consolidated fund, settlement amount is going to be sent to the consolidated fund. And realized under this act shall be credited to the consolidated fund of India all the settlement amounts. Right, so that is what they are saying, that all the settlement amount, all the penalties, all the money that is going to be collected by SEBI, it has to be credited to the consolidated fund of India. Two amounts they are excluding, disgorgement amount and legal cost. Legal cost is given to the party who has borne that legal cost, and the disgorgement amount is not retained by SEBI. We will see where we are going to deposit that. Now, so this is the credit of sums. Penalties, whichever is going to be collected by SEBI, that all that amount is going to go to the consolidated fund of India. All the settlement amount that we are going to collect, that is going to go to the consolidated fund of India. The disgorgement amount, okay, the disgorgement amount that is there, that we are going to transfer to the investor and education, to the Investor Protection and Education Fund of India, and that money is going to be utilized for creating investor awareness, for holding training programs. For that we are going to utilize it. Legal cost is going to be given to the parties, to whoever it has been awarded by the authorities. So what? The penalty is going to be going to the consolidated fund of India. Settlement fees is going to go to the consolidated fund of India. Your disgorgement amount is going to go to the Investor Education and Protection Fund of India, and the legal cost is going to go to the respective parties who have spent that particular amount. These are the things that you should keep in mind. Next, case snippets illustrative for the settlement proceedings. Various cases where settlement was entered into. The latest being the case of Infosys under the PIT regulations. Settlement of insider trading violations. I have made an exclusive video, a detailed analysis of this settlement proceeding case by Infosys. You can have a look at that particular case. You have one more case, JM Financial Limited 2020. Here the former vice president settled a case for insider trading by paying a settlement fees of 15 lakh rupees. The investigation had revealed that there was unauthorized off-the-market trades that were taking place during the closed trading windows. Okay, so these are certain cases where the settlement agreement was entered into between SEBI and the alleged offenders for violation of SEBI provisions. One more case, Kapshi Commercials Limited. Shareholders settled an alleged violation takeover norms by paying 34 lakh rupees for delayed disclosure requirements under the SAST regulations. So, under SAST regulations, whenever certain acquisitions are there, certain percentage of shares are acquired, they are required to make certain disclosure requirements. Here the shareholders had failed to make that disclosure requirement. They made a delayed disclosure. If it had to be made within a certain period of 30 days, they made it after 90 days. So, that delay period was there. For that, they settled the case by paying a fees of 34 lakh rupees. Next, Northward Financial Planners, again 2020, the firm settled the allegation for non-compliance with investment advisors regulations by paying a fees of 21.67 lakhs. After operating without registration for over 4 years. So, they were investment advisors who did not obtain SEBI registration, but still they were functioning as investment advisors for 4 years, and they did not comply with the code of conduct for investment advisors and investment advisors regulations. That is why they settled the case by paying 21.67 lakhs. Next. So, what has happened? Case is initiated, investigation is done, adjudicating officer has imposed the penalty, all that is done. If you want, you have settled the case. Now, next question is, penalty has been imposed, whether it is 5 lakhs, whether it is 20 lakhs, whether it is 5 crores, 10 crores, 25 crores. How will SEBI ensure that money that has been imposed as penalty is recovered by the SEBI officials? You have imposed a penalty, but that order should be implemented, right? You should collect that penalty amount from the wrongdoers. How are you going to ensure? So the first step is, it is for the wrongdoers to actually come and submit within the given duration of time. So if we are imposing huge penalties, we don't say that give it tomorrow. We'll give them a certain duration of time. Within this time, you have to deposit the penalty amount with the SEBI officials. This is what is the order that is going to be given. Now, if within that duration also the wrongdoers or offenders do not submit the penalty amount, how are we going to recover that penalty back from the wrongdoers is the question. And that is why SEBI Act has clearly already made arrangements for all these possibilities, that at any point in time, if any person fails to submit any amount, any penalty amount, any disgorgement amount back to SEBI authorities, how are we going to recover that amount from them? We have a clear section 28A which talks about recovery of funds. They say, if any person fails to pay any penalty, fails to comply with SEBI directions for any kind of refund, fails to comply with the disgorgement order, fails to pay any fees that is due to SEBI, because intermediaries are also required to pay annual fees for renewal, right? If they fail to pay the fees, the recovery officer can then take action for recovering the amount that is due towards the Securities Exchange Board of India. So initially you have investigating officers, you have adjudicating officers, now we have recovery officers. If you don't pay the amount, recovery officers are there to take it from you. How are they going to take it from you? There are various modes in which they can take the money from you. They can attach your movable property. You have bike, you have car, right? They can attach those, they can sell it, whatever amount comes, they can use that towards the payment of amount due to SEBI. They can attach the bank accounts. In your bank balance, some amount will be there. You have multiple bank accounts. In all your bank accounts, some amount will be there. They will attach your bank account and direct the bank to transfer those money to the bank account of the Securities and Exchange Board of India. Then you have attachment and sale of person's immovable property. Immovable property also can be attached. That is nothing but your house, building, land, okay, anything that you have that can be attached, sold, and the money can be recovered. Arrest the person and his detention in prison. You don't have any of the above, or any of the above is not sufficient to clear the amount that is due. Last resort is we are going to arrest that person, keep him in the prison, make him do the work, and whatever amount is there you can recover. Next is appointing a receiver for the management of the person's movable and immovable properties. So, you are going to attach the properties, movable property, bank account, immovable property. How are you going to manage? At what price are you going to dispose of? At what amount you are going to receive? How you are going to clear the loan? So, for that you are going to appoint a receiver who is going to manage the entire properties and ensure that maximum amount is going to be recovered by SEBI towards the clearing of any fund money that is due to the Securities Exchange Board of India. What is the recovery procedure? So, we have seen recovery officer is appointed in case any amount is due and that person is not paying back to SEBI. We know what are the modes in which recovery can be done. Now, we will see the procedure. Again, the modes of recovery is one common topic that the institute asks under this particular chapter. Now, let's see the procedure. The recovery officer creates a certificate specifying what is the exact amount that is due, which has the priority over other claims against the individual. They can also seek the help of local administrative assistance to enforce recovery action. So, they can take the help as may be required to recover the amount that has been specified in the certificate by SEBI, that this amount is due from so and so person, please recover that particular sum. Now, recovery procedure, most important thing. See, now I know I have to pay, let's assume 1 crore rupees to the Securities and Exchange Board of India. Now, what have they said? They have said that they can attach my movable property, they can attach my immovable property, they can attach my bank accounts. What if I transfer all my assets in the name of my wife, my husband, my children, my immediate relatives? My immovable property is 0. My movable property is 0. My bank account balance 0. I don't have anything. I've transferred everything that I have to my near and dear ones. Then how are the officers going to recover? So, the law has clearly said that you are smart, but we are smarter than you. We have made a provision that if you transfer your properties to the near and dear ones without taking money from them, without having an adequate consideration, we are going to believe that you have transferred it to them only for avoiding the refund back or recovery to the SEBI officials, and we are going to consider that whatever you have transferred, even it is in the name of some other person, we will continue to believe that it is your property and we will go ahead and attach it. So what are they saying? They are saying that a person's movable, immovable property amount held in the bank account includes any money that has been transferred directly or indirectly without an advocate consideration is going to continue to be treated as the account balance property of the wrongdoer himself. So even if you try to cheat by transferring your properties to other people without taking adequate consideration for them, we will treat that it is your property in whosever name it is going to be attached. So they have made that provision as well. Next, continuation of proceedings, again one important topic, section 28B. What do they say? They say that I am the wrongdoer. A case has been filed against me. Okay. Now I die. What is going to happen to the case? From whom are they going to recover the disgorgement amount? From whom are they going to recover the penalty? In whose name are they going to continue the case? Because I myself am not there. I am dead. In whose name will the SEBI authorities continue that particular case? How will they recover the amount? Right? For that, they have clear-cut made the provisions as continuation of proceedings, and it is the legal representatives who will be held responsible in case such cases going on. Right? So here two things you should keep in mind. One is the case has already started. If the case has already started, we can later continue it in the name of legal representatives. Second one, the case has not yet been started. SEBI only had an eye on you. They had to still file a case. Case has not been filed. In that case, later on, the legal representative's name itself, we can start the case for the wrongful activity of the whoever he represents as legal representative, right? So this is the continuation of proceedings, where they say that if the wrongdoer dies or the person against whom we have alleged offence, that person dies, we can still continue the case in the name of the legal representatives. If the case also is not filed, we can still start a fresh new case directly in the name of legal representative itself. Why is that? Why have we made these provisions? Because ultimately, whatever wrongful gains are there, that person is not taking with him anywhere else. He is leaving in his bank account, he is leaving in the form of some property. Who is going to get that property? Legal representatives are only going to get those properties, right? Somebody dies, all that property is going to go to the somebody, no, some family member, some nominee, whoever has been mentioned, it is going to go to them, right? So we can recover it from them, because they will not get it if their ancestors or whoever has done the wrongful activity, if they did not do the wrongful activity, they would not have the money. If they would not have the money, they would not leave it and go once they died. So that money is anyways not entitled to be given to the legal representative. It is a wrongful money that they are holding. So we can still recover it from those legal representatives. But there is one condition that you should keep in mind, which I will tell once we are doing the further discussion. So let's see continuation of proceedings. When a person dies, his legal representatives shall be liable to pay any sum which deceased would be liable to pay if he had not died in the same manner to the same extent as the deceased. There is this person who is the wrongdoer and there is a legal representative. We are going to put the legal representative in the shoe of the deceased person. We are going to assume this person itself is the wrongdoer and recover every amount that is due to SEBI that would have been paid by this person. Now it has to be paid by the legal representative. So the extent of liability is same. Whatever this person had to pay earlier, today he is not there, you pay it for us. That is continuation of proceedings. Now, in case of a penalty, so now I am talking about various funds. You know, there is disgorgement amount, you know there is settlement fees, you know there are other amounts that can be recovered. All that amount can be recovered through legal representatives, but one amount, that is the penalty. cannot be recovered from the legal representatives. Let's see. In case any penalty payable under this act, a legal representative shall be liable only in the case the penalty has already been imposed before the death of that deceased person. What are they saying? Only with respect to the amount due in the form of penalty. They are going to divide it into two situations. One is the penalty has already been imposed before the death of the person. In that case, it can be recovered from the legal representatives. If the penalty has not been imposed, the case is still going on, the final outcome is not there, the penalty is not imposed yet. In that case, we cannot collect it from the legal representatives because penalty can be imposed for a wrongful activity on the wrongdoer. We cannot collect it from anybody else. So, only in case of penalty, if it is imposed prior to death, we can collect it from legal representatives because that order was passed in the name of that person itself, the wrongdoer. You just have to recover the money from legal representative. Here we are talking about imposing the penalty. Penalty can be imposed only on the wrongdoer. The wrongdoer has already died. You cannot impose penalty on a legal representative. So, if the penalty has not been decided before death, the penalty cannot be imposed. If the penalty has already been imposed on the wrongdoer, but before paying the penalty he has died, you can recover it from the legal representatives. I hope this distinction is clear. Please make a note, penalty cannot be imposed on a legal representative. If it has already been imposed on the wrongdoer before his death, it can be recovered from the legal representative after his death. But if it is not imposed at all, you cannot recover also from the legal representatives. Next, that was with respect to penalty. Now talking about the disgorgement amount, the refund amount or any other money that is due for recovery before the recovery officer, and the case has already been filed before the death of the person. Case has been filed. While the person was alive, the case has been initiated. We can continue the case in the name of the legal representative. What are they saying? That person is there. Okay, this is the wrongdoer. We have already filed the case. The case is going on. And in between some stage, this particular wrongdoer dies. From this stage itself, we are going to include the legal representative to the case. For whatever stage, at whatever stage the case has stopped due to the death of the wrongdoer, from same stage, we are going to include the name of legal representative and continue the case further. That is what this particular provision talks about. Next provision is, there is this wrongdoer. Okay, SEBI is having a watch on this person, but he is not filed a case. He is under the view of SEBI. Basically, they are doing inquiry, just seeing, inspection, basic work they are doing. They have not started any case against him. Okay, this person dies. Case is only not there. No case is filed. Only is under the purview. He is under the vigilance. He is under the surveillance. But he dies. What can we do? We can still start the case in the name of the legal representatives. So, whether the person is alive, case is filed, then you continue in the name of legal representative, or case itself is not filed, but still you can start the case in the name of legal representative. Both the provisions are provided for under the SEBI Act. Now, the next question is the extent of liability. Extent of liability. Now, you are a legal representative. You will not get the entire property, right? There might be multiple other people who will have a claim over that money. So, to what extent the legal representative will be liable? Let's assume the amount that is due to be paid to the Securities Exchange Board of India, the amount that has to be recovered is 25 crore rupees, right? I, as a legal representative, have received close to 7 crore rupees from the property of the deceased, of the person who has died. I have got only 7 crores from his estate, from his properties, from his bank balance, whatever, collectively out of the person's wrongdoer's money, I have got only my share, that is 7 crore rupees. Now, when I am called for as a legal representative in a case, to what extent should I be held liable? Should I be liable for full 25 crore rupees? That is, I've got 7 crores from him, I'm ready to pay that. Out of that, whatever remaining balance is there, should I pay it out of my pocket, my hard-earned money? I'm not even the wrongdoer. I'm not even the wrongdoer. I've not done anything. I'm not even involved in that activity. Should I pay out of my pocket, out of my hard-earned money? The answer is no. They say that any legal representative, his liability is only going to be limited to what extent? Limited to that extent of the estate that he recovers from the property of the deceased person. How much you have got from the wrongdoer's property, to that extent only we will hold you liable. You do not have to pay out of your pockets. Let's see. Every legal representative shall be personally liable to any sum payable by him in his capacity as a legal representative if, while his liability for such sum remains undischarged, he creates a charge on or disposes of any part with any assets of the estate of the deceased which are in or may come into the possession, but such liability will be limited only to the value of the assets so charged, disposed of or parted with, right? So, you had got a property and you have sold it off. That amount is in your name after selling the property. At what value did you sell the property? That they are going to determine, and that much liability you will be held responsible for. So, to tell in simple terms, they are only saying that how much value has been derived by the legal representative from the property of the deceased person, only to that extent we will personally hold him responsible. Beyond that, his personal money we will not touch. How much estate he is inherited from the wrongdoer, only to that extent he will be held responsible. So, we have limited liability. How much he got from wrongdoer, to that extent he will pay back to SEBI. Beyond that, we will not ask him to pay from his own pocket money. Next, the liability of the legal representative is limited to the extent to which estate or deceased is capable of meeting the liability. How much he has got, only to that extent he will pay back. He will not pay his personal property. Next, coming to the provisions of Securities Appellate Tribunal. What do we mean? We mean that the lowest decision-making authority under the SEBI provisions is the adjudicating officer. Now, somebody is not happy with the adjudicating officer's decision, right? That person can file an appeal that this is the order passed by adjudicating officer. I am not happy with the decision, so I am going to appeal before the Securities Appellate Tribunal. It is an appellate authority. If you are still not happy with the decision, Securities Appellate Tribunal has passed a decision. If you are still not happy with the decision, you have a right to appeal before the further courts, that is Supreme Court, right? So, let us see the provisions of the Securities Appellate Tribunal. They say that the establishment is provided, central government has the power to establish one tribunal which is going to be called as the Securities Appellate Tribunal to exercise jurisdiction and powers which is conferred under this particular thing, and in the notification they are going to specify what is the jurisdiction that is going to be exercised, for which area which tribunal will be held responsible, how many Security Appellate Tribunals are required to be set up in the entire country. All that decision is going to be made by the central government. Now, composition, you are going to have one presiding officer, you are also going to have certain judicial members and technical members. So, composition is judicial member, technical member and a presiding officer. Now, appeal before the Securities Appellate Tribunal, when and how. Key provisions are provided under 15T and 15U. Any person who is not happy or who is aggrieved by the orders of SEBI, who is aggrieved by the orders of the adjudicating officer, who is aggrieved by the orders of the IRDA, who is aggrieved by the orders of the PFRDA, All this comes under the jurisdiction of the Securities Appellate Tribunal itself. So if you're not happy with SEBI orders, IRDA orders, PFRDA orders and the orders of the adjudicating officer itself, you can file an appeal before the Securities Appellate Tribunal, and a maximum duration of 45 days is provided to you. Once you receive the copy of any one of these authorities, you will have 45 days time to file an appeal. You can prefer an appeal against their orders. In the appropriate form it should be, and along with the appropriate fees, you should submit the application for appeal. Late filing is permitted. If within 45 days you are not able to file an appeal for various reasons, during that time itself you are not well, somebody is hospitalized, your advocates are not available, some sufficient cause, some valid reason is there for you to not file the appeal within the 45 days period. If sufficient cause is shown, you give an appropriate valid reason for not filing it within 45 days period, they will allow you a further extension as may be required based on the facts of each of these cases. Timeline for disposal. Maximum 6 months time is given to the Securities Appellate Tribunal to hear the case and give the final judgment. Beyond 6 months they cannot go. Now, what are they going to do? What are the options available with the Securities Appellate Tribunal? One is they are going to say whatever the adjudicating officer has said is correct. We are agreeing to it. We are going to confirm whatever has been told by the adjudicating officer or any other authority. Whatever adjudicating officer has said is wrong. What are we going to do? We are going to set it aside. We are going to change the decision, setting aside the decision of adjudicating officer. In the first case, adjudicating officer has said that yes, it was insider trading. Securities Appellate Tribunal will say no, there is not a case of insider trading, right? Total opposite decision, that is setting aside the decision of lower authorities. Or adjudicating officer has made a decision, the Securities Appellate Tribunal agrees to the decision that yes, there is insider trading, but the amount of penalty you have imposed is not right. We are changing the penalty, we are changing the directions, we are changing the guidelines. So only basic modification is going to be made to the decision. Either you agree completely to the decision of adjudicating officer, you totally reverse the decision of adjudicating officer, or you only make a modification to the decision that has been given by the lower authorities. So yes, after hearing both the parties, the Securities Appellate Tribunal has three options to confirm to the order whatever lower authorities have given is correct. You modify, you only make certain changes to the decision that he has made. And lastly, set aside the original order, you completely reverse the decision. If he is held guilty, you will say he is not guilty. If the adjudicating officer says he is not guilty, you will say he is guilty. Total opposite order is setting aside the original order. A copy of the Securities Appellate Tribunal's final order is required to be sent to the lower authorities against whose decision the appeal has been preferred. So if the appeal is from the order of adjudicating officer, a copy should go to the adjudicating officer. If the appeal is from the order of IRDA, a copy should go to the IRDA. If a appeal is from the PFRDA, you should go to the PFRDA. So whosever order has been appealed against, the final order of the Appellate Tribunal should be sent even to those lower authorities. Next, appeal procedure. Again, we are not seeing the detailed procedure, we are just overlooking the appeal provisions. Again, like I said, appeal is made by the way of an application with the appropriate fees. That application is going to be called as Memorandum of Appeal. It should be presented by the aggrieved person before the Securities Appellate Tribunal within the jurisdiction, depending upon which is the area you are living, where is the offence, which Appellate Tribunal has jurisdiction over your area. Before that Appellate Tribunal, you are required to file an application. It is going to enter in the registry the case or appeal memorandum that has been required. In the memorandum, what are the things that you should provide? You should concisely include the distinct headings. What is the ground of appeal? Without giving the arguments and narrative, you only should specify what is the reason of appeal. Don't go into the details. Give clearly what is the ground for appeal, and it should be clearly printed form, neatly legible and numbered consequently. So basically nothing but your appeal format should be specific, it should be concise, it should be limited, means you do not have to give detailed explanations, you don't have to argue in your appeal letter or application of appeal. You just have to specify what is the reason why we are appealing. You just have to mention the grounds. You don't have to go into the detailed arguments in the appeal application itself. Next, procedure. Again, like the adjudicating officers, even the appellate tribunal is not bound by the civil procedure code. You're not bound by the Indian Evidence Act. What they have to do is they just have to follow the basic principles of natural justice. That is, hear both the parties, give them opportunity of being heard, and only after that pass the necessary orders. So they are not bound by the procedure of the civil procedure code. Next. Similar to what we saw for SEBI, what we saw for the adjudicating officers, even Securities Appellate Tribunal is a quasi-judicial authority. So they will need a certain powers to conduct the hearings and give the final judgment and order, and that is why whatever powers are vested with the civil courts under the civil procedure code, same powers are also vested with the Securities Appellate Tribunal. We have already discussed this, like summoning the people and calling them before the authorities, checking their attendance and taking the examination under oath, requiring the discovery of documents and production of documents before the authorities, receiving the evidence under the affidavits, issuing commissions for the purpose of collecting evidence, witness and documents, reviewing its own decision, dismissing an application for default or deciding an ex parte. What is ex parte? Means even after multiple reminders, we are calling you to appear before us, but you are not coming and giving the appearance itself. We are going to pass an order without hearing you, because we gave you multiple opportunities of coming and appearing before us. You yourself are not appearing before us. So on the basis of what one party says, we are going to pass the order, ex parte order. Without hearing, we are giving an order because you yourself are not coming. We have summoned you n number of times. We have tried all the possible ways of issuing the summon. You are not appearing before us. That is not our fault. So we will pass an ex parte order. Setting aside an order of dismissal or an application for default of any order passed by it ex parte, any other matter which may be prescribed. So these are certain powers that are given to the Securities Appellate Tribunal so that they can hear the case and finally pass a judgment of the case. Next. At any point in time, if there are two members, one judicial member, one technical member, both of them are not agreeing to the same thing. One person says he is guilty, one person says he is not guilty. One person says there is a violation, one person says there is no violation. In that case, what judgment will you give? Because the judges who are listening to the case, the people who are hearing the matter, both of them are itself not agreeing to each other. In that case, what are we going to do? Whenever there are even number and there is a problem, we are going to refer that case to the presiding officer, and then they will become 3 members. Then we are going to take the vote. Whichever majority decision comes, that is going to be the decision. Next, legal representatives and appeal procedure. Now, whether it is before the adjudicating officer or the Securities Appellate Tribunal, does the member have to go himself, the wrongdoer has to represent himself, or the company has to represent? You have opportunity that you can appoint any professional to appear on your behalf, and the Securities Appellate Tribunal has recognized the following category of people who can appear on behalf of their clients, that is chartered accountant, company secretaries, cost accountant, legal practitioners, or any of its officers. Any one of these people can represent the case before the Securities Appellate Tribunal. It is not necessary that only advocates should appear before them. Like we have in the regular courts, only advocates can appear, whether it is criminal court or civil court. Advocates who are on roll of bar association, only they can appear before the regular courts. But here they have allowed legal representative by even other professionals like chartered accountant, company secretaries, cost accountants, legal practitioners, nothing but advocates, and any of its officers, right? Legal team will be there, inbound legal officers will be there. They can also appear before the Securities Appellate Tribunal. Limitation and jurisdiction. Again, you are going to have the limitation period applicable for appeals. Whatever duration is given, 45 days, 60 days, 90 days period, within that duration itself, appeal is required to be filed. If sufficient cause is shown, we will extend the duration, but beyond that, we will not allow any kind of Last is the appeal to the Supreme Court. You're not happy with the lower authorities, you can prefer an appeal to the Appellate Tribunal. If you're not happy with the Appellate Tribunal, you can prefer an appeal to the Supreme Court. And again, the duration is going to be specified. You have a duration of 60 days within which you can file an appeal before the Supreme Court. From the date of the order of the Securities Appellate Tribunal, the day you get it, from that day you will have 60 days time to prefer an appeal before the Supreme Court. But the only important thing you should keep in mind is every case is not appealable before the Supreme Court. It should be a question of law that is there. So there are two questions, two type of appeals. One is question of fact. Another one is the question of law. What is question of fact? Question of fact is, did Mr. A pay B? This itself is the dispute, whether A has paid any money to B or not. That is a fact which has to be verified. Whether A has paid the money to B is a question, but that is based on the facts of the case. This has nothing to do with the Supreme Court. When will Supreme Court involve itself? It will involve itself when there is a question of law. What is a question of law? Like you saw the question with relation to adjudicating officer, whether the provisions of section 15 are taking over the powers of the adjudicating officer. What does insider trading mean? What is the interpretation of insider trading? When you want to interpret one section, when you want to bring about the meaning of a particular law, provision, subsection, rules, regulation, only then when there is a need for interpreting the provisions of law, when there is a dispute with respect to interpretation of the law itself, only then we call it as a question of law, and only then the Supreme Court is going to involve itself. For small mere questions of fact, the highest court of the land will not waste its time, right? So they clearly say that only those cases are appealable before Supreme Court where there is any question of law that is going to arise. Wherever there is a dispute with respect to interpreting the provisions, only then the Supreme Court is going to involve itself, or else no appeal lies before the Supreme Court. For any reasons, if you are not able to file the appeal within 60 days period, a further 60-day period is going to be allowed only if you show a sufficient cause why you are not able to submit the appeal within the given reasonable period of 60 days. Next, bar on jurisdiction. Again, what does it say? It says that when for securities market related provisions, you already have an adjudicating officer created by the Securities Exchange Board of India. You already have the Securities Appellate Tribunal established exclusively for hearing the cases in the securities market, insurance market and provident fund market. And appeal is appealable before the Supreme Court. When exclusive jurisdiction is already created, why should we allow the regular civil courts to entertain these kind of cases? So by that they clearly impose a bar on jurisdiction, where they say that apart from these specialized tribunals that have been created, no other regular civil courts are allowed to entertain any court in relation to any of the SEBI provisions, right? That is what it means, bar on jurisdiction. Injunction prohibition is also the same thing. No courts can impose any injunctions for any matter that is specifically provided for in relation to the Securities Appellate Tribunal or SEBI provisions. Punishment for contravention. If anybody contravenes the provisions of any of the Act, rules, regulations, imprisonment up to 10 years, fine up to 25 crore rupees, and or both imprisonment and fine. Okay, it's either imprisonment or fine, or both imprisonment and fine. So this is if you are violating the provisions of the SEBI Act itself. Then there is the penalty provisions. Next, if you fail to pay the penalty, right? If any person fails to pay the penalty that is imposed by the SEBI or adjudicating officer, or it fails to comply with the directions which is issued by SEBI or adjudicating officer, imprisonment for minimum of 1 month up to 10 years, or fine up to 25 crore rupees, or both imprisonment and fine, right? So this is if you fail to pay the penalty, we are going to do this. Even after this you don't do, then we are going to recover the amount. Next is compounding of offence. What does the mean compounding? Compounding means settling the matter, right? There is a difference between settlement proceedings and compounding. Let's have a look at it. any offence which is punishable under this act not being an offence punishable with imprisonment only or with imprisonment and also with fine may before and after the institution of any proceeding be compounded by the Securities Appellate Tribunal or the court before which such proceedings are pending. Right? We are going to compound the offence. Which kind of offence can be compounded? Any offence can be compounded where imprisonment is not there. Imprisonment as a factor is not there. If the provisions or the punishment is only imprisonment, this kind of case is not eligible for compounding. If the punishment is imprisonment plus fine, in that case also the compounding of offence will not be permitted. If the case is only fine, then you can go ahead for compounding. If it is fine or imprisonment, even in that case it can be compounded. Where the element of imprisonment is mandatory, it is only imprisonment or it is imprisonment and a fine. Where imprisonment is mandatory, those kind of cases cannot be compounded. Only the case in which imprisonment is an option or only fine is there, only those kind of cases can be compounded. Next is cognizance of offence. What is cognizance? Cognizance means making a note or taking a case into action. You get a complaint, you are recording that and taking the case into consideration. Cognizance of an offence, taking note of a commission of a crime. Who can do so? Right? The court shall not take cognizance of any offence which is punishable under this act or any rules and regulations except unless a complaint is made by SEBI. So they are clearly saying that no case can be initiated until and unless a complaint is received either by SEBI or any other person makes a complaint or gives an information that yes, this is wrongful activity, please register a complaint. So complaint is mandatory to initiate a case under the provisions of SEBI Act. Establishment of special courts. We already have the Securities Appellate Tribunal exclusively constituted only to handle the disputes arising out of the securities laws. Now, why do we need one more category of courts called as the special courts? It's only for certain category of cases that can be heard by special courts, and it is only for speedy disposal of cases, right? We'll see the provisions. What is the purpose of establishing a special court? It is only for ensuring speedy trials of offences under the Act. Please remember, all kind of cases cannot be heard by special courts. Only certain category of cases are pushed to special courts. All other cases are still heard by the adjudicating officers and the Securities Appellate Tribunal itself. Only specific list is there. Those kind of cases can be heard by the special court for speedy disposal of cases. What is the composition of the special court? We saw under composition of Securities Appellate Tribunal, you have a presiding officer, technical member, judicial member. Under the special court's composition, you have a single judge. Only one judge is going to hear that case. And who is that judge? That judge should be appointed by the central government, and the central government should consult with the Chief Justice of the High Court before appointing that particular judge. Right? So you are going to have special courts and one judge only is going to be there. That judge is going to be appointed by the central government in consultation with the Chief Justice of the High Court, in whose jurisdiction you want to set up that special court. Qualification, that single judge who is going to sit, how are we going to determine who is that single judge? He should be already serving as a sessions judge or an additional sessions judge prior to his appointment to the special court. So the designation is he should be a sessions court. Sessions judge or additional sessions judge. Offences which are triable by the special court. What are the cases that can be heard by the special courts? Again, all offences under the relevant act are cognizable and triable by a special court. The special court is designated for the area where they handle offences occurred, will handle the particular case. In which area the offences occurred, according to the jurisdiction they are going to hear the cases. If multiple special courts are created in the same area, then it is the High Court who are going to distribute the business and tell which one of the special court is going to handle a particular matter. Now, appeal and revision. If you have to appeal against the order of the special court, where will the appeal lie? The appeal lie before the High Court, because we have said that the special court is going to have one single judge, and that single judge should be a sessions judge or additional sessions judge. And if you see where sessions judge sit, they sit in the sessions court, okay, and appeal from the session court lie before the High Court. So they have given the special court same designation as that of the sessions court, so automatically appeal from the special court will also go to the High Court. What have they done? They've equated the special court to the sessions court. From the sessions court, appeal go to the High Court. That is why even the appeal from the special court will go to the High Court itself. So the High Court has the authority to exercise the powers of appeal and revision in relation to the matters as provided in relation to the special sessions court, right? They're equated to each other. Application of the code, they are talking about the application of the Criminal Procedure Code. Now the Criminal Procedure Code has been repealed. Instead of Criminal Procedure Code, we have the Bharatiya Nagarik Suraksha Sanhita 2023. The procedures provided under that act will be applicable to the special courts. Till now, for Securities Appellate Tribunal or to the adjudicating officers, none of the procedural laws were applicable. But here it is a special court, and actually judges of the regular courts are only sitting in the special courts. So again, we are going to treat it as a judicial authority, and the provisions of the regular codes, that is procedural codes, whether it is CPC, whether it is CRPC, now the BNSS, will become applicable. Transitory provisions they have given, again we can skip this, not very relevant. Next, contravention by companies, right? So we have identified the procedural requirement, how appeal, appellate provisions, special courts, all that is done. Now if you are an individual person, okay, we are going to file a case against you, you are the wrongdoer, you will be held responsible. But when any contravention, when any wrongful activity is done in the name of an entity, it is a listed company, it is proposed to be listed company, or the intermediary itself is registered as a company. In that case, who will be held responsible? Who should pay the penalty? Who should go to the jail? Right? Because there is imprisonment factor also, there is penalty also, there is fine also. Who is going to pay that? Should it be paid in the name of the company? Should it be paid by the key managerial personnel? Should it be paid by the directors? Who will be responsible for a wrongful activity of a company is what we are going to question. They say very clearly that whoever is responsible, because company is an artificial person created by law, right? It does not have a mind. It is the people who are running that particular artificial person. To run the artificial person, you ultimately need a human mind. So whichever human mind is responsible for the non-compliance, whichever human mind is responsible for the contravention of the provisions of law, that person should be held responsible. So they say that whenever there is a contravention of any of the provisions of the SEBI Act, rules, regulations, and there is any contravention that has been committed in the name of the company, every person who at the time of that contravention was actually committed and was responsible in discharging the function, he will be held responsible as the person who will be liable for that contravention, as well as the company also. So it is not only in the name of the company that we are going to file a case, but every person who was responsible for that particular action, whoever was responsible for taking that particular decision, whoever was involved in that wrongful activity, each one of them will be held responsible for the contravention and will be liable for punishment also, because they are the ones who are creating it, planning it, they are the ones who are executing it, so they will be also held responsible. Next question is exemption and defense. Now, whenever you are talking about a company form of organization, it is not one person who is making the decision. There is not one person who is involved. It is a teamwork. A lot of people come together, create one team and execute. There is a legal department, finance department, secretarial department. Each one of these departments are different. Now, there might be a possibility that within one team there are 10 members. 9 people are involved in that wrongful activity, but they know that that one person, if he gets to know, he will become a whistleblower. He is very ethical, he is very diligent, he is an honest man, he has a lot of integrity. If we tell him, he'll definitely blow the whistle, he will not let us also make the profits. So those 9 people secretly, without telling the 10th team member, are executing a particular wrongful activity. Should we hold that person who belongs to the team responsible, or should we exempt him? He's not even involved, he does not even know what is happening within his team. It's a secret from him, they have not told him only. Should we hold him responsible? The answer is no. So that is why whenever one person is held responsible because it was his duty, he was also responsible for that particular task, but he did not know at all about it. He did not know only, the other team members didn't let him know about it itself. He can be given an exemption, but he should prove before the court that I had no knowledge about this wrongful activity. My team members didn't tell me anything. They kept it a secret from me. I had no knowledge about it at all. If he is able to prove it, he will not be held responsible. That is the first situation. Second situation is the 10th person, the team members did not tell him because he is an honest man. They knew that he will not agree to that wrongful contravention. They didn't tell him, but from somewhere he gets an idea that these people are doing a wrongful activity. What will he do? He will try to tell them, don't do it. He will try to stop it. He will exercise all the powers that he has. He will try to stop that activity, all due diligence, everything, whatever is in his capacity, he has done it to stop that wrongful activity. But still the other 9 people are powerful than he is. So he is not able to stop it, but he is not also a part of that wrongful activity. He knows about it, but he did not help them in anything, right? So in that case, he should prove that he tried his best to prevent it from happening. He had the knowledge about it, but he did not help it. He also stopped them from doing it, but he could not do so because he did not have that level of powers. So in these two situations, where he did not have a knowledge at all, and where he had the knowledge, he tried to stop it, but he couldn't stop it. In these two cases, that honest man can get an exemption from being held liable for the wrongful activity of the company. So let's see, they say that this provision of holding every person responsible will not become applicable if such person is able to prove that the offence was committed without his knowledge, or that he had exercised all the due diligence, he had tried to prevent the contravention or commission of that offence. He tried his best to stop it, but he could not do so, or he did not know only that wrongful activity is taking place. If he is able to prove this clearly to the courts, he will not be held responsible, and all other people who are responsible will be held liable as well. Next, extended liability. So you know there are teams, higher end managers. You have managers, directors, vice presidents. These are the people who will be targeted because they are the decision makers. But the law says we should go beyond. Right from a small clerk to accountant, a lot of people may be involved in this contravention. Each and every employee of the company who will be involved in the contravention will be held responsible and will be guilty for the contravention. Whatever is your role, if you are helped in the contravention, you will be held responsible. So extended liability to each and every person who is abated, who has helped in the commission of that wrongful activity, will be guilty and will be held responsible as well. Next. So that is all about the SEBI Act, right? So till now we were studying SEBI Act of 1992. Lesson number 4 for the new syllabus students, lesson number 2 for the old syllabus students. Now the new syllabus students, you can continue referring to lesson number 4 because it is a part of lesson number 4. If you are belonging to the old syllabus, please you can change your material to lesson number 14 because we are going to continue now discussing the dispute resolution mechanisms. Two concepts are there, scores mechanism and informal guidance scheme. That is what we are going to discuss. So let's begin with the scores mechanism. Scores, all is capital, S-C-O-R-E-S. What does this mean? It means SEBI, S stands for SEBI, C and O stands for complaint, R and E stands for redressal, S stands for system. SEBI complaint redressal system, scores mechanism. Okay, this is established by SEBI to solve the complaint of the investors. Let us see what are these provisions. Again, like I told you, there is no act for this. There are no guidelines, there are no regulations, because this has been established by the way of a circular which is issued by the Securities and Exchange Board of India. But from where did SEBI get the power to issue this circular? We are going to see the purpose. We know SEBI had main purpose protecting the interest of investors. They will be protected only when all their problems are addressed to. To address that problem, they need a mechanism, they need a platform where they can get a solution to their problems, and that is when SEBI decided that let's establish this mechanism called as a scores mechanism, where any investor, if he has any problem, any complaint, they can file it before us, before this particular mechanism. So what is it? It is an online platform. Everything is online. Online complaint system for designed to help investors to lodge their complaints pertaining to the securities market online with the SEBI. So what are they saying? It is a complaint filing platform. It is online platform. They can file complaint only and only exclusively related to any problem in relation to the securities market. They can file this complaint before the Securities and Exchange Board of India, but against whom? They can file it against any listed company. They can file the complaint against any SEBI registered intermediaries. They can file it against any recognized market infrastructure institutions. So these are the three categories of institutions or organizations against whom individual investors can file a complaint before the Securities and Exchange Board of India on this online platform. Launch, when was this entire system established? June 2011. It was established to facilitate grievance redressal for unsolved complaints. So it is a complaint redressal mechanism where if anybody has any complaint that is not answered to, any complaint that is not resolved, any complaint that is not addressed to, it can be filed over this particular platform. Next, purpose. Purpose of establishing, it is to provide platform for the aggrieved investors whose grievances pertaining to the securities market remain unresolved by the concerned company or the intermediary after a direct approach. Very, very, very important point. After a direct approach, what are they saying? They are saying that you are an investor, right? You are an investor. You have a problem. You have a problem. What are you going to do? You have a problem with a listed company, let's assume. You have to first go and contact that listed company. You have to go and contact that listed company, tell them what is your problem, and wait for certain days for them to reply. What is the possible solutions? One possible solution is listed company is going to reply, but you are not happy with the solution that is given. That means your problem is not solved. You got a reply from the company, but your problem is not solved. Second is, the listed company is going to reply, okay, and you are very happy also with the decision. That means your problem is solved. There is a third possibility, that the listed company has not given any kind of response. No reply at all. In that case, again your problem is unsolved. It's unresolved, right? So these are the three possible solutions, three possible situations that can happen in a given case. You are an investor, you have a problem, you have filed your complaint with the listed company which is creating the problem for you. There are three possible scenarios. You get a reply, you are not happy with the reply, your problem is not solved. You get a reply, you are happy with the reply, the entire solution is received, so the problem is ended here. There is no further course of action that is required. Or you do not get a reply at all from the listed company. Even in this case, your complaint is not solved. You do not have a problem to the solution. You do not have a solution to the problem that you have. In that case, what are we going to do? In these two cases where your problem is not solved, what are we going to do? We are going to contact the scores mechanism. What are they saying? This investor can directly contact the scores mechanism if it has first done a direct approach. first you should contact the person who is giving you the problem. If you don't get a solution, then you come to the scores mechanism. Directly, if you come to the scores mechanism, what is the point? Maybe if you would have gone to the listed company, they would have given you the problem. So what are they saying? Scores mechanism will become helpful only after the direct approach has been taken. You have contacted the person who is giving you the problem. If he does not give you a reply, he gives you a bad response, then you create a complaint on the scores mechanism. Because in the scores mechanism, we do not have judges who are sitting. We do not have anybody who is going to listen to your complaint and give a solution. It is only an online platform for directing complaints. What is scores platform? You have a scores platform. This platform is online. What do? They only channelize the complaint. There is an investor. He has filed a complaint before the scores mechanism, okay, on the online platform. What does this online platform do? The same complaint, it is going to forward it to the listed company, registered intermediary or the institutions. They say that this is one investor who has filed a complaint against you. You have to give a reply. You have to give a reply to that complaint, and that reply is further forwarded to the investor. Why do we do this? Why do we do this? If a regular investor, small individual person is going and contacted the listed company, he's like, oh, one small investor, what will he do? Why should we take his complaint seriously? You don't take it seriously. But similarly, if you get a notice in the name of Securities Exchange Board of India, oh, we have received a complaint from SEBI, we should immediately act on it. We are answerable to SEBI. They will take it more seriously when a regulatory authority is going to be involved. That is why they've established this system. Nobody is hearing the matter here. Nobody is solving the problem for you from the SEBI's department. They are only creating a platform to channelize the complaint to the listed companies, registered intermediaries or the market institutions. It is only a channel. Ultimately, the solution is still going to be given by the problem maker itself, but it is only going to be routed through the SEBI platform. SEBI officials are not involved in the complaint redressal system. They are only giving you a system, they are giving you a mechanism, they are going to give you a procedure through which the listed companies will listen to your complaint, because once a complaint is filed through a scores mechanism, timelines are there. Within a specific time, they have to give a reply to the complaint that has been forwarded by SEBI. They are answerable to the Securities Exchange Board of India. That is why this makes it more structured, more answerable, more formal, and it is taken much more seriously than just receiving a complaint from a regular small investor. So that is what it is. They say that it is a mechanism through which we can file a complaint before the SEBI authorities, where they are going to take only those complaints which are not resolved after the direct approach. First is direct approach. If you have not done the direct approach, SEBI will not forward the complaint. First you finish the direct approach, then we will take the case into consideration. What is the platform? Again, it is the same thing. It is just overseen by SEBI. See, again I am telling you, SEBI is not giving a solution to your complaints. They are not solving your problem. They are only directing, they are overseeing that you receive a solution. Their objective is that the investor should have a solution to his problem. They are only giving a setup, they are only providing you a market, or they are going to provide you a place through which you can channelize your complaint directly. That's all. They are only overseeing by SEBI, through which the investors can approach the concerned listed entity, registered intermediaries, for getting speedy redressal for their grievance in the securities market. It is the same thing that I have told. Now, what are the features of the scores mechanism? It has a centralized database. That means the entire complaint that is received throughout the country, everything is created and saved in a single central database. Online movement. All the transactions, all the complaints are received online. Those complaints are forwarded to the respective person against whom there is a problem online. There is no physical movement of papers. Everything is absolutely online. Action taken report. As soon as a listed company gets a complaint, it is going to have a strict timeline. Within that timeline, it has to reply back about what action they have taken for the complaint that has been received, how they have given a solution to the investor for the complaint that he has raised. That report also has to be uploaded by the person against whom a complaint has been filed on the SEBI platform, and immediately as soon as that action taken report is submitted, the investor will get a notification that your problem has been solved. This is the action that is being taken by the listed company for the problem that you are seeing. 24/7 access, it is an online platform. Whenever you want, you can file a complaint. It is not that it is a government office 10 to 6, your office also 10 to 6. When are you going to file a complaint? No. At the comfort of your house, at the convenient time, whether it is midnight, early in the morning, whenever you want, you can access the website and file a complaint. Immediate acknowledgement, like as you place orders, okay, whether it is your instant Swiggy orders, Amazon parcel, or whatever you're booking, or you're creating an email account, you're opening an Instagram account, immediately you get an acknowledgement, right? So similarly, immediately you will get a unique identification number. That number you should keep with yourself to track further what is the status of your complaint. Accessibility, again, it is accessible anywhere at any point in time because it is online. Unique complaint registration number, for every complaint a new registration number, like a complaint number is going to be released, and that complaint number can be used for further tracking whether what is the status, whether complaint has been forwarded, action taken report has been uploaded. Just to track what is the status, you can use that identification number. Online process, the entire procedure is online, right from you filing a complaint to the complaint being forwarded for the uploading of action taken report, you getting the ultimate solution. Entire procedure is online, no manual documentation, nothing, everything is electronic. So no paper involvement, everything is an electronic online procedure. Next, coming to the complaint submission process. So we have understood the features, we have understood how the scores mechanism works. Now let us see what is the procedure as such. First, direct complaints, I have already told you, direct approach. The person who is giving you the problem, you should go to him for the solution. If you go randomly anywhere, you will not get a solution, right? So first contact the person who is giving you the problem. Maybe the problem will be solved instantly. You do not even have to go to the higher levels or hierarchy of the chain. You don't have to go. So that is what they say, that the investors can submit their complaints first directly to the listed companies or the registered intermediaries and wait for the solution for 30 days without the intervention of SEBI. Give 30 days time for them to give a reply. If within 30 days you don't get a reply, or you get a reply but you are not happy with the reply, in that case only in that case you can approach the scores mechanism. If it is unresolved, then the complaint can be registered on the scores mechanism for the intervention of SEBI. This is the direct approach, direct complaint. Mandatorily, the investors have to first take up their grievance through the listed entity or the people or the compliance officer for solving their problem. In case the entity considered fails to reply, you have not got a reply at all, or gives a reply but you are not happy with that particular reply, only then investors will be permitted to file a complaint on the scores mechanism. I have already explained this in detail, so it is the same, similar to what I have told. Now, what is the procedure? They are taking you through the registration procedure. First, you have to visit the website www.scores.government.in. It is a government website. You have to click on register here and first create your investor profile. After creating the investor profile, then you can file a complaint. Complete the registration form by giving basic details. What is your name? What is your PAN number? What are your contact details, email ID, Aadhaar card and KYC procedure. After that, your profile will be created. Once your profile is created, then you will be permitted to give the complaint details. Ensure that all the information is accurate for effective and quick grievance redressal. Once you have created your profile, you can get a user ID and password on your email ID. Okay, on your email ID you will get. Then you can receive an acknowledgement towards the email containing the credentials of what is the user ID and password. As soon as your profile is created, you will get an email that you have registered on scores mechanism, your profile is created and your credential, your user ID is so and so, your password is so and so. Using this user ID and password, you can log into your profile. After you log into your profile, you can start filing a complaint. So you should log into the scores portal using your user ID and password. Then you should go to navigating the complaint section and fill out the details about your grievance against which company you have a problem, whether you have against the registered intermediary, which registered intermediary, what are the details, what are the documents that you have to prove that this is the complaint, that you are the shareholder. Basic documents, it will allow you to attach documents. It will have a space to type your problem and give all the details. Click on the submit button. As soon as you click on the submit button, complaint registration number will be received. It is a unique registration number. You should keep a track of that number for the purpose of tracking the complaint. What is the status of your complaint, you can identify. Timeline. Complaints must be lodged within 1 year of the cause of action. For 5-year-old problem, today you cannot ask. The timeline is there. If you have a problem for say 2-3 months back, something had happened, today you can file a complaint. 6-7 months back, something had happened, today you can file a complaint. 12 months back, something had happened, you can file a complaint. 13th month, something had happened, you cannot file a complaint today. Maximum period is 12 months. Within 1 year, if something has happened, for that you can file a complaint. Beyond older problems, SEBI will not take into consideration. After approaching the entity for redressal, if the complaint is rejected, if there is no communication, or if a dissatisfactory response is received, same thing that I am telling. You have not got a reply, you can approach scores. You have got a reply, you are not happy with the reply, you can file on scores. If you have filed a complaint, you have got a reply, you are happy with the reply, there is no need for approaching the scores mechanism. Rejection of complaints. SEBI can also reject the complaints which are older than 1 year and it has not been addressed as such. Now, one-time review option. This is a new concept that has been added by the way of amendment to the circular, where they say that one-time review option should be given. Right? Instead of directly going to the scores mechanism, will give you a review process. The complainants who are not satisfied with the reply which is given by the companies or the registered intermediaries, they can apply for review of their solution within 15 days of the closure, and the complaints will be escalated to SEBI's supervising officers. So, even after the direct approach, why directly go to the scores mechanism? If you are not happy with the solution, give the company one more chance. No, apply for a review that we are not happy with the decision that you have given, we are not happy with the solution that you have given, please reconsider. Okay, that can be done. That is one-time review option. Exclusion from scores. Now, what are those kind of complaints which scores mechanism will not at all accept? What complaints will not be taken into consideration by the scores mechanism? First, complaints against the companies which are unlisted, which are delisted, which are placed on the dissemination board of the stock exchange. It is not a listed entity. It does not come under the ambit of SEBI regulations. It was a listed company, but now it is delisted. Again, does not come under the ambit of SEBI regulations. Dissemination board of stock exchange does not exist as on today. So, any one of these categories are not under the regulatory ambit of Securities Exchange Board of India. So, any complaints with respect to those companies does not come under the jurisdiction of SEBI authorities. So, we are not going to take into any complaint against unlisted companies, against delisted companies, and against any companies which were earlier placed on the dissemination board. Next, any complaint which is filed against a sick company where a moratorium order has been passed, or it has been to the insolvency proceedings or winding up proceedings, in that case also we will not accept any complaints. If a complaint is in the name of a company and that company has already been struck off the register of companies, that company is not in existence at all, we will not accept any complaints. If it is declared to be a vanishing company, the company which is not traceable, you are not able to identify the promoters, you are not able to identify directors, you are not able to trace to any of the key managerial personnels, we call those companies as vanishing companies. And if it is published by MCA that this company is a vanishing company, no complaint against such vanishing companies are going to be addressed by the scores mechanism. Any complaints which are suspended or under liquidation, BIRF, etc. If it is under liquidation, under bankruptcy, insolvency, we will not consider those kind of complaints. Any complaint falling under the purview of any other category of bodies like RBI, IRDA, PFRDA, CCI, etc., or any other purview or any other ministries, etc., we are not going to consider. When we saw the powers of Securities Appellate Tribunal, that tribunal has a wider jurisdiction. It is also looking into insurance sector, PF sector, securities market. It is looking into these sectors. But when you talk about scores mechanism, it is exclusively only for SEBI, any other ministry, any other sector, scores mechanism is not the right platform. It is exclusively only and only for Securities Exchange, Board of India problems, and only those problems which belong to under the jurisdiction of SEBI, only those kind of complaints are going to be accepted. So, if it is a complaint from IRDA, PFRDA investors, we are not going to take it into consideration. Next, any complaints that are sub judice or relating to any case which is under consideration by the courts of law or quasi-judicial proceedings. Any matter for which already a case is going on before adjudicating officer, Securities Appellate Tribunal or any other court for that matter, special courts for that matter, we will not take that into consideration, right? If already case is going on, they'll give you the judgment. Wait, no, you don't have to file a complaint on the scores mechanism. So, these are the kind of cases which are not going to be addressed under the scores mechanism. Next is scores authentication. What is scores authentication? It is nothing but, I told you the format or structure, right? This is the platform. There is this investor. He files a complaint. The complaint is forwarded to the listed company, registered intermediary or whoever is there, right? This is the system, this is the structure. Now, what happens is when this particular person is filing his complaint, the form or the online platform is such that it is going to ask what is the details, what is the complaint, against whom you have a problem, whether it is a listed company, registered intermediary or any other person. If you select listed company, it will give you a drop down, okay. From that drop down, you will have the name of all the listed companies. You have to select one of the listed companies with whom you have a problem. Let's assume ABC Limited. That name is going to appear. For that name to appear here, that listed company should have created its profile on the scores platform. Like we investors are creating our investor profile, similarly like that the listed company registered intermediaries are required to create their profile on the scores platform so that their name can reflect in the drop down and the investors can select that particular name. This is scores authentication. Every listed company, every registered intermediary is mandatorily required to obtain the scores authentication so that their name appears in the complaint form, right? So, for all those listed companies and registered intermediaries which were registered much earlier, even before the scores mechanism came in 2011, they did not have any such provision. So, after scores mechanism was launched, they were given a specific timeline. Within this time, please get your scores authentication done. They had to get it done. But now, the companies which are yet to be listed, the companies today which are planning to be listed, they don't give them the listing unless they finish the scores mechanism authentication. Right? So, you got it. If it is an old company, we have given them a specific time within which they should finish the scores authentication. If it is a new company which is now going to become a listed company, we will not allow you to make the initial public offer until you have finished the scores authentication. First do the scores authentication, then we will give you the permission to make the IPO. So, this scores authentication has become a part of the process of making a public issue. This itself is scores authentication. They say that the procedure for generation of scores user ID and password is fully automated and all new SEBI registered intermediaries, market institutions who get registered on or after 2019 have to get it at the time of registration itself, right? At the beginning, at the time of making a public issue, at the time of providing a certificate of registration for registered intermediaries, right at that time they should obtain the authentication in case they want to make a public issue, in case they want to get the certificate of registration. First they should do the scores authentication, then they will get the certificate, then they will get the permission of making a public issue. Scores user ID and password details shall be sent to auto-generated emails to the email ID of the compliance officer after the completion of the entire procedure. Stockbrokers, depository participants are not required to obtain the scores authentication because for stockbrokers, stock exchange is there as the master, and for the depository participants, depository is there as the master. I have explained all this concept in lesson number 1. Right? So, there is a stockbroker, he is the agent, he has a master, stock exchange. So, the stock exchange is answerable So the stockbroker need not obtain the authentication. Similarly, in the depository and depository participant, the depository participant is the agent, depository is the master. So the master is going to be held responsible. The depository participant need not get the scores authentication. If any problem is there with respect to stock exchange or depository participant, the complainant will contact the stock exchange or the depository as may be required. Next. Companies intending to list their securities on the SEBI recognized stock exchange, they have to mandatorily get the scores authentication done. It is an online form, can be accessed from the website. They have to no, it is a green initiative mechanism. That is why we say it is an online mechanism. Everything, credential, etc., everything is going to be provided through emails itself. It is a green procedure. That means no involvement of paper at all. Now, compliance responsibility. Who is going to be responsible for giving a reply to upload the action taken report? Who will be held responsible is the question. So, they say the companies intending to list their securities on SEBI recognized stock exchange, they have to have in-house or through a register to an share transfer agent. Right? So, either you can have a separate department, in-house department, which is going to process these complaints, or you can delegate this authority to the registrar and share transfer agent who are one of the intermediaries. Either you yourself do it or you outsource this activity to the registrar and share transfer agents. In case the complaints are processed by the registrar to an issue and share transfer agents on behalf of the listed company, any failure on part of the share transfer agents to redress the complaint or failure to upload the action taken report will be treated as the failure of the listed company itself. What are they telling? They are giving two options. Whether it is listed company or registered intermediaries, you have two options. You have your own system that you yourself, your employee itself are going to reply to all the complaints that are going to be filed, or you can outsource this work of giving a reply and giving an action taken report to the registrar and share transfer agent. Now, if you are not replying, you will be held responsible. If you are not uploading the action taken report, you will be held responsible. But when you have outsourced the activity to the registrar to an issue and share transfer agent and they fail to upload the information, they fail to answer the problem, in that case also it is the company which is going to be held responsible and not the outsourced agency. You should ensure that the registrar to an issue and the share transfer agents are working properly. The company will be held responsible even if the share transfer agents or the registrar to an issue is not going to upload the action taken report. Now, coming to handling of complaints by stock exchange against listed companies. Like I told you, directly all the complaints are not going to go on the scores mechanism. It is going through the scores mechanism, but certain kind of complaints can be raised before the stock exchange. Stock exchange is going to be the first point of contact for certain problems, and they are going to give the problems against the listed companies. Since 2020, stock exchanges are serving as the first recourse for any kind of complaints against listed companies. So, instead of directly going, you can also contact the stock exchange where the company is listed for any kind of problem that you are facing in relation to the thing. Stock exchange can manage various type of investor complaints, including but not limited to. All complaints are not addressed by the stock exchange. We have a list of complaints which can be directly contacted through the stock exchange. Non-updation of information. You don't have the address, signature, change or correctness. You want to update the information but they are not updating that information for you. In that case, you can contact the stock exchange. Financial entitlements. You have to get bonus issue, you have to get bonus shares, you have to get dividend, you have to get a duplicate share certificate, you had applied for share transfer. All these things you have applied for but you have not got any one of these. You can contact the stock exchange saying that the listed company had to give me bonus share but I have not got it. I am contacting them, they are not giving me. You can contact the stock exchange. Delay in the payment. Dividend should be paid within 30 days. You have not got the dividend even after 30 days. You can contact the stock exchange. Non-receipt of interest for debentures. Non-receipt of interest for delayed redemption procedures. Non-receipt of interest or delayed refunds. Non-receipt of interest on security. So, any amount that is due to you, if you don't get that within that specified time limit, you can contact the stock exchange. securities transaction, non-receipt of rights issue form, non-receipt of securities after various corporate actions, non-receipt of shares after transfer, transmission, public issue, rights issue. If you don't get your shares that are due to you, you can contact the stock exchange. Miscellaneous issues, receipt of refund, dividend, physical mode, receipt of shares in physical mode instead of electronic mode, complaints relating to dematerialization, rematerialization of shares, or any other complaints as may be specified. All these category of complaints can be directly filed before the stock exchange. Now, in the year 2023, we have got an updated version of the circular where they have made certain amendments to the original scores mechanism which was launched in the year 2011. It is a significant longer duration of time. They had initially just started. Now they have established well settled mechanism. Now they are seeing how we can further improve the already existing system. What are the things that we can bring about more efficiency, more faster and quicker resolutions. That is why they have updated and revised the original scores mechanism in which they have changed the timelines. Okay. Earlier within 21 days they had to give, now within 15 days they have to give a reply. Let's see. Why are they modifying or bringing a revised structure? It is to strengthen the grievance redressal system. It is enhanced procedures for complaint handling and resolution. They want to make it a very strong redressal mechanism. That is why they are bringing about changes to improvise it further, to make it much better than what it was in 2011. We are bringing about these changes. Next, auto-routing and escalation. Instead of involving somebody in between, it is better that we have somebody that is auto, instead of involving any person in between. Auto routing and escalation systems are incorporated. So, we have advanced the technology that is involved in this entire scores setup. Timeline for resolution, earlier it was 21 calendar days. Now, they have reduced this further to 15 days. Okay, we will see that further as well. Monitoring by designated bodies. So, complaints are simultaneously sent to the relevant designated bodies for overseeing and support of the redressal process. Though it has been routed through the scores mechanism, under the scores mechanism also you have a designated body which is going to oversee this entire mechanism. First review process. Earlier, we did not have the first review option. Now, we have the first review process where if you are not happy with the first answer, you are not satisfied with the answer, you can apply for a review, you can apply for a re-reply, you can ask for one more reply, one more solution. That is permitted. Now, responsibilities of the designated bodies, that is the stock exchange and the depositories. What is their response? Because for any stockbroker, stock exchange is responsible. For any depository participant, depository is responsible. What is the role of these designated bodies? What are they going to do and how they are going to take forward the grievance redressal mechanism? So, huge responsibilities now put upon the designated bodies who are going to oversee the scores mechanism. First one, monitoring and handling of all the processes. They should ensure that all the problems are resolved within the given timeline. Taking non-enforcement actions. If any complaint is not resolved even on the scores mechanism, the listed companies are not replying, the registered intermediaries are not giving the answer within the timeline, they can take action for not giving a solution on the scores platform. Framework for handling investor grievance via the scores mechanism itself. How are we going to do so? First one, submission of complaint and handling of the complaint by the entity, that is the direct approach. Complaint receipt, all entities are going to receive complaint through the scores mechanism. They are going to have 21 calendar days to give a reply. Automatic forward of complaint, I have already explained you the system. Automatically, as soon as in the drop down you select the name of the company's email ID and compliance officer's details is there. Automatically to that company's email address and the scores platform or profile, they will get an update, a new complaint has been filed against you. They can automatically see it. The action taken report submission, they are going to have 21 days time to submit the action taken report and give a reply to the problem that has been filed. As soon as the action taken report is taken, a notification is going to be given that this particular problem has been solved, and the designated bodies will also get to know about it. The investor will also get to know if he enters the complaint number that I have got an action taken report. Now I can see what is the solution that is provided to my complaint. Designated bodies oversight, they are going to monitor whether the answer is proper, whether action taken report is properly being updated, whether grievance has been addressed or not. SEBI's role, here SEBI has no role to play. It is only going to monitor and provide that platform to ensure that the grievance has been redressed in effective and efficient manner within a short duration of time. They are not going to sit and look into the matter themselves. They are only going to provide a platform where this mechanism or system can take place. First review of the complaint, the same thing I told you, it is a newer concept which has been brought by way of amendment. If a complainant is satisfied with the action taken report, the complaint is disposed of. But if he is not happy with the complaint that is being given even by the way of action taken report, they can file for a review within 15 calendar days of the submission of action taken report. So you gave a direct approach. From direct approach you were not happy, that is why we went to the scores mechanism. In the scores mechanism you got the action taken report. In this you are happy with the action taken report and no problem. But if you are not happy even with the solution given on the scores mechanism, you can apply for one-time first review and see whether what is the further reply that you are going to get. Designated body's role. If a review is requested after the action taken report and it is not submitted, then the designated body is going to get involved itself. The entity is then required to submit a new action taken report within the stipulated time period. So you have to give a second action taken report if the investor is not happy with your first action taken report. Clarification. The designated body has full authority to question and seek the clarification on the action taken report from the entity and the registered intermediaries within a specific timeline, and they have to give a reply within 10 calendar days to the review. Second review of the complaint. Requesting for a second review. If the complainant can seek a second review within 15 days from the action taken report submission by the designated body. If a complainant is not satisfied with it, the designated body fails to submit the ATR within 10 days, SEBI will then further intervene and a case can be initiated because you are not getting a solution to your problem via the scores mechanism. SEBI can then consult with the stakeholders and require immediate action to be taken involving the listed entity or body considered, with the revised action taken report to be submitted within a specific timeline. But again, even with the SEBI's intervention, if no problem, no this thing is there, you can file a case. But if you are happy with the second action taken report or a intervention of SEBI, you are going to finally dispose of the complaint. And if you are not at all happy with the complaint, you can file a case. If you are happy with the complaint and no review is selected or no appeal is filed, in the sense, again you are not asking for first review, second review, we are going to assume that you are happy with the solution and we are going to close the complaint. Action for failure to redress the investor grievance. That is what, if you are not happy ultimately even with the first review option, second review option, intervention of SEBI, from any of the action taken reports, you are not happy with the solution that is given, then in that case, the designated stock exchange will impose a fine of 1,000 per day per complaint on the listed companies that violate the LODR regulation. That is, if the companies or the listed companies or the intermediaries fail to upload the action taken report within the given timeline, then it is going to have a problem because penalty is going to be imposed for every day of failure where you are not replying to the action taken report. Escalation. If the company fails to comply, the designated stock exchange will notify the promoters requiring the action taken report to be submitted and payment of fine within 10 days. Even after imposing of the fine, if the company is not uploading the action taken report, we will intimate the promoters of the company that, see, your department, legal department, we have sent this action taken report requirement, but your company is not giving us a solution. You, being the promoter of the company, tell them to do some work. Tell them to submit the action taken report. We are going to directly tell the promoters of the company that please submit the action taken report. Non-compliance may lead to freezing of the promoter shareholding and their demat account. Even after telling the promoters the company is not uploading action taken report, in that case the authorities have the power to freeze the promoter's demat account and they have the power to take the demat account of the shareholders into their custody. Then the promoters will become serious. Oh, we have to look into this, let us solve this matter. So that to that level scores mechanism they want to establish. If the company continues to fail to resolve any complaint, they may take any additional action as may be required. Next, applicable complaint categories. What are the complaints that can be filed? So the procedure applies specifically to the following complaints: address signature updates, non-receipt of dividend, bonus, etc., issue related to dematerialization, rematerialization, or any other specified complaints. These are the things against which you can file a complaint upon the scores mechanism. General provisions for investor grievance redressal. Initial approach, the same thing. First, you have to directly concern the person with whom you have a problem, get a solution. If they give a solution, well and good. If they don't give a solution, contact the scores mechanism. If they give a solution but you're not happy with the solution, contact the scores mechanism. That is the initial approach. Then lodging of the complaint on the scores mechanism. I've already told you what is the procedure. Go onto the website, create your profile, and then file a complaint using the. Again, it is the 1 year period. Within 1 year only you can file a complaint. A complaint that is older than 1 year will not be addressed on the scores mechanism. Limitations: any complaint beyond 1 year period can be rejected by SEBI scores mechanism even if it is not answered by the listed company. Complaints that are not handled against, it is the same thing that we have already covered: unlisted company and delisted companies, companies which are all case which is already pending before the quasi judicial authorities, issues which is pending before other regulatory authorities like IRDA, PFRDA, RBI, we are not going to consider. Companies for which are under liquidation, insolvency, bankruptcy, company that has been struck off or is a vanishing company, liquidated companies, or market intelligence related complaints, we are not going to take into consideration. It is something that will not come under the ambit of the scores mechanism. SEBI's role: SEBI is only going to manage the first review complaint for the intermediaries without a designated body. For the second review, designated body is going to come into picture. If you are not happy with the action taken report, you have to give a complaint must provide reasons for their dissatisfaction at any stage. So the complainant should say why you are not happy with the action taken report, what are you expecting out of this complaint, what is the solution that you want, that has to be specified. Facilitative nature of scores: it provides a platform only for redressal of the grievance. It is not adjudication. This is the most important thing. We are only giving you a platform. We are not giving a solution. Solution is given by the listed company or registered intermediary itself. We are only facilitating the solution. We are not giving the solution. We are not adjudicating the dispute. We are only giving you a platform where your complaint is going to be addressed. Further remedies: okay, if at any point you are not happy at all with first review, second review, any action taken report, you have the adjudication procedure, legal procedure. You can go about by filing a case for getting whatever solution you want. Implementation date: with effect from 1st April 2024, we are going to have the new master circular, that is the 2023 scores mechanism, that is the first review, second review, all that will become applicable from 1st April. The new amended version of the scores platform is going to be provided. Next, coming to SEBI mobile application for scores mechanism. Till now, whatever we saw, we dealt with through the website of SEBI. Now, everything has migrated. SEBI has also launched a mobile application, that is the scores mobile application, where what you can do on the website, same thing you can also do via your mobile phones by installing the necessary app. The same thing. It is launched on 5th March 2020. It's only to increase the convenience and accessibility for the people that mobile application is more user friendly. Ease of access: acknowledgement can be received easily, complaint can be tracked easily. Whatever you can do on website, same thing you can do via the mobile app also, right? So the same thing, for that reason they have launched the mobile application. Helpline is there. If you are not able to file a complaint, if there is any problem with the score system itself, technical issue, you can contact the helpline numbers. They will help you in filing the complaint. Availability: it is available on both Android and iOS platforms, whether it is an iPhone, Apple phone or Android phones. On both you can download your mobile application. So that is all about the scores mechanism. Now let's get into the new and the last topic for discussion, that is the SEBI Informal Guidance Scheme of 2003. Informal Guidance of 2003. So what is informal? Informal, something that is off the record. Informal is something that is not formal in nature. Some conversation that is beyond the professional ambit. Something that you're getting just to help you out. Okay. So that is informal, something that is not in professional capacity. Now, why does SEBI need to give informal guidance, right? So there are a lot of times, firstly, SEBI expects 100% compliance. SEBI expects that whether it is the listed company, whether it is the intermediary, whether it is the acquirer, whether it is the investors, everybody should be within the ambit of the SEBI rules and regulations. But imagine a situation where the laws are not clear. You are not knowing how to interpret the provisions of the law. You don't know how to read a regulation that has been issued. You don't know the meaning of the circular. You don't know what is the guideline that has been given, whether that particular circular is applicable to your organization or not applicable to your organization. You have problem in interpreting the provisions of law, sections, regulations, circulars, notifications, directions, or anything for that matter. If you have a problem in interpreting these documents, how will you comply with it? Right? So SEBI thought that when people have a problem in interpreting the provisions of law, we can help them out. If not in formal capacity, if not in capacity as the Securities Exchange Board of India, we can create a separate department, an informal department which can give solution to the questions of the investors, to the question of the listed entities. People who are not knowing what to do in a given scenario, we can give them a possible answer in our informal capacity, outside the regulatory framework, outside the ambit of us being a Securities Exchange Board of India. We can help them understand the laws better. So that will also increase the level of compliance within the market. With that purpose, they have launched this informal guidance scheme where SEBI has created a department which is going to help the people in the securities market whenever they have any kind of problem, whenever they have any kind of interpretational issues. Okay, let us see. It is to facilitate a better regulation and orderly development of the securities market by allowing specific parties to seek informal guidance from SEBI. When people have interpretational problems, they cannot comply with the law. When they don't know what is the, how will they comply? So to help them do 100% compliance, you should make them understand what is the law. If they have problem in understanding the law, if they come to you, you can explain to them what is the law. So that is what they are saying, that we want to provide a setup where if they have a problem, if they have something that is not understood by them, they can ask us. Okay, that is the purpose with which they have launched this SEBI informal guidance. Now, who can make use of this informal guidance? Every person is not allowed to directly contact the informal guidance scheme. No, only if you are somewhere related to the securities market. You are the registered intermediary with SEBI. You have code of conduct that has to be followed. You have application procedure for registration. You have disclosure requirements to make. You have obligations to fulfill. You have responsibilities to fulfill. If you have any problem in identifying any one of this, interpreting any one of this, you can contact the informal guidance. You are a listed company. N number of regulations are there that are applicable to listed companies. If you are not understanding it, you can contact the informal guidance. You are a company proposing to get listed. You have submitted your draft prospectus with SEBI, but in the process of making a public issue, you are having a problem in interpreting some kind of provisions of law. You can contact the SEBI informal guidance scheme. Mutual fund trustee company, asset management companies, or the acquirers under SEBI SCST regulations. Only these 5 category of people are permitted to make use of the informal guidance facility that is provided by the Securities and Exchange Board of India. Next. What are the types of guidance that are given by the informal guidance scheme? They talk about 2 guidance. One is the interpretive letter. Second one is no action letter. One is the interpretive letter. Second one is the no action letter. What is the no action letter? No action letter tells that, let's assume you are a company. You are in one particular situation. You want to execute, let's say, rights issue. While interpreting the provisions of rights issue, you have some problem. Okay, you say that we are planning to do so and so like this. This is the thing. This is the plan of action. We are going to execute the rights issue like this. You give them the full plan and ask them, if we do like this, will some action be taken against us? Have we done any kind of non-compliance in the plan that we have given? If we follow this, will some action be taken against us? Action will be taken if there is non-compliance. If whatever you have planned for, whatever action you are taking, whatever you are implementing, if that is full correct, it is 100% compliant, SEBI will issue a no action letter saying that please go ahead with whatever you are planning. SEBI will not take action against you because it is 100% compliant. No action letter, SEBI is giving a no action letter that in future SEBI will not take any action against you if you execute this particular deal, if you execute this particular transaction. Acquirer is there, he wants to acquire one company, he's planning, this is how I'm going to do the acquisition. He can ask SEBI, can I go ahead with this acquisition? If I do this acquisition, will SEBI take some action against me? If SEBI takes some action, they will not issue a no action letter. If they think that it is in compliance, there is no problem, they will issue a no action letter. So that is to get a verification whether what we are doing is correct or not correct. Second kind is interpretive letter. Like I told you, if you don't understand one section, you don't understand one regulation, you can ask them, I have this interpretational problem, these are the facts of my case, this is my company, I am involved in so and so business, this is the instant situation, how do I apply this law to this facts of my case? That interpretation you can get by the way of a interpretive letter. So there are two types of guidance, no action letter and interpretive letter. Under the no action letter, SEBI indicates whether it would recommend enforcement of action based on a described transaction. And SEBI provides interpretations for specific legal provisions concerning the proposed transaction. Random interpretation they will not give. Interpretation of a section or a provision in relation to your company's situation, facts of the case, they are going to help you. Right, the same thing I put it in the table format. No action letter and interpretive letters will be in relation to acts, rules, regulation, guidelines, circular or any other legal provisions which comes directly under the SEBI provisions. If you have any doubt in relation to Companies Act, they will not solve it. They will solve only something that directly comes under the ambit of the Securities Exchange Board of India. Some law that has been passed by SEBI, SEBI Act, SCRA, ICDR, LODR, PIT, SAST, Mutual Fund, CIC. With respect to any of this, if you have any problem, only those kind of complaints, only those kind of informal guidance they are going to address. What happens in no action letter? There is a separate department of SEBI. They are going to give you recommendation whether or not SEBI is going to take any action against your plan of action or not. It is based on the proposed transaction as per the request application. So based on the facts, they are going to give whether action is taken or action is not taken. Here we are going to interpret the provision, specific provision. You should specify, I have a doubt in section 15A, I have a doubt in regulation number 6, subregulation 1. So clearly you should mention what is the problem that you have in interpretation, which regulation, subregulation you are not able to analyze. So they are going to, on the basis of the factual situation, interpret that particular section, regulation, rule and give you the answer about what they mean by that particular provision of law. Now, issuance of no action letter, that is where a no action letter is issued by the department affirmatively. That means they are issuing the no action letter. That means that the department will not recommend enforcement of any action to SEBI subject to any other provisions of the scheme. That means everything is proper. There is no any enforcement action to be taken against the organization. Now, how do you make an application for informal guidance? Like any other thing, you should need to submit a form, application form. In that application form, you should clearly tell that it is an application under the scheme of 2003. Second one, you should say whether you are asking for a no action letter or an interpretive letter. What do you want? Which type of guidance you want? Whether you want a no action letter or interpretive letter. That also should be clearly mentioned in the letter, in the application itself. It should be accompanied by the fees of 25,000 rupees. It should be addressed to the concerned department of the Securities Exchange Board of India. And your application is going to be in the form of a letter. There is no fixed format. Like we have various forms, no, you don't have a form. You can write it in the form of a letter to the appropriate authority. The subject should be clear that you want whether a no action letter or an interpretive letter for whatever provisions. That should be the subject line. And it should say that we are seeking for no action letter under the informal guidance scheme. We are seeking the interpretive letter under informal guidance scheme. So that should be the subject matter of your letter, where clearly you are indicating it is under the scheme and you are asking for one of the guidance from the Securities Exchange Board of India. In the letter, you should clearly specify what is your request, what is that you are looking for. You should clearly analyze the facts and circumstances involved. You should tell them what are the facts of your company, what are you doing, why are you seeking this interpretation, what is your doubt. That should be clearly mentioned, and you should mention all the applicable legal provisions. What all doubt you have with proper regulation number, section number, you should mention. Randomly if you say, I have a doubt in ICDR regulations. ICDR regulation is huge, very, very long. What doubt will they clarify? You say under ICDR regulation, regulation 6, sub-regulation 1 is where I have a doubt. So, proper provision number should be mentioned if you want a clarification from the SEBI under the informal guidance. Now, once the complaint or once the application or the request for informal guidance is submitted, that is going to be received by the department of SEBI. What is SEBI going to do? SEBI should dispose of the request as early as possible. There is no timeline as such. They say within a maximum of 60 days of receiving the request, you should give a reply. But again, every request is not accepted. They don't have to reply to all. Only if they think it is relevant, it is justified, it is valid, then they are going to reply. They are not under an obligation to reply to every request. They are going to have a separate department. That department is going to sit together, give a hearing, conduct the interview of the person who has a problem, and then discuss internally and come up with the reply. That reply also is going to be documented, and that document is going to be sent back to the person who has requested for that particular informal guidance. Here they are only going to receive the reply. Whatever discussions took place internally within the department, that will not be mentioned. Ultimately, what they think is the reply interpretation, that they are going to specify in this thing. Internal records will be confidential for SEBI. Only what is the final reply after the discussion, that is going to be mentioned in the letter, and that letter is going to be sent to the person who is seeking the informal guidance. Now, request submission. When you are submitting this request for informal guidance, you can request the authorities that please keep this confidential, because there is one obligation that as soon as SEBI gets a informal guidance request, that request is uploaded on the SEBI website. When a reply is given to that informal guidance, the reply is also uploaded on the SEBI website. So, if you just log in into SEBI website and see for the guidance notes, you can actually see various requests that are submitted and also the replies that are given by the authorities. It is so easy to access everything. So, if you don't want your request to be put out in the public domain, you can request for confidentiality. You can request for confidentiality, saying that please keep my request confidential. Don't put out this in the public domain, right? So, we will see the provisions with respect to that. The request must clearly state the nature of inquiry, whether it is for no action or interpretive letter. It should be accompanied by the fees. It should have all material facts, and SEBI aims to respond within 60 days. That is the request submission. I have already discussed it. SEBI, like I told you, is not responsible for answering to all the kind of requests. These are the kind of requests will automatically be rejected merely because it is very general, does not provide complete and sufficient details, does not give factual situation on the basis of which what will SEBI reply. You have not given full details itself. SEBI has not understood your question only. How will they reply? Involves hypothetical situation. It is a situation that you have created. It is not in actual situation. You are assuming if this happens, if that happens, how will I do it? No, if you want to do it, how will you do it? If that is the question, they will answer. If you are imagining something and creating a situation for yourself, they are not going to reply to such hypothetical situations. Again, a very important topic which is time again asked by the institute. The requester has no direct and proximate interest. I am some random person. I am asking about applicability of some provision of law for ABC Limited. I am a third party, no way related to that situation. They will not reply. If you are directly interested in that factual situation, they are going to give a reply. Applicable legal provisions are not cited. You have said that I have a doubt of LODR regulations. Under LODR regulation, what is your doubt? That you have to specify. No action or interpretive letter has already been issued for the same matter, same topic, same doubt with similar facts, then they will not repeat it. You have to keep a check on what all action letters have been issued, interpretive letters are issued. You please see, keep a track of what is happening in the market, see what SEBI is directing. Something that has already been done for same fact, same doubt, how many times will they reply? They will not reply for multiple queries on the same topic. investigation, inquiry or other enforcement action has already been initiated. For the doubt that you are asking, already some cases pending against your company for the same interpretational provisions. We will not address it. Connected issues are pending before any tribunal or courts. The policy concern requires that the department does not respond. Okay, so one of these reasons exists, then SEBI is directly going to reject. That means they are not going to reply to these kind of requests. Next, request for informal guidance. If it is going to be rejected, what is going to happen to the 25,000 rupees that you have submitted? You have not even got a guidance. They didn't even reply to your informal guidance request. Then what is going to happen to the money? They will refund the money, but they will not refund the entire money. Out of 25,000, they are going to deduct 5,000. This 5,000 is the processing fees. They will go through, the letter and see whether it is worthy enough of giving a reply. To process, to reach that stage, many people are going to be involved. That is the processing fees. Whatever is the remaining balance, that is 20,000 rupees. This 20,000 rupees will be refunded. 5,000 rupees will be deducted as processing fees. Refund of 20,000 rupees will be given back in case you don't get a reply for your informal guidance request or if your application is rejected. Okay. So, if the request of application is not in compliance with the requirement that the content is not there, fees is not proper, description is not proper, or if for any of the grounds where we thought it is hypothetical situation, you are not related to the situation, you have not given the proper provisions of law with respect to what you have a doubt, any one of the points that we saw before, if it is falling under any one of those grounds, the fees that is paid by the requester will be refunded. That is total fees, amount of refund, that is total fees minus 5,000, that is 20,000 will be given, 5,000 will be deducted as processing fees. Next, SEBI may not reply to the following types of requests. Okay, where a request is rejected for non-compliance, the fees, if any, paid will be refunded. The same thing that I put in the diagram format, that is 5,000 will be deducted as processing fees and the remaining 20,000 is going to be refunded. It is the same thing that has been provided in the theory form. Now, discretion of SEBI, like I told you, SEBI is under no obligation to respond. It is their absolutely discretion. If they think it is worthy enough of giving a reply, they will reply, or else they are not going to reply. So, SEBI is under no obligation to reply to any informal guidance. If they think worthy, they will reply. If they don't want to reply, they will not reply. If they don't reply, they don't even have to give a reason of why they are not replying to your informal guidance. Also, they are not liable. They are not liable to give you the reasons or disclose the reason as to why they are not replying to your informal guidance. Next, confidentiality request. This is the one that I was talking about earlier. If you don't want your informal guidance request to be put out in the public domain, in the letter lastly you can include a clause, we request you to maintain the confidentiality and give us a confidential treatment. Right? The requester can request for confidential treatment. This request should be included right at the beginning when you are making the letter. In the letter only, you should include that we want a confidential treatment. Now, depending upon the facts, depending upon the situation, what is the request? On that basis, SEBI is going to consider, should we grant the request or should we reject the request of confidentiality? If they grant the request of confidentiality, in that case, the letter will not be published on the SEBI website. They are not going to publish on the SEBI website. They are going to give you confidential treatment only for 90 days. After 90 days has expired after getting a response, after that they are going to upload it on the SEBI's website. For 90 days, we are going to give you confidential treatment. If SEBI thinks that this is not a situation where confidential treatment is going to be required, they'll tell you that no, we will not give you confidentiality. We will upload it on SEBI website. We are not going to give you confidential treatment. You tell us whether you want to continue with the request or you don't want to continue, because we are not giving confidential treatment. Now you tell, are you okay if confidentiality is not given? So then the question comes back in the hands of the requester that whether he wants to withdraw the letter, because we are not giving the confidential treatment. Do you want to take back your request, or you are allowing us, okay, it's okay, don't give us confidential treatment, give us the informal guidance. So that is the two options available with the requester. What is happening? SEBI is saying we are not giving you confidentiality. Now that has gone back to the Requester has to decide whether he is okay with not getting confidentiality or whether he really wants confidentiality. If he really wants confidentiality, SEBI is not ready to give him, so he has to withdraw his request letter. They are not going to give any kind of guidance. But if he is okay with not getting confidential treatment, but he really wants the informal guidance, he will say, I am not going to withdraw the request. It's okay, you give me the information and make it also available on the website, no problem. In case he withdraws the letter, SEBI is going to consider it as no response and he is going to refund the fees. So this is the entire setup for confidential treatment, but specifically you should ask for it if you want a confidential treatment. The same thing put into the theoretical format. If they grant it, it is going to be available for 90 days. If they reject it, the requester has to give a answer whether it is going to withdraw the application or it is going to go ahead without confidential treatment. Withdrawal of request or continuation with the scheme. Now, the guidance which is going to be given by SEBI under one of these informal guidance, it is subject to a condition that whatever reply we are giving, it is purely based on the facts that you have specified in the letter. If you by mistake have given wrong facts, if you by mistake has slightly monitored or altered the facts, the situation is different from what you have written in letter. We will not be held responsible for wrong reply. What you have specified in the letter, what facts you have stated, on that basis we are replying. So whatever reply is going to be given is going to be based on the facts specified in the letter. Where no action letter is issued by the department, it means that the department will not recommend any enforcement action to the Securities and Exchange Board of India. Post the letter is issued under the scheme along with the request application, it should be posted on the website of SEBI if no confidentiality request is there. If confidentiality request is there, after 90 days they are going to post it on the website. Next, what is the legal impact of the informal guidance? If the informal guidance is given, some interpretation is given, that interpretation is then subjected to some case in the courts. Will the guidance hold good? No, it is not a formal guidance. They have given you guidance in informal capacity. You cannot hold SEBI responsible for the guidance given under the informal guidance scheme. Okay, it is merely a view. It is not binding on SEBI. You cannot say that in the informal guidance only they had told us, that is why we did this. No, they are only giving you guidance. They are only directing you. They are only monitoring you. They are only helping you. They are not giving you a binding decision that if this is the interpretation, this is only the interpretation. No action means definitely no action will be taken. That guarantee they are not giving. They are only helping you understand and manage that situation betterly. So whatever is in the interpretative letter or no action letter, that is not binding on SEBI. You cannot question what has been given in the informal guidance. It is not a conclusive decision. They are giving it to in an informal capacity only to help you to a certain extent. So that is not a conclusive decision. That can be challenged. No, it cannot be. Not a determination of any question of law or fact. They are only helping you understanding and interpreting the provisions of law. They are not deciding a question of law or question of fact. That is the role of a court. Here they are dealing with you in informal capacity. So it is not conclusive, it is not binding, it is not a conclusion of question of fact or a question of law. Plus, it is not an order of SEBI, so it is not appealable also. It is merely an information that they are giving. They are helping you understand the law better, that's all. They are not giving you a decision that can be appealed. So this is very, very important. What is the impact? It is not binding in nature. It is not a conclusive decision. It is not an order, so it cannot be appealed against. Plus, they are not giving a conclusion on question of fact or question of law. They are only helping you understand the provisions better in relation to the facts of your case. Liability, again it is the same thing. What I mean to say is the legal implication, the same thing. It is not binding in nature. It is only a request which has to comply with on the basis of the facts. It is not a conclusive decision. It is only a guidance. They are guiding you through. They are helping you through. It is not a decision. It is not a final judgment. Not appealable, same thing. It is not a question of fact, question of law or a decision. It is only in informal capacity that they are giving you some kind of guidance. They are helping you in interpreting the provisions of law. They are helping you make an action plan. That is all. Apart from that, it is not an order, it is not a decision, so it cannot be appealed against. Public disclosure, Again, the SEBI may post the issued letter along with the incoming request on the website of the Securities Exchange Board of India. Both the request letter and the reply letter both are uploaded on the SEBI website. If confidential treatment is asked for, they will not upload it for 90 days. After the completion of 90 days, they are going to upload it. Now, SEBI's liability, again SEBI will not be liable in case any company suffers any kind of loss or damage by the requester or any other person based on the reply of the informal guidance scheme. If somebody suffers a loss, even then SEBI is not going to be held responsible. The request is not being answered, it is not responsible. Request being belatedly answered, they are not responsible. Board taking a different view from the action letter already issued under the scheme. Under the informal guidance scheme, they have given you this is the answer. But while the court is interpreting, they have interpreted it in an opposite way. You cannot hold SEBI responsible for this interpretive letter. Okay, if there is any contradiction between informal guidance and the view of the court, SEBI cannot be held responsible, because whatever is happening here under the SEBI informal guidance scheme is happening in the informal capacity. They are not doing anything professionally or officially or formally. They are only there to guide you, and their guidance can go wrong sometimes. You cannot hold them responsible for that as well. Next, status of the guidance obtained through fraud or misrepresentation. You have given a wrongful facts and obtained some kind of guidance, but your facts are totally different, but you are applying the guidance to your particular facts. Such kinds of fact, first SEBI can take legal action against you, because you are wasting the time of the department by asking information or informal for some kind of fraudulent activities, and declare such a letter to be non-S. That means the case of the requester will be dealt with as if such letter has never been issued at all. On the basis of wrong facts, wrong circumstances, you have obtained some kind of guidance. In that case, the authority has the right to take legal action against you for giving the wrongful information, plus the letter that has been issued in reply to that wrongful information will be considered as invalid. We will treat it as that never that letter has been issued at all. We will assume that that letter has never been sent. It is going to have a state of invalid level. So with that, we come to an end on the entire chapter on SEBI Act 1992, the scores mechanism, as well as the SEBI informal guidance scheme of 2003. Study well, because this chapter has a lot of weightage in the question paper. All the best. If you all have any doubts, you can leave it down in the comment section. We are going to reply and address to each one of your questions. All the best for all your preparations.